As soon as Lee finishes handing out papers to us, we'll get going. Good morning, everybody. This is the Texas Low-Level Radioactive Waste Disposal Compact Commission meeting. Today is Friday, the 30th of November, and it's about a little after 9:30. And working 9:30 seems to help because we normally start about 9:10, so at 9:30 we're actually on time. And starting this morning, so the meeting is called to order. The roll call of Mr. Salzman is here. Judge Dolgener is here. Vice Chairman Lee is here. Ms. Morris is here. Dick is here. And Mr. Bradford, welcome, sir. Eric Doyle said he would not be here. He couldn't make it today, so there are just 7 of us. And, of course, Mr. Krausen, our attorney, and Ms. Ng, our acting contract person who does everything for us, is here. And Audrey, thank you. So you have all of us. We're all present and accounted for except Mr. Doyle, and so we'll get underway with that. I would notice that is Bobby still here? Ah, there you are, Bobby, and Mike Lozano is okay. And Senator Seliger came by and Betsy Byrd to pay their respects this morning, but I don't know of any other, except for the judge, of course, any other elected officials. There may be some present that I'm not aware of, but are there any members of the press here? I'll always like to just tell us who you are. We're glad. Welcome. We're glad to have you here. You haven't been here, so I'll tell you this is a habit I have that I picked up 40 years ago of making sure that in these meetings like this we welcome the press because we appreciate what you do. And with that, the first regular item on the agenda is we always have a public comment item, and under our bylaws, it's we allow any member of the public to address us for a short period of time on anything that is within our jurisdiction, and the public can also register on any agenda item to give us comments on that particular agenda item, and they can really do both. And so the first thing is I'll call for public comment to see if anybody is out there who wants to talk to us generally about anything within our purview. We can't act on it, of course, because it would not be on the agenda, but we will be glad to entertain any comments or suggestions from anybody. And Ms. Haddon, I see you're getting information ready, so I assume you're ready to go.
Yes. Good morning.
Good morning, Kara.
Well, good morning, everyone. Hope you're doing well. And I am unfortunately sad to relay news. Maybe you got this through email. But one of the things on my mind at this moment is the passing of Glenn Lewis, who did work for TCEQ on radioactive waste issues. He was a former writer for the Austin American-Statesman. And he has spoken several times since his employment there. He is one of 3 employees who actually left TCEQ because of concerns about this WCS application. And one of the big warning signs and red flags that he raised was about water at the site. And he did this after talking to every member of the department. It wasn't something that he did alone. Every single member, and he sat down and he clarified their issues and clarified the data. And then he was the one who brought forward the August 14th, 2007 TCEQ interoffice memorandum that spelled out the many concerns about water, how close it was to the compact waste facility, that he felt that they felt that this violated the permit, the license, and that it was a matter of time before there were problems with groundwater. They thought there would be intrusion into the site. He was one of 3 employees who did resign in protest of the licensing, and he continued to speak out. He spoke here at the Capitol, and the date on that was February 8th, 2011, and at that time pointed out that when, in his opinion, when WCS came forward with their application, it was just a rewrite of their hazardous waste application. And this is taped, and basically, he said, basically where it used to say RCRA waste, RCRA, they had basically put in radioactive waste. And he said that he and others, their jaws simply dropped when they saw the application. This was the nature of it, that it wasn't the due diligence that they expected. It wasn't a more specific application. So I think that it's right to honor his integrity. He left his position even though he needed the health insurance and he was not able to have it after that. And that was a major sacrifice in his personal life. And I'm bringing to you one of the articles that was written that involves him from the Texas Observer. And later, I'd like to address some of the water issues as we come up to the permit itself, or into the agenda items themselves.
Okay, Ms. Haddon, and of course, we all respect the work that Mr. Lewis did when he was at the agency. He was at a different agency. He wasn't here, and of course, we don't regulate the licensing, but we all respect and honor his service to the state of Texas when he
Yes.
did do his work. And we'll be glad to take the articles from you.
Great. And I would add one additional comment, that there have been some steps taken since then in regard to water at the site. WCS tells us how many wells they've drilled, and that's good. They should, and it's good that TCEQ required those. But the data is showing that we still have water at the site. And when this was addressed, there was an amendment. It was done as a minor amendment, and that was to reconfigure the site due to the presence of water. That was probably a good thing, but there's never been an opportunity for the public to come in into a full public hearing, a SOA-type hearing, and to bring forward the experts that should have been brought to bear, that should have said, is it good enough? That is the question that still remains. And so I'll leave this article with you.
Thank you, Ms. Haddon. Robert?
Hi, my name is Robert Singleton, and I want to thank you for delaying the public comment while the public was running late. But I have one point I want clarification on. It was my impression from a previous meeting that the application for sending waste to WCS was going to be broken out so that there was a clarification how much of the waste was A, how much was B, and how much C. It was my impression you were going to revise the form, but I noticed on one of the applications you got today that it still says simply A, B, and C waste, and it doesn't say how much of each it is. Was I wrong in thinking that you said you were going to start delineating this or make some change to the application in order to get more accurate information about the volume that was A, the volume that was B, and the volume was C?
I don't have a specific recollection of that,
Okay.
Robert. I really don't. If somebody else does, they can certainly respond to you, but I don't have it.
But if I was mistaken about it, I would certainly like to encourage you to be as specific as possible on the form and to make sure that we know how much, particularly considering the article in the Statesman today about Class A waste being shipped out of state. We'd like to have some clarification of what volumes of A waste are being stored.
Stored on site or disposed of?
Being disposed of on site.
Disposed of on site. We'll talk about that a little bit later.
Okay.
I think Ms. Ng will talk to us about our discussions with TCEQ about getting reports from them on different classes of waste on a basis. So thank you.
All right. Thanks a lot.
Is there any other member of the public who cares to address us on any item on our agenda or anything within our purview, even in spite of the fact that it's not on the agenda? Okay. Seeing no more volunteers. Karen? Okay. The next item on the agenda, we are fortunate today to have a presentation by the Low Level Waste Forum Disused Sources Working Group. Leonard Slosky, who's with the Rocky Mountain Low Level Radioactive Waste Board, and I've known Leonard for a number of years now. Welcome to Texas and welcome to your group, and I'm glad you could arrange your meeting to be here in Austin in advance of this meeting so you could come tell us what we need to know and what you've been doing.
Thank you very much, Mr. Chairman, members of the Commission. I'm pleased to be here today. I'm the Executive Director of the Rocky Mountain Compact. As the Chairman noted, I'm representing the Disused Sources Working Group today. It's a working group of the Low-Level Waste Forum, which is the National Association of State and Compacts on Low-Level Waste. We were originally approached by the National Nuclear Security Administration, which is part of the U.S. Department of Energy, a couple of years ago, and asked that we form a working group to focus on disused sealed sources. This has been an issue of great concern in the nation, particularly since 9/11, and the concern about radiological dispersion devices, commonly known as dirty bombs. As there's been a big effort to better protect these sources, to encourage disposal of them, to try to keep them out of the hands of people who would do bad things with them. So the forum took up this charge and formed a working group. And we formed the working group in October of last year. So we've been meeting about a year now. And the NNSA, as I will call it, was primarily interested in facilitating disposal. And the compacts and states were interested in that, but said we would only undertake the effort if we could look at the sealed source problem in a comprehensive way. We didn't just want to look at how do we bury them. We wanted to look at how you can improve the management of sources throughout their life cycle. So we set up a working group. Several of the other members are here today. Mike Garner from the Northwest Compact is here. Catherine Haynes from the Southeast Compact. Rusty Lundberg from the state of Utah. The other members of the working group who are not here are Max Batavia from the Atlantic Compact, Brad Broussard from TCEQ, who may have come in, Elise Peterson from New York, and Stan York from the Midwest Compact. I would note that Todd Lovinger, the Executive Director of the Forum, and the lead staff person for the working group is also here today. So you can see we have a very broad representation, compacts that have facilities, compacts that don't have disposal facilities, a good geographic representation of the states and compacts. So we're in the middle of our process right now. I unfortunately don't have conclusions or findings to share with you, but I'll tell you what we've been doing and a couple observations as it relates particularly to Texas. So we are working to try to clarify the problem. The Department of Energy has a database of disused sources which shows several tens of thousands of disused sources in the nation. And so it's obviously a big problem. We're working to try to clarify and bring some greater specificity to the nature of the problem and what can be done to improve the management of sealed sources. We've met 7 times, including the last 2 days here in Austin, and appreciate everyone's hospitality here. And as I mentioned, TCEQ has been an active member of the working group since the beginning. We've met with a series of stakeholders, federal regulators, state regulators, users, manufacturers, waste processors, brokers. So we've been in the information gathering phase, and we're just getting ready to enter what I would call our deliberative phase of starting to formulate findings and recommendations. After we have some tentative findings and recommendations, I anticipate that we will re-talk to a lot of these people and test out what we're saying. And if everyone is mad at us, we're probably going in the right direction. My personal view is the system is broken. If the system was working as designed and intended, we wouldn't have tens of thousands of disused sources. We wouldn't have people storing sources for years or decades. There's obviously not been disposal access throughout all time, but for the majority of time that we've been using disused sources, there has been disposal access. And in our region, for example, we've had uninterrupted disposal access for all classes of waste, yet we have hundreds of disused sources in our region that are registered with the federal government. So it's clear to me at least that some improvements are needed on the regulatory front, but we're just getting to the point of talking about what those might be. So I'm hoping this is the beginning of a dialogue with you, and as we make progress, we can report back, and TCEQ, I would suggest, could be the sort of the everyday liaison. They can certainly provide you with current status reports, but myself and staff and the other members would be more than happy to speak with you anytime you have an interest. I would also mention that in our process, we diverged from the central focus of disused sources and formed a group that commented on the U.S. NRC's, Nuclear Regulatory Commission's, branch technical position on concentration averaging. This is a very technical matter. Some of you that have been in the waste business will know about the concentration averaging, BTP. It is incorporated by reference in most of the state licenses of the disposal facilities, and it controls, at least to some extent, what can be received and the concentrations that are acceptable. So we wanted to make sure that the states and compacts had a full voice in that rule. It's not a rulemaking, it's a guidance. So we did diverge and formulated some comments on the branch technical position. So we did that. I'm sure you're aware, the NRC is also revisiting the primary regulation, 10 CFR 61, that regulates low-level waste disposal. So the forum has also created a working group on the Part 61 revisions. Rusty Lundberg, who's here, is chairing that effort for the forum, and I would defer to him any specific questions you have about that. But it's a major undertaking. It has potentially large impacts on all the host states with facilities. This regulation was last revised, I believe, in 1982 or 1980. So we've been living with this for decades, and my personal opinion is I don't know why the federal government wants to revise the regulations, since there are not a lot of licenses pending before the federal government. All the sites are licensed by the states, and there are no licensing activities for new sites anticipated, but in their infinite wisdom, they decided to revisit the ground rules. The forum obviously wanted to make sure that the states and compacts perspectives were well represented in that effort, so we have a companion working group on that. As I said, we don't really have conclusions and findings refined at this point, but it's clear that Texas has a special role in this issue of disused sources for a couple of reasons. First is there are more disused sources in Texas, we believe, than any other state by far. According to the DOE database of registered disused sources, more than half of all the disused sources in the nation are here in Texas. And as you know, the state makes a huge use of sources, particularly in oil and gas development. So it's not surprising. The other special aspect for Texas is that you have a couple disposal facilities, the compact facility and the federal facility that may play a role in improving the disposal of disused sources nationwide. So you're at an interesting apex of the issue, and I think whatever we come up with and whatever path forward there is to improve the disposition and management of sealed sources, the state of Texas will benefit from. And my personal opinion, at least, is that the state will also play an important role in contributing to the disposal of disused sources. That's what I wanted to share with you. I really appreciate the time and hope that this is the beginning of a dialogue on this issue, and would be happy to try to answer any questions you have.
Thank you, Leonard. Before I launch in, I'm going to ask the other commissioners, does anybody have any questions? Linda?
We might have some questions for you if you'd care to comment when we have the discussion on when is a waste is a, that whole topic. So we might ask you your opinion, or
if you care to stick around.
If you do.
I actually plan to be here for most of the day and would be happy to share my thoughts on other things. I was the executive director of the Rocky Mountain Compact when it was first formed in 1983, so several of you I've commented to that I have been through what you're now going through. So I sympathize with you, and there are a lot of important issues that you have to grapple with.
It's nice to know that survival is possible.
I used to be about 6'6", but...
John, questions? Comments? Judge?
Leonard, I just thank you for y'all's work. I was at a forum meeting when y'all, I think it was in Georgia when we actually I thought I was in Florida, but I was actually in Georgia. Is that meeting?
I get confused where I am.
I flew into Florida and went to the meeting in Georgia or Mississippi or somewhere. But I was in that executive meeting, and when Susan was there, and I really appreciate TCQ stepping up and actually putting somebody else in that role that Susan had, because you're right, there's a lot of we need to get this straight. It's been out there a long time. A lot of sources are out there. We had a kind of a scare in the oil field the other day when an isotope fell off a truck. Probably wouldn't hurt anybody, but it's still nuclear, and it still, comes with all the things. And I think a pumper found it a couple months later without all the hoop to do helicopters and all that trying to find it. So I do understand that. My bigger problem is, as you know, I'm from that county that has a site, and as all the other commissioners know, we need to know what's from Texas and what's from Vermont, and then what's from everybody else. And once that's defined, I think I'll be all right with it. But since half the stuff's from its own state, then that may not be a problem. But I do think we need to, as I thought in Georgia, that this policing of and I like, the conversation back then was the universities and stuff before would go and get an isotope that they didn't know if they needed it or not. And now there's a little policing to that they're actually saying, well, no, what do you need it for, or why you need it, or, there's some policing of that. So at both ends, maybe we can get this deal. But I appreciate y'all's group. And
Thank you.
Quick question, Leonard, when do you anticipate, if you took a look at your process, that you'll actually come back with some findings for consideration?
We are supposed to be done next fall, so I think that might slip a little bit, but I would hope within a year or so, maybe less, that we will have be at an end point.
Okay. Thank you.
The only thing I'll do is observe two things. First of all, we have some special requirements that I'm sure that you're aware of in Texas, and Judge alluded to some about out of compact versus in compact origin. Secondly, that most of our out of compact agreements have to be with generators, our brokers acting on behalf of generators. I'm just wondering if those kinds of issues are being taken into account in your studies.
Yes, your requirements are not at all unique. As you know, in our compact, we issue an export permit
Yes.
for anything that leaves our compact for any purpose. So, many of the compacts are used to what I will call waste tracking and waste attribution. So we're very much aware of those issues, and I think your requirements are very reasonable and will be respected.
Thank you. Second thing I'll observe, and this is just in terms of a time intensity for occupying us for our time, it's amazing that such a small percentage of the actual radioactive waste takes up so much time, because there's so many of these little discrete sources as opposed to the origins in the generation stations of 95% of all the waste that we disposed of. But these kinds of issues are taking more and more of our time right now, and of course we're just learning.
Yeah, so I would just observe that the volume of sealed sources is quite small, as you know. They're very,
Yes.
for the most part, very small devices. Some of them do have a large amount of radioactivity, and some of them are definitely national security concerns. So they are a small volume, but in a very important issue.
Yeah. Thank you, Leonard. Does any of your other people from your group want to make any comment, Rusty?
Maybe they should just stand up so you know who they are. Justine, Catherine, Mike, Todd. Oh, Elise is here from New York.
That's great. And welcome all of you. We're glad to see you here, and we hope you come back often. And we have meetings regularly, and you're welcome to any of them anytime you come. Catherine comes to some of them. Todd, I think this is your first. Rusty and Elise, welcome.
We also have, she's not on the task force, but Kathy Davis, the executive director of the
I saw
Southwest
Kathy when
Compact.
she came in, so welcome, Kathy. All right.
Thank you for your time.
All right. All right.
Those meetings on the internet? Those meetings on the internet?
Oh, I'm sorry.
Rusty, is those meetings on the internet?
Which
the webcast? You told me.
We record them and then make the recordings available.
Oh. The forum had a deal on looking and I couldn't find where y'all.
The forum is different. I thought you were referencing maybe our
No,
state.
your board meeting forum had the board meeting on there.
All right. That does number 5, but next we get into discussion item 6, discussion and possible action with respect to resolving the question of when a waste becomes a waste for purposes of applicability for commission rules. And Ms. Moore?
I'll defer to John on this one. He's so good at it. He does the cup thing.
They have a limited number of cups.
A bigger cup. Nicely.
There we go.
We met with representatives of the TCEQ to talk about when waste becomes a waste, and that was Linda and Lee and Audrey and myself met with Tanya Baer, Charles McGuire, and Brad Broussard to talk about this subject a couple of weeks ago here in Austin. We had previously met with NSSI just as a sort of an information gathering point. We've looked at a lot of information which has been provided by other compacts and received phone calls from generators and waste brokers and processors, and so we've had a pretty fair amount of input. I think the point that you raised a minute ago is important, and that is the legislation that exists for this compact, particularly from the state of Texas, indicates that any waste that comes from the other 48 states, i.e. not Texas or Vermont, there's a requirement that there be a 20% surcharge, I believe is, I'm sort of paraphrasing, 20% surcharge on that waste. So clearly, the legislature in the state of Texas has decided that's an important issue. So I think as we, with whatever our ultimate findings are, I think we have to take that into account. And the other thing is, they were very clear that we cannot take waste of international origin. And so whatever we put forth needs to make sure that we can comply with that as well. In our meeting with TCEQ, we spent a fair amount of time talking about scenarios and what would happen with a source manufacturer or somebody who's a waste generator or a waste broker, or processor, that kind of thing. We also spent some time talking about a document that TCEQ has published. I guess it's really a form. It's called Instructions for Completing Texas Compact Waste Shipment Verification Form, and it's TCEQ Form 20225. And that document lays out, if you will, how sort of when waste would become waste, if you will, and I think what it I'll paraphrase again, what it would assert, if you will, is that whoever's the last beneficial user of a radioactive material is really the generator, and that's really, I believe, the intent of this document. So if we start there, I think we have to look at, so what does that mean in a practical sense to generators in Texas or Vermont or anywhere else? I think if we start there, it helps the commission, and I think this commission and TCEQ and the state of Texas with defining and perhaps putting into place a system where we can ensure that we collect the right fees, and hopefully where we can ensure that we don't take waste of international origin. Let me stop there for a minute and see if there are questions by my fellow commissioners just on sort of that basic framework.
Well, I guess we can get into kind of the exceptions to the manufacturer receiving sources back again. So there are some caveats, I would have to say, to this general concept.
What we talked about, and I think this probably goes into there's a provision in Texas law, and I have to admit I could only paraphrase it, but it basically indicates that if you're a source manufacturer, that you can take back your sources, and that if you take back your sources, those sources would be your waste. So if I understand correctly, if you are manufacturer A of a radioactive device or a radioactive source, and you sell that to some company, they use it for some period of time, and then they choose to return the source to manufacturer A. Manufacturer A can then dispose of that source as their radioactive material. And I think I've paraphrased accurately what we believe the intent of Texas legislation is. So if we apply that to source manufacturers, they can take back the sources that they manufacture. I think the finer point of that might also be that means that if they take back a source that they did not manufacture, that is not their waste. That becomes the generator of that material would be the company or the individual that sends the source back to that source manufacturer. Did I adequately explain?
Essentially.
Yeah, in essence, if it doesn't mean that a source manufacturer can't take back sources from other other entities. It just means if they do that, they're acting as a waste broker at that point, at least in our sort of understanding of this.
I'm going to read the definition of generator
I should have done
from the compact so everybody can know the kind of things we're struggling with. What the compact itself, which is our act, and the thing that we operate under, contains a definition of generator, which means a person who produces or processes low-level radioactive waste. So the first thing it has to be a waste. They produce it or process it. In the course of its activities, excluding persons who arrange for the collection, transportation, management, treatment, storage, or disposal of waste generated outside the party states unless approved by the Commission. That's what our definition says. So what we're trying to do is figure out how our definition fits in with the definitions in the federal government of who a generator and what low-level waste is, and the organic statute in Texas governing low-level radioactive waste and low-level radioactive waste disposal, which has different concepts. That's where we are.
That's where we are, and I think the other point that we need to understand is, well, really two. We want to whatever we decide, if you will, we want to make sure we have an even playing field for everyone. Whether you're a source manufacturer, a broker, a processor, a generator, we need to have a set of rules that treats everyone equally. Now, it may treat everyone. Nobody may be happy with it. I heard that phrase earlier, and you know that it is what it is. But we treat everybody equally, if you will. The other thing that I think we have to make sure is the rules that we put in place don't allow a company acting in whatever fashion to take materials and declare them their own to get some kind of a benefit of out-of-state waste, or out-of-compact waste versus in-compact waste. To me, that's critical, again, because of the legislation that exists, which says we must collect this 20% surcharge for out-of-compact waste. And if you will, I'm going to read a little bit from the TCEQ form. It says that original generator means the last person who puts radioactive material to practical use. And then parenthetically it says practical use means concerned with the production or operation of something useful. So that's, I think that's reasonably well defined. It also, and there's other parts of it, but it goes on to say a processor broker may not list itself as the original generator of its client's radioactive material or waste, nor sign on behalf of the generator. So, in essence, for the TCEQ form, and I apologize to my friends with TCEQ, I'm not trying to explain your form. I'll be more than happy to let you all explain it. But I think the intent of this then is whoever puts the material to last practical use, in essence, has to sign the form that TCEQ has developed. And then if that generator chooses to use a broker or a processor, or they send the waste directly to the waste site themselves, those are all options. But that's sort of the playing field, if you will. If you are a source manufacturer, then you can take back the sources that you manufactured and they become your waste. Whether you reuse those sources, possibly, or you decide there's no useful purpose for that source and it needs to be disposed of as waste, they become your waste. Most people would think of that in terms of a sealed source, but there are other companies that manufacture radioactive devices. For example, there's what they call a technetium-99M generators. These are devices that are used at a lot of hospitals and veterinary schools and things like that for producing very short half-life radioactive materials that are used in nuclear medicine studies. Well, these devices, a company manufactures them, and they send them to, or they sell them, if you will, to a hospital, or at least, I guess you could say maybe it's a short-term lease, to a hospital, vet school, things like that. That entity uses that device for some period of time, maybe a couple weeks to a month or two, and then the device is no longer capable of producing enough of that short half-life radioactive material. So that device gets returned to the manufacturer. The manufacturer will take it apart, reuse parts of it. Some of the radioactive material they may be able to reuse. Other parts of it become waste, and that waste has to be disposed of. So that manufacturer would be able to send that material as their waste to the compact waste facility. If they were in Texas or in Vermont, it would go as in compact waste, and if they were one of the other 48 states, then it would be out of compact waste, obviously, if they had an approved import permit with the commission. So let me stop again and
I'm just going to add, based upon what John is saying, and so everybody knows, there's another layer here, and that is that anything we say is a waste has to meet the waste acceptance criteria and has to be approved by TCEQ. So we want to have, what we're driving for is a seamless system to where everybody understands who the generator is, when it's a waste originating in the compact, and when it's not a waste originating in the compact. And finally, everybody has to understand is we cannot take, and the site cannot take, waste generated outside the continental United States. With possibly, we really got approached by this on the Department of Defense one time, because they say we might have waste from Spain in one of our Air Force bases, but the U.S. government owns that. Is that out-of-continent waste or not? So we have all of these layers of questions and problems. We're trying to struggle through this to make sense of it so everybody can have a total understanding where we come out with, because we realize how important the site in Andrews County is going to be for many of these disused sources. But I've probably said enough now. Anybody else?
I don't know if it's on or off. We realize that all of this can have implications for a number of the companies now, but just to emphasize that even if a company is accepting sources from out of compact, they can do so, but again, they would have to probably separate what's in compact and what's out of compact. And with the fees, the higher fees, of course, associated with the out of compact. But I guess that would be an example, again, of a broker. And the broker would be the broker for the sources that originated out of state that had not been manufactured by that company. Does that make sense?
That's correct. And I'm honestly not certain. TCQ would probably have to address that specific question, which is if a broker receives sources or radioactive material, I don't think it matters in this case, from both in compact generators and out of compact generators, I don't know if that material has to be in separate containers.
Yeah,
or
I don't know.
To me, that's part of the waste acceptance criteria and those kinds of things that really are not before this commission. It's probably a nuance that's important, but not to this commission. But again, I think the summary of what I'm proposing is that the TCEQ form, I think, does an adequate job of defining when is a waste, and I think it also allows this commission in the state of Texas to put into place provisions to ensure that we don't take international waste, and also to help ensure that we can collect the 20% surcharge that's required. 25. Or 25, the surcharge, however much it is.
Yeah. The judge wants to make sure he's there. What are you recommending to us, John, at this time, or are you recommending anything to us?
I guess my recommendation would be that we, I don't know if the term is accept or adopt or use the definitions and the information that's provided in the TCEQ form. I think it does a fair, adequate job of defining the subject for us.
Well, you posed a matter that I'm going to refer to our counsel, Mr. Krausen, because we need to know when we're engaged in rulemaking as opposed to something else.
The most conservative thing that we could do. The most conservative thing we could do is have certainly have a rulemaking where this gets laid out and discussed. And so that would clearly be my recommendation. But I would not be red-faced defending an action that you took today if you feel so compelled.
Well, we can act on an ad hoc basis, but for clarification purposes, we might want to proceed to have a more formalized statement, and even a formalized policy statement would amount to a rulemaking. And I understand that, but we can certainly make decisions based upon
absolutely
the waste acceptance criteria of TCEQ, because those are in place under the license, and we could certainly do it that way. And one of the questions that I had, John, is one of the importances that we're emphasizing is the difference in disposal rates associated with out-of-compact versus in-compact disposal. And aside from your packaging question of whether or not it would be required to be separately packaged, my question is, could we accommodate that just by an accounting transaction, showing that of a particular container, X number of devices are out of compact and in compact, so you have fewer containers going to the site. But
yes, I wasn't suggesting really a physical separation, but just really a paperwork separation.
I think accounting is a good way to phrase that.
Yeah.
There needs to be an accounting for the out-of-compact versus in-compact waste.
Okay.
Dick? John mentioned something when he gave us that kind of tutorial on the last time, where my recollection is that you said that in these devices sometimes, or they will have, they'll use radioactive material. That material might have come from Russia or China or somewhere. And one thing you can bet is that Russia or China or somewhere isn't going to take it back.
That's been the information that we have found out to date.
That's what?
That is correct. To the best of our knowledge, those foreign countries who are manufacturing radioactive materials and selling them in this country don't want them back.
So if that kind of material is in one of the, how should we just get past that question? I mean, if that kind of material is involved in something that's sent over here, or that's in a compact state, say, I mean, can we just hit that up front and say, as long as they're not trying to game the system, there's nothing we can't really slice it and dice it that fine?
I guess I would say that I don't think the origin or the production of the radioactive material is pertinent to our decision on waste. In other words, I don't think it's critical to know whether the radioactive material was produced in Texas or Louisiana or at one of the DOE sites in around the United States, or if it was produced in Russia. Once that radioactive material is produced and it is placed into a device or something like that and sold to a United States company, a United States-based company, then I think it becomes the United States issue to deal with.
Okay. Yeah, that seems reasonable. It was kind of a loose end.
If we didn't want it, we shouldn't have bought it.
Well, Dick, you're sort of asking the same question I did, and my concept of this is there are really three stages. There is the radioactive material that's enclosed within a radioactive source, it's called, which is a thing that's then inserted in a instrument or a device of some kind to where the device is used. And there are my experience is that sometimes people take devices back, instruments that they manufacture or other people manufacture, and it happens to contain this radioactive source. Sometimes they can handle that by just taking the source out. The radioactive material is inside the source. It's encapsulated. Some people, however, actually break into those sources on rare occasions.
I can add a little nuance to this, and it's something that we actually was talked about yesterday in the Lola Voice Forum meeting, and that is there is no americium-241 being produced in the United States currently. The inventory was used up a few years ago. So any new americium comes from Russia. Now there's talk about the United States government starting up the americium production again, but currently that capability does not exist. So if you need americium, you either have to get an old source from someone else and take it and cut it open and get the americium out, or you have to get your americium from Russia. So any device that has americium in it, there's a pretty fair chance that material was manufactured in Russia and will be at least for the next several years till the federal government makes a decision on this issue.
So the convention, I think, in the industry, and I'm probably saying this wrong because I don't have that much experience with it, is that the source itself is the waste, not the radioactive material inside the source. Is that correct?
I think that's a fair way to describe it.
Yeah. Linda?
The TCEQ may have to make some of these decisions because they'll see the applications in some cases when we won't. If it's an in-compact company wanting to dispose of what the company feels is all in-compact waste, it wouldn't come before this commission. Is that correct?
That's correct, and I think that's one of the things that is hopefully will help be a seamless effort, if you will, is that if all generators, brokers, processors are required to follow this form, if you will, it puts everybody on an even playing field. It I think, clearly defines who the generator is versus who the broker or processor is, and I think it will allow TCEQ to help ensure that where it's appropriate for out-of-compact waste that may be being handled in this compact to help delineate what needs the 20 or 25% surcharge and what is a Texas or Vermont waste.
Mr. Lee?
John, to you and Linda, during your evaluation and due diligence process, at the federal level, state level, any place else, including the facility that you saw in Houston, I believe it was, right? Did y'all encounter anything that, based on the recommendation that you talked about earlier, that would put us in direct conflict or inconsistent manner with whatever we may adopt from the TCEQ or any place else in order for us to, on your surcharge and no international waste, put this commission in a position of saying we need to dig deeper, we need to look at this more closely, or are you sensing that this is going to put us in reasonably good consistency and ability to be able to make those determinations?
I think the position that this commission, if we take that position, would probably put us in concert very well with, I'll start out first with the other compacts. I think generally speaking, the other compacts handle this issue in essentially the same fashion. I think in general it will put us in concert with the federal government. There's the question that the chairman raised about DOD waste that might be generated in a base overseas. Obviously that material is owned by the United States government, and I think a reasonable interpretation, and I think the way the federal government would see that is that waste does belong to the United States, and so to put it in a United States facility would be acceptable. There perhaps is a small nuance. The NRC has some guidance that, I'm not a lawyer, but you could perhaps read to say that if a source manufacturer sold a source to a foreign government, that source manufacturer could take that source back and it would be their waste. I think that might be the only issue that we could perhaps diverge a little bit, but my understanding is we actually asked TCEQ this question, and Ms. Baer was kind enough to do some research, and it was her report back to the commission that, in fact, the NRC has said their guidance doesn't apply in that case to our facility. So with that possible nuance, I think we're going to be pretty well in concert with both other compacts, I think with other states and the way they interpret things, and with the federal government.
John, is it a fair summary of what you're proposing is that this commission be guided by TCEQ's form with regard to these issues?
That's correct.
That certainly doesn't require a rulemaking.
No, that would not require rulemaking, and
because they're the ultimate decider anyway of whether it meets their acceptance criteria. So there's certainly nothing wrong with us saying that.
I want to add that the Commission recognized the fact that there's going to be some unusual cases, and probably it'll be up to the TCEQ to evaluate those on a case-by-case basis. So I'm sure that some manufacturers are going to have a good firm grounding, firm stance on there's a unique situation, so we'll have to deal with that.
And I think the other area where there can be some perhaps unique situations is what some people refer to the term orphan sources. A small company goes out of business, and when the doors get shut, maybe the new buyer of the warehouse finds a box in the corner, and in that box is a lead pig, and in that lead pig there turns out to be a radioactive sealed source, and sadly enough that's not an unusual circumstance, more common than you would think. So, in general you could term that an orphan source, and the question is, so who's the generator of that source? I think those are circumstances which are going to happen, but I think in those cases the entities can come before the commission and explain the situation. They can talk with TCEQ and explain the situation. I think we can come to a reasonable understanding. We need to get the regulatory agency of, if that happened in Illinois or Indiana or Louisiana or whatever, we can get that regulatory agency of that state involved as necessary to help understand the situation. But in my opinion, this commission is willing to understand that there could be some circumstances that don't quite fit the example, and that we're willing to consider those.
Does Mr. Slotsky have any comments?
Yeah, can I speak from here?
it'd be better if you came up there.
Before you talk, Leonard, I just want to make a comment. It's my view, and I'll be deal, but I think this is kind of really down to the nitty-gritty. But when somebody said no international sources, that meant from foreign governments. But we've got that down now to each sealed source, and that's my comment. But I really think when it said no, it really meant for foreign governments.
Or from a generator.
Yeah, just
or Francis nuclear power plant.
whoever.
Right. I think what you're discussing is generally very consistent with the other compacts' approach to this issue. The compacts have been very diligent over the years, so that when a waste broker or processor takes in waste, that waste is attributed back to the original generator. So whether it's a sealed source or dry active waste, it doesn't get transformed by a waste processor, let's say in Texas. They take waste from Nebraska and it comes into Texas for treatment. It doesn't get transformed into Texas waste. So I think that, it's very consistent in that regard. The one item that may be inconsistent with some of the compacts is when a source manufacturer takes back sources that have been used, last used in another state. At least some of the compacts would say that that is the waste of the compact or state at which it was last beneficially used. My personal view is that I think we need to be open to some special approaches on sealed sources because really sealed sources have been treated somewhat specially for a very long time. For example, when we first adopted our export rules in the 80s, we permitted by rule the return of sealed sources to the manufacturer from our compact. So the concept has always been, at least for the decades that I've been involved, that you want to get sealed sources back to the manufacturer if you can. So I think attributing the waste, attributing the sources that a manufacturer receives back to that manufacturer is a little bit different, but it may well be an appropriate policy. The one issue I'll just mention to you that is out there is that the federal government has new guidance on importing sealed sources from foreign governments. And their import policy, so to speak, does allow sources to come back to the U.S., and some of those sources may not have originated in the U.S. and or may not have been last used in the U.S. And so you have that nuance as well of the foreign waste where the federal government allows it in, actually without even a permit, and whether you're going to then say, that waste or that source is Texas waste or foreign waste. And a lot of times there's an exchange of devices. A manufacturer will provide a customer with a new source or device and in turn receive back a used source or device, and that can be from a foreign country, and that device they're receiving back and the source may or may not have originally been manufactured in the U.S. But I think that we don't have any source manufacturers in our compact, so we've not confronted that particular issue, but I think that if we did, and we may in the future, conceivably, we might arrive at the same place that you have, that for national security and public health and safety, given the small volume of sealed sources, that if it's manufactured in our region, when it's returned, regardless of where it was used, we might well call that our waste.
Thank you.
I guess the only thing I would, and thank you very much, I appreciate that very much. The concern I have on the international waste is that other entities don't have the same prescriptive legislation, perhaps, that the state of Texas does from our legislature, which was, I think, fairly clear. So, it may be that our rules have to be a little bit different than some of the other compacts or even the federal government, just because of the law that exists in Texas. So
that's one of the interesting things about compacts is we can actually prohibit foreign waste from coming into the compacts. Could be that the United States can't.
And as you know, other compacts have taken that position too.
Yes. And so that's one of the interesting things about a compact. So thank you, Leonard. Are there any other comments from commissioners or questions? We've spent considerable time on this. Let me tell you, my sense right now is that we would, unless there's objection, we'd follow John's recommendation to use the TCEQ on an interim basis, but I'd like to bring this back at our next meeting to consider whether we need a rulemaking, and if so, start talking about the maybe we can even develop some ideas about the parameters that would go into rulemaking. If that's, unless there's objection. Hearing no objection, Judge, is that okay with you?
I was really trying to see what the motion was.
No, I did not make a motion.
It was not a motion. It was, he is making a recommendation to act using the TCEQ form on an interim basis. That's what I understood him to say.
I'll have to ask the lawyer, that needs to be in the motion since it's something to do. It's a possible action.
I'm drafting a motion, that's what.
Okay.
What's that one now?
That is TCEQ Form 20225.
Ms. Haddon?
Thank you. This is a really interesting discussion. And I think, clearly you do have kind of a slippery slope here. And Mr. Salzman referred to the state law, which defines waste of international origin, and it says it means low-level radioactive waste that originates outside of the United States or a territory of the United States, including waste subsequently stored or processed in the United States. So I think that some of what you're doing right now is kind of expanding that that piece of legislation, and maybe I question whether that's appropriate. When you're talking even about the americium coming in, that to me would be waste of foreign origin. It came from Russia. And I'm also concerned about the expansion into the territory of shipping waste overseas for processing and coming back. If we're saying then you can allow, if this Compact Commission decides that you can take it back and then call it yours and it's gone overseas, then there's a whole nother problem of the risk of mixing with other international waste. I question whether the DOD waste is that's been on bases around the world is actually permitted to go to this site. I support your concept of having an actual rulemaking because I think you're on a very slippery slope, and personally I would hope that you would not approve any applications that could have this as an issue until it gets fully resolved.
Thank you, Ms. Haddon. I'll observe that there is a difference between radioactive material and radioactive waste statutorily. You can have a radioactive material, and that material does not necessarily mean that it's a radioactive waste. So even the definition you read, which we're familiar with, it has to be a waste first. And what we're really talking about is when it becomes a waste, and that's the reason that, in my mind, it's so important.
And if I may ask one other question, too. Yes, I agree. I'm also questioning what the definition is of beneficial or practical use. Do we have one?
I would get that from Webster's.
I mean, is there?
We're not going to try to define every word in the English language.
But has it been defined in these relevant pieces of legislation?
I think it's more defined by custom and practice than in language in a definition. That would be my reaction.
Okay.
And that would not surprise me because practices dictate a lot of what we're trying to deal with here. Okay?
Yep. Thank you.
Robert?
I want to make the same general point. In fact, I'm going over some ground I think I've covered with you before, but I've got a different analogy for it this time. You're trying to interpret what the legislature meant by waste of international origin. I don't remember how many of you remember the Twilight Zone episode about the little boy who could wish people away to the cornfield. He had all powers, and the town people had to run around figuring out what it was that the little boy wanted because they didn't want to get wished away to the cornfield. Well, what they were dealing with was a powerful, cryptic, and sometimes vengeful entity, and I'm not going to say that that accurately describes the Texas legislature, but I just wanted to ask you a question. In terms of determining what the legislature meant by waste of international origin, and I could argue with you that waste, it doesn't matter when it becomes waste. If it's of international origin and it becomes waste, it's waste that originated outside the United States. It's just a definition of, it's just an interpretation of what the word of means. But I would say that waste of international origin is waste that originates outside the United States as nuclear material and then becomes waste. Its origin was still international. The material's origin was still international. So I think that what I want to ask is whether the Commission has done due diligence on this. Have you looked at the legislative history to try to determine if there are some clues to what the legislature meant by waste of international origin? And I think until you know that, action on this item is premature, because you're trying to interpret something that may in fact have a simple answer in looking at the record from when the legislature discussed this issue.
Okay. First, I will say that a radioactive material originating overseas may not be a radioactive waste originating overseas. And that's clear to me from looking at these definitions. So just because it's a material originating in a foreign country doesn't mean that we can't take it here, because when it becomes waste is the question, not when it becomes radioactive. That's my first reaction as a lawyer. And then the next thing that I'm going to say is I don't think we would get a lot of clarification from looking at the legislative history of that particular phrase because of the context in which it was made. And I'm very familiar with the context because of the 10th Circuit case involving the Utah facility and the whole question about whether that facility could regulate the waste that went into the Clive, Utah facility of international origin. And so, familiar with that. So I think that was the context, and I think it's a practice, and that's where we are, and we're trying to do our best we can to make it work within the letter, within the wording that we see in the statute. That's all we're trying to do.
I understand, and I don't want to see any of you wish joy to the cornfield. So.
All right. Jim, you were suggesting a motion?
Mr. Chairman, I'd like to make a motion.
Yeah.
I move that with respect to determining when a waste is a waste for the purposes of determining the applicability of the Compact Commission's rules, the Commission be guided by TCEQ Form 20225.
Is there a second?
Second.
Okay. So motion is second that we be guided, and I assume that's currently by the TCEQ form that you specified. Is there any discussion on that motion? Any questions? Hearing no questions, no discussion. All those in favor of the motion say aye. Aye. Any opposed? Any abstentions? Motion carries, and that's what we'll do. And thank you very much for your work. Yeah, and what we're going to do, and we will have a discussion item in our January meeting about the rulemaking. And Leonard, maybe by that time you'll make further progress in your working group, and you can communicate with us and help us come up with something that's rational within both your context and ours on what we have to deal with. And I have some ideas, but I won't state them publicly what those could be because they're too simple to work. All right.
Keep them away from lawyers.
Keep them away from lawyers, that's right, particularly this one. All right. That's we have discussed item number 6. Item number 7 I'm going to go ahead and take up before we have a break. Item 7 is considerable and possible action on the following application on agreements for importation, and we have 2 of them. I'll take up RAM Services first. Do we have a representative from RAM Services here? Nobody's here from RAM. Lee, can you report to us about the status of this?
He's going to run out to the book real quick. Which tab is it on?
there are no documents associated with this matter in the book. So I have spoken with Jerry Wiesa of RAM and made him aware of where the commission may choose to go as they adopt a concept of where a generator ends and a broker begins, and that the application that we deferred would potentially be impacted by that discussion. And so he's aware of the situation, but he said he had other plans that he needed to take care of today, and had indicated to me he would not be able to attend.
Well, our choices are to defer again or to act on the basis of what we know. And this application was actually in our book for the last meeting, I think, and I still have it if you care to look at it, but I brought it with me just out of curiosity. But our choices are to defer it, grant it, or to deny it on the basis. John, did you look at this one?
I haven't looked at it for it's probably been 2 weeks, but my understanding is at this point the Commission hasn't received any additional information or from RAM Services on the application, and clearly the issue that we had at the last meeting was RAM Services, as I recall, applied as a generator for a number of sealed sources, and this commission, our perspective was that they were acting more in a broker capacity. And
where is RAM physically located?
Is it Idaho?
Wisconsin.
Wisconsin. Sorry.
All right.
Sorry. Wisconsin. So my perspective on this is the application that we received, particularly in light of the discussions that we had today of when a waste becomes a waste, they would have to resubmit an application that they are in accordance with the TCEQ form. They are not the generator. They were acting as a broker, and so my opinion would be that we would deny this application. That's my technical opinion as the application was submitted.
All right. Is there a motion?
I move that we deny the RAM Services application. And our number for that is 1-0014-00.
That would be without prejudice to the resubmission.
That's correct. Yes. Is there a second?
I'll second.
Is there any discussion among the commission members about RAM Services? Judge? Hearing none, I'll call for a vote. All in favor of the motion say aye. Aye. Any opposed? Motion carries. They'll be notified that it's denied without prejudice to resubmission of it. All right. Next is the agenda item number 7B, Qualtech application, and this one also is is anybody from Qualtech here? You want to come forward to address us?
How are y'all doing today? Am I pushing? Is it on?
It's on.
Okay. First of all, I want to make sure you guys understand we appreciate the process you guys are going through.
Did you state your name, please?
Oh, sorry. Travis Snoder, Qualtech Associates from Idaho.
Sorry.
Much warmer here than it is up there, so I don't not enjoy the trip. You guys are going through a process that's a very complicated one, understanding when waste is waste. We understand that. I do want to let you know that we really appreciate the work you're going through, and you guys have actually come to, and listening to what you talked about, what the NRC actually recently reported in one of their findings was very similar to answer the question that was proposed of when is practical or useful or intended use of a source. It's basically anything other than for the purposes of final disposal is what the NRC actually in one of their report findings came out. So it's in line with what you guys are talking about. In light to our application, we submitted, and I apologize, we've been going through a lot of work trying to make sure that it was put together in a useful and easy to view format, and it's taken us some time to do that. we were not able to submit it in enough time for review. I think we got it in just a couple days ago, is that right? Before everyone got a chance to see it?
5:10 on Wednesday.
Okay, yeah, so it was literally a race to make it happen, but I'll cover the basic topics of how we responded to that. If I can pull this up here, I'll actually use my brain.
While you're pulling it up, I'll tell you that none of us have had an opportunity to review this information that you submitted on 5/10 on Wednesday.
I'm aware of that. I just want to make sure that that we were in line with what we did and how we responded to these. So in review of the questions that were asked, one of the things that was first discussed was the paperwork. Where we had previously had this stuff, there wasn't the authority to ask for everything, at least not in the simple form that many other brokers had been using. We had transfers of custodies for the material and so forth. But organizing the information as far as individual sources, each one of those, what we've done is we've actually gone back and created a worksheet that was submitted, but I understand, and I haven't had a chance to review it, I guess some of those scans didn't come through perfectly legible. We're going to be meeting with Audrey, I guess, next week to make sure that some of those are more visible, which ones didn't come through clearly. But this worksheet does allow a clear and easy, simple process for them to identify the generator, the source, and with a click of a button, bring up the actual document that was associated with that. So as they go through the many sources, they can simply, in that worksheet, transfer that to each individual document very easily. So that should ease the process of that review. The second one that came up was the phos therapy sources. The discussion, as you were having now, of who is the generator of that material. Where we still believe that phos therapy may have been, in many of these cases, a generator, what we did is we basically just avoided that altogether, went away from that altogether and used the generator previous to phos therapy so that we could show where this material came from in the use that the source was originally licensed for, not necessarily for a service provider or so forth. So we've gone back, we pulled out any sources that were from a generator that previous to phos, and those sources are specifically listed in that worksheet as rejected sources as coming from a licensee previous to phos outside the country. I think there were 17 of those total sources, so they are shown explicitly as excluded from this application. In addition, all the other phos therapy sources, we have individually identified the broker or the generator prior to phos therapy on the individual compacts in which they're from. So on that worksheet as well, you'll see phos therapy still shown as a reference, but the original generator in red associated with them as well, so you can see what state and what compact they came from. Okay, and the licensee prior to.
You're not trying to be you're changing over to be the broker now?
We never were. We were always a broker. Yeah, we have never. Again, while we do have some sources that we do bring in for practical use, we loan rent gauges and so forth and sell them and so forth. Those are not included in this.
We were just trying to show title. Is that what you're trying to do?
Yeah, we're just trying to show, the transfer of that material. Yep. The last ones, the couple other things that we had was the discussion of energy solutions, them being a broker and us showing them as a generator. And these were in light of a situation that you actually mentioned, which was essentially they were orphan sources that a state had collected, and there really wasn't a generator, so we elected to take them from the last licensee that we had, or who we took transfer from, and that was Energy Solutions. We've since traced those back and found that it was, and this is included in there, it was from a licensee in Tennessee that went out of business. State of Tennessee took possession of the sources, hired Energy Solutions to do the roundup of the collection. They, of course, are not licensed to dispose of sealed sources, so they contract with us to get rid of those sources. So we had shown Energy Solutions as a generator. State of Tennessee is not necessarily comfortable with showing themselves as the generator of that material, even though there's no export fees or anything else like that associated with it, but still a discussion to be had. They're not even, at this point, we're not even sure who the hospital was. We're trying to trace this back to who the state was in charge of that hospital and who actually owned the sources. It's quite far beyond where we actually took them from. So again, speaking these special circumstances, by that they are orphan sources. So at this point in time, we're kind of leaving that for you to determine if you want us to show Energy Solutions as the generator or State of Tennessee. And if it is State of Tennessee, we'll have to work with them to make them aware of that.
Is it all right with you if we put this off until we get more information from you?
Sure, that's fine. I'm only informing you of the situation,
Okay.
so as you go through this, you can take action on the, I guess, January meeting, so.
I make a motion, we take this up to the January meeting.
Defer it until our next meeting,
And it may be later than that if they.
whenever the,
Yeah.
I would second that motion.
okay.
Okay.
We have a motion and
Don't do a good job.
second to defer. We appreciate the fact that we're imposing these requirements, and
Sure.
and you have to get used to us, and we have to get used to you, and we have to learn what the industry does, but and we're trying to accommodate each other. But
Sure. My intention today was not to pursue action, only to inform you. I'm not sure we'll be able to attend the January meeting is my concern. We have a lot of other things that we're hoping to get this done before then. We're going to do everything we can to make sure we're here. But I wanted to make sure that in the next 30 days we've answered any questions. So if you guys look at this as you review it, we can answer those.
I'm sure we'll be glad to keep reviewing it. It may be that one of the solutions is we have to bifurcate or separate the application into some things that we know we can handle and other things that still need additional work. And it seems to me that might be possible, depending upon how the information shorts out. So, but there's been a motion and second to defer until our next meeting.
Okay.
Some action on the application. Is there any further discussion? All in favor of the motion say aye.
Aye.
Any opposed? No opposed, so we'll take it up again. We'll just defer, but continue to leave the application pending. Okay?
Thank you.
All right. That takes us through item 7 of the agenda, and we're going to take a break. We've been going an hour and a half, and we're going to break for about 15 minutes and then come back and see how far we go. And because next of them we have agreements for import and then export. Everything going on.
I wonder if anybody has these applications handy. Oh, good morning. Jeff Parker. Yeah, the legal attorney.
And it was funny that I asked
Right, and that's what, even my, it was a parent, he didn't really want to talk to me, because I went through several steps, and, well, yeah, you don't know. Well, you weren't in existence. I've been in existence for 17 years, buddy, and I realized, I don't want to talk to you.
the thing that I think
Right, because he says, I don't follow California rules. I said, no, you're, I already turned him over to the Arizona officials. Yeah, he'll be getting a call.
and so and I understand what you're saying. He used to transfer this out. They know
I think the downfall of the and I understand, so if you're the manufacturer, and he returns it back to the manufacturer, then you can be the generator. However, the form you had inside, I have your transfer of with disposal. Disposal, has the word disposal on it, so that was establishing. You were declaring it as waste.
And that's something we're discussing.
And I sent those to him. I said, you signed a form saying it was waste. Oh, no, I didn't. No, I didn't.
And see, for them, in their industry, and even outside the industry, I'm saying, because just like you mentioned, they make certifications to that manufacturer utilize that and sell that price. Well, no, I'm sorry. They can keep it clear before
So then you're declaring. See, that's where it.
But we still want to show them the generators. Yeah. And this is where the gray area is.
I apologize. I had to send two more
technically, that individual source, so we're trying to find best it's not part of it. So we have to say, if we bring one in, we may utilize it, or we may use it. And that's so, from his perspective, you have to look at it and understand. So, I talked to him about the offer. The irony of this is, all those things, all this
As the paper trail from my contract, and it wasn't very effective. That's all sorts of people carrying like a dirty box. And I told this guy, attorney, the same thing. Well, yeah.
We're familiar with it. What we offer.
Now you start asking me questions, and I have to be quiet. And
The water's made everything tough.
And they got to sign off on that. My gosh. No, compact, mom said. Pulling those out and then just establishing yourself as the generator. But if it was clean, but then the space flood is here, I don't know. So, right, so you're not going to even be shipping.
And that's where, we're very clear, we want to be very clear, especially
No, I'm actually out of the branch office here in Austin. I've been working with them in calibration. Exactly. Keeping them in check,
Well, I just Mike Garner executive.
Mike, Travis, you've been a man on my agenda.
Okay.
You're going to see very soon.
That's a rare You know, it sounds familiar to me. We're kind of similar to things we do, kind of separate out. I'm so involved in the nuclear investigation. I don't know
Good morning.
Probably. He's probably who you talked to because he's one of our reps that go out and retreats. We have an office here. Our branch office as well as actually an office here.
So here's the way it works. So everybody's awake. When we bring forth
the house, or do you remove the whole house?
That would be more to talk to Travis about. Depends on the application, depends on the situation. But our license allows us to process
I would say no, because it is the case. If we, the federal part, we're talking about what we define industry. Or, but he can't ship but there is
Yeah, you do. And we only all the time. Yeah, yeah. You gotta see this person. Well, I want to make it easy for you guys. You got a big job. Crazy that is. Oh dear.
But it was very nice.
All right. Well, and I had asked Doug Bassett, and I asked him what I was asking him to be a speaker at my workshop to talk about the experience of having contact, where you're brokered, you pack, you ship it, the intention of your entire processing, nothing's happening, or you gotta, what are you doing now? What are your thoughts? He was interested, not great, but I was hoping that he could kind of talk about it. Well, like, what are you doing with the waste? How are you processing? What does Tennessee want you to do? Because now you're dealing with reservation. Well, yeah, I know, but I want our generators to hear that, you know, and that it's still in limbo. They haven't really finalized. Yeah, and I think it's come from the year 2012. The year, most of it was 2011. And, you know, and then they went to bankruptcy. So I had a few that went like be a little more flexible, you know, like, see what that makes us. If it's, you know, if you're gonna show that it's from, say, Falcon Harbor, they've got to make sense. And you've ended up with the process, okay? What you need to do is call and show me some proof that I have it, and I share it with your sign it as the broker.
Crack the whip.
We don't know what hospital yet, we're gonna get down on the track. Just like blame the tickets. I'll tell you what. You'll find out. They will own up and go on up.
Yeah, that's all right. I know. See all of you now. I got everything. Well, and then I was forgetting this guy that a big change. You know, and when you're in institutions and then if I was working too, it's like, oh no. We're on the same page. I mean, that was
Been texting me your questions and answers
Tell him, text him back, say, Bob says hi. All right, folks, if the noise will settle down to a dull roar, we'll resume the meeting when we get the commissioners back seated.
That's what I pop this break in the noon hour?
No. Wishful thinking on your part.
I was going through, I remember who you said.
Will you promise to be?
Yes.
How you been?
I'm fine. Susan, I've been doing this in a fine state. Y'all watch the weather.
It's getting a little nippy, yeah. First week when it hits, brutal.
Right.
Usually windy. Crazy stuff. After a while, I was getting around 20
I guess all the big leaves are on the ground.
All right, Dick. I'm going to crack the whip and see if we can get everybody back. All right, folks, if anybody cares, we're about to take up item number 8 on the agenda. Okay, item 8 on our agenda is consideration and possible action on each of the following applications and proposed agreements for importation of low-level radioactive waste. The first one is Philotechnics, which is limited TLLRWDCC number 1-0016-00. And John, are you up?
Yes, I'm up. The technical committee has reviewed this application from Philotechnics, and I'll just go over kind of a few of the high points. They've application as a I think I'm on. There we go. They've applied as a broker and for materials from small quantity generators. The volume is 47 cubic feet, and the curies is 0.007 curies, a very, very small amount of radioactive material. I don't see that the volume of waste and curies that they've asked for are materially going to increase the volumes that are received at WCS. Interestingly enough, we just recently received a copy of the TCEQ's waste study, and so the implications of that document, obviously this commission is going to have to read it and understand it and then determine how it may affect or change any decisions we would make with regard to import. But at this point, I don't think, at least I know I haven't had sufficient time to review that to come to any real conclusions. The material that they're proposing is sealed sources, or on my apology. In this case, it's 4 drums of americium 241 material. It's Class A and Class C waste. I guess I'll stop there and ask if any of the commissioners have any particular questions about the document or about the information.
Any questions of any of the commissioners? I reviewed it briefly. I don't have any.
The volume, the 47 cubic feet that they've requested, will easily fit within the small quantity generator set aside that we had discussed of 5,000 cubic feet. We were, I can tell you that not including any of the import applications before the commission today, the commission has currently approved 652 cubic feet of waste from small quantity generators. So this would be adding 47 cubic feet to that, and again, that's considerably underneath the 5,000 cubic feet of waste that we set aside.
Right. All right. Is your recommendation that we grant the application?
Yes, that's the recommendation of the technical committee.
All right. Is that a motion?
I make a motion. Hold on one moment. I make a motion that the commission approve an import application. The number for that application is 1-0016-00 from Philotechnics for a period of today through April 26, 2013. The origin of the waste is state of Massachusetts. It's dry active waste. The classification of the waste is Class A and Class C. We have received an approval letter from TCEQ that the waste is approved to be received at the WCS site. The volume of material will be 47 cubic feet, and the number of curies is 0.007.
Okay, there's been a motion. Is there a second?
Second.
There's a motion and a second. First of all, any questions from any of the commissioners about this particular application? Ms. Haddon, you look like you were going to tell us, make an address to us about this particular
Briefly,
application.
I would recommend, based on the earlier discussion, that americium is basically coming from Russia these days, that while it says Massachusetts, that you hold off on this until you can get a little more clarification on international origin, perhaps do a rulemaking. I understand that the TCEQ has approved it, but I think that there is cause to look closely at the international origin issue, and that this is something that could, in fact, wait.
Thank you for those comments. Robert?
Since the commission has previously said that waste is a matter of declared utility or lack thereof, There are two concerns I have. One is everything is becoming waste as soon all nuclear material is becoming waste as soon as it's taken out of the ground. In fact, before it's taken out of the ground. So it's just a question of when someone declares that it no longer has waste. I forgot to bring my styrofoam cup, so just imagine I have a styrofoam cup here. We agree that it's full of radioactive waste. It used to be full of radioactive material, but at some point it became radioactive waste because it ceased to have any utility. My argument is that a reading of the phrase waste of international origin says this radioactive waste, and we agree that it's radioactive waste, is of international origin. It has to do with where it came from, not when it became radioactive waste. And I think that's what the legislature was trying to say when they prohibited waste of international origin. They didn't want to fill up the U.S. Dump facilities with waste that came from other countries. It's a question of disposing of our own waste. And perhaps that raises the issue of whether we want to be importing radioactive material, knowing it's going to become radioactive waste. And to me, it's also a matter of utility. Let's say the Russians have a lot of what they call radioactive waste, but they suddenly realize, well, it's still hot enough that somebody could do something with it. So they take the waste and they package it, and they put it in a sealed source, and they send it to the U.S., and then it becomes radioactive waste when no one has a use for it anymore. But it's always been waste of international origin because the Russians said it was waste, but then they found out they could package it and send it to somebody who could use it, so suddenly it ceased being waste. I'm saying it is and has been and always will be waste of international origin.
Thank you for your comment.
Let me clarify something.
Sure.
About just a hair. All right, this waste has been sitting around for a while.
Yourself for the record, please.
Oh, John McCormick, by now. I know everybody knows. All right.
But Mike didn't.
Yeah. This waste has been sitting around for several years, and this waste did not come from Russia. It was manufactured in the United States or developed in the United States. It's a byproduct from a U.S. company, and it is U.S. waste.
Thank you. Anybody else have any other commissioners?
Well, I just want to comment that if we didn't allow the importation of radioactive material from other countries, we'd shut down nuclear medicine and our oil and gas industry pretty much.
All right, any more discussion from any of the commissioners? Hearing none, I'll call for a vote. All those in favor of granting the import agreement, application and agreement for Phylotechnics, please say aye. Aye. Are any opposed? Hearing none, the motion passes. The next one, 8B, Thomas Gray and Associates. This is 0017.00. John, you're up again. I sure do appreciate your help on evaluating these.
Try to stay organized here. All right. The next application is Thomas Gray, and Chairman Wilson has stated the number of that application. Thomas Gray is a broker who's acting both as a processor and a collector for radioactive materials. Their application is, in this case, for 30 cubic feet. And I will note that in the commission form, they requested 1 curie, but they also included some a draft agreement statement, and in that they listed 10 curies. In reviewing this, I'm recommending that we would approve them for 1 curie. They've included some other information, and when you add up the various quantities, I believe 1 curie is the correct total, and the 10 is probably just a typo. So the technical review is for, and approval would be for 1 curie. In this case, the state of origin of the waste are 3 states. It's California, Maryland, and Alabama. The waste is sealed sources. It's Class B and Class C. It is stable, and we did receive an approval letter from TCEQ dated October 2nd where WCS is approved to receive these materials. They've requested, again, 1 curie of activity. They are requesting 0.0053 microcuries of technetium-99. This request is from small quantity generators, and I believe it would be appropriate to attribute the waste to that allocation. And as I noted earlier, we have not had an ample opportunity or enough opportunity to review the TCEQ report in terms of projected waste volumes at this point, so I can't make a comment in that respect. The volume in the curies is very small, though, and again will not appreciably increase the amount of waste being received at the WCS site.
I understand. Any questions from any of the commissioners? They're in the Southwest Compact. Some of these sources, do they have permission to export?
Yes.
All right.
And that those were included, those were provided
right.
to us during the
I thought they were, but since Cassie's here, I wanted to make sure. All right. Any other questions or comments from any of the commissioners?
So the recommendation of the technical committee is to approve this import application.
I figured that through April 26th, and it's 1 curie.
I'll make a motion if there are no questions. So
there aren't any.
All right. I make a motion that we approve the import application from Thomas Gray and Associates / Environmental Management and Controls for a period of today through April 26, 2013 for waste coming from California, Maryland, and Alabama, consisting of sealed sources, Class B and Class C. It's stable waste. The volume is 30 cubic feet, and the curies requested is 1. And they're also requesting 0.0053 microcuries of technetium-99.
Is there a second?
Second.
Okay, there's a motion to second. Any questions from the commissioners? Mr. Singleton.
I'm sure also they were asking for 1 curie but not 10, but I just think there ought to be some penalty for an order of magnitude error. If I went home from college and told my mom I got 100 on my physics final and I actually only got a 10, I think there would be repercussions for that. So I think anytime you get an order of magnitude error, you ought to just have a policy that you have to resubmit the application.
Thank you, Mr. Singleton. I think the penalty in this case would be that if they really wanted 10, they're only getting 1.
They're only getting 1. Okay.
And they will come back. I would
Let's make sure they don't make an order of error, order of magnitude error on the invoice or the manifest, though.
They're only going to get, if we vote to approve it, they're only going to get 1 curie from us. So, and I'm sure TCEQ will track that. So that's the motion and the second. Without any further discussion, all in favor of the motion to approve the Thomas Gray and Associates application as described, please say aye.
Aye.
Any opposed? Okay, no opposes. Thomas Gray passes. Another one. Third, Perkin-Elmer Health Service Sciences, Inc.
I'm going to be representing Perkin-Elmer.
Great. Let me let John go first.
Which John?
Which John?
Commissioner John.
All right. Perkin-Elmer has submitted an application which the number for that is 1-0018-00. Their application was for a small quantity generator set aside. And this is not the first application that we've received from Perkin-Elmer. We have already approved one. In that other one, the commission disagreed that it was a small quantity generator based on the volume and curies, and I would make that same comment today, we don't believe they're a small quantity generator, and as such, we would not attribute any approval they received towards the small quantity generator set aside. They've requested 96 cubic feet and 3,651 curies. The waste is coming from Massachusetts, and it is laboratory trash and paper, plastic, glassware, materials like that. It is unstable waste. It's Class B. They're not requesting any activity for C14, technetium 99, or I-129. And we did, there is a letter on file from TCEQ dated October 9, 2012 that approves WCS to receive this waste. In their initial application, they went through an explanation indicating that if we approved this agreement, that we would terminate their earlier agreement. When I looked at the accounting of the amount of radioactive material that they've already shipped, that would have created difficulty because they've already shipped more curies than this application is for. So if the commission were to take that action, I guess it would immediately put them into violation. So
that was a mistake in the letter.
And we then subsequently received a communication from PerkinElmer where they acknowledged that they had made an error and that they did not wish to have this commission terminate their earlier agreement, and I would agree that I think that would be precipitous for us to do that. So with that, are there any questions?
Our application said term and duration approved 2 years.
That's correct, and at this point, when I get around to making a recommendation, it will not be for 2 years. It will be for the same term that we've approved all our other agreements for, to end April 26, 2013.
Okay. My question is, these curies not in the small quantity set aside, I assume we still have room in the 200.
I'm glad you asked that question.
Curies.
John, let me give you a new accounting. Make it a little easier on you. Originally, the commission approved 15,188 curies. We've already disposed 11,634. So on the current application, there's 3,554 curies remaining. All we really need is 96.96 curies for what for this application, for what we have to ship. We're going to make the shipment in December, and that will basically close out what we have stockpiled. So our total activity that we want is not the 18,000 number, John.
So you're asking for 96 cubic feet and 96.96
curies, which will get us to where we need to be.
Is that 96 in addition to the previously approved? Or
into the previously approved 15,188, we want to add on basically 100 curies to that.
These are increments.
Right. Because the application that they sent you was for, I believe, an additional 3,600 curies.
It was 3,651 curies.
Yeah. Yes.
So you only need
96.96. So if you could round it to 100, basically, that'd be good. And Judge, to answer your question, it'll be shipping this year. So.
Well, why don't you? I'll get Mr. Williams' question first, but why do you want that much, but you didn't use it?
I've just recently become involved. So, you mean as far as the 2-year time period?
Well, I mean, it's just one thing for the commissions. We said before, when y'all come and ask for your deal, ask for what you need, and not because you're taking up space and time for somebody that may have, we could have used that 4,000 somewhere else.
You know, again, I just entered into it with them, but what I believe the problem was is they didn't know how to amend their current application. So they have a shipment that is this much activity, and they thought their other one, they had to cancel it out and then to resubmit a new one for the new shipment.
I guess what my question was is they told us they needed 15,000 in the beginning, and they didn't.
Well, they pulled some stuff off the last shipment. That's why they did need it. They did need it, but it just didn't make it to the site.
So they will use the entire 15,188 curies of the original allocation.
Plus 100
plus
more curies.
They need an additional 96.96
Right.
curies.
It's just a matter when you ship it, John, is that basically what this?
Basically, right, is what's happened.
Judge, I will also say that I was somewhat at a loss for trying to understand the math as well.
Well, we're trying to get all this stuff in by April or whatever we're supposed to get it in. Everybody needs to, and you're doing a good job.
So in essence, you're saying they will get the entire 15,188 plus 96.96 curies shipped by April 26th.
By Christmas, actually, if you approve it and I get a letter, the minute I have that, we'll set up the shipment and it'll come in before Christmas.
Yes, of course.
These guys are a little more conversant in this than I am. I take it that there are certain parts of this petition or Annex A that would be changed, right?
Essentially. And really, the best way would have been is to just go for an amendment to the current application and ask for the additional 100. And that's the way we should have proceeded, but there's no real mechanism in place, and they misunderstood, so that's why I'm here now.
But I just want to know whether we're going to wind up with a written record that, other than tossing these numbers around.
I would be happy to present one to you.
Whether we're going to wind up with a written record that tells us what we've, assuming we vote to approve it, tells us what we've approved. I mean, it
would be 96 or 90 or 100 rather than.
And I'd be happy to provide that to Lee on Monday, if that would be acceptable.
All I'm asking is that the blanks be revised and filled in, and if everybody's kind of on the same page, that's okay. But my problem is that this kind of opens the door to revisions, like as we're traveling along, kind of we're saying, well, we're going to do this more curies, and you've got them over here, and this more.
And that's the problem
with so on. But there's, I mean, these are sophisticated businesses, and these are, and this is a sophisticated business. You're in shipping waste. And there's absolutely no reason why this shouldn't be fairly cut and dry. It's not something that people should. I realized that there was an outfit in Vermont a few meetings ago where I had to kind of make the plea, well, they didn't know quite what they were doing and they want to move it around a little bit. But it made me uncomfortable, I must confess, and I think it's important that we send the signals that the shippers are going to have to give us the exact numbers that they want. And even if that means coming in at the day of the hearing and saying, this is a slightly changed, and let us show you the change. You know what I mean?
Yeah. In this instance, I think they anticipated shipping X. They could have requested much more, but they didn't. They tried to be too accurate. And when you prepare a waste shipment, a lot of times, as things go along, you collect more, you have more coming in, and you just don't know. So in the absence of anything before, a lot of us have asked for a little more activity than we needed.
I don't have any quarrel with that. I understand.
Okay. They played it too close to the vest.
Kind of rounded up or whatever.
And at this point forward, we shouldn't have any of these questions. Ryan knows a little bit about this waste too.
I'm sorry, I'm Ryan Williams with WCS. I guess, John, I guess I have clarification. Based on the previous application that was approved for 15,188, they should have requested 15,888.
888, and it was a typo.
So that's a difference. They still need that, so that's a difference of 693 curies
Okay.
that they need.
Currently, I guess there's 3,600 sitting.
Correct.
Plus 50 more scheduled. So we need 3,651 off of the 11,634, and that's where we're coming up with a 100 curie difference. You already have in-house 11,634. Okay, that leaves us with 3,554 on the original application.
And that totals the 15,188.
Right. So 3,600 you currently have, okay, plus the 51 comes up to 96.96. So basically 100 curies more is what we need. And that satisfies you and satisfies the next shipment.
I'm sorry, I guess so if they needed the 15,881, correct, original,
Mm-hmm.
they were given something that was 693 curies less.
Right.
Now they need another 100 more.
Well, they were only, the number they have, John, which number do you have, 15,881 or 15,188? That's where I think the problem is.
Yeah, because they meant to request, from what I understand, 15,881.
The Perkin-Elmer request 00-0006-00 was for 15,188 curies and 378 cubic feet. That's what the commission approved.
Right. So that's why we're short now. That's why that shipment couldn't go in, is because the 881 was transposed to 188 at some point.
Okay, so that would bring us as a shortfall of 693 curies?
Right, we would have been fine.
If we had approved the 881.
If you'd approved the 881, right.
But we didn't. We approved 188.
We approved the correct amount.
Right.
Okay.
Yeah, so that's why I need 100 more curies. And again, I will give you something, Lee, on Monday documenting all this.
And if I may offer, I know that our amendment process isn't always completely clear. That's very well known amongst our commissioners. And so what happens a lot of times when people have an amendment or have something they want to change, I invite them to call me ahead of time. And before the document is submitted, we can go through some of the details and run the traps to ensure that anything that needs to get worked out can be worked out ahead of time. So I invite Perkin-Elmer to do that at any time.
And as far, I want to make this statement real quick. As far as I'm concerned with my amendments, Lee and Audrey have been very, very helpful. And I do appreciate everything you guys have done.
Well, I didn't mean to throw a monkey wrench into all of this.
Actually, I very much appreciate your question, and I think there was still perhaps some confusion among as to how many curies they were actually asking for.
Well, I think of it kind of as a lawyer in court. If you're going to change the numbers that you're going to put in front of the judge or the jury, you at least show up with a sheet, if not a great big blow up of it. And I think it would be good if in the future we had that kind of.
I wholeheartedly agree.
Well, are our friends from WCS now satisfied? Or are they confused and still have questions?
And maybe I'm just confused. But I'm still thinking that the amount would have been for 15,881. We had another 100, so we should be getting 793 total curies to receive the remainder of that shipment plus the additional.
Can I do this?
Y'all go offline.
Yeah, and then can I come back at the end here?
At this point, the technical committee is not ready to make a recommendation.
Very good. We'll move on to the next agenda item. We'll come back to this one shortly. That one was 8C. We'll postpone that temporarily. The next one is 8D, Students Processing Facility, Irwin, LLC, and that number is 10019.00.
Good morning. Joe DiCamillo, General Counsel at Studsvik.
Hi, Joe.
Good morning.
The technical committee has reviewed this application from Studsvik. In their application, they have requested a term or duration that would end April 26, 2013. They're requesting 722 cubic feet, 4,457 curies. The waste is from Tennessee. I would note that similar to their first application, Studsvik has indicated that they are the waste generator, and this commission in the first application and in this application, at least the technical committee would disagree that they are not the generator of the waste. They are acting as a waste processor, and we believe that that's the way the paperwork needs to be completed, and we believe that would be in accordance with the TCEQ form that we are going to use as guidance or implement. The waste is Class A, Class B, and Class C stable material. They're requesting 5,143 millicuries of C14 and 133,886 microcuries of technetium-99 and 22,457,143 nanocuries of I-129. The material is solid metal oxides, spinels, carbonates, and aluminates, which are collectively referred to as reformed residue. TCEQ issued a letter on November 8, 2012, indicating WCS is authorized to receive this waste. And I would note that approval of this amount of material in terms of the curies, hold on one moment, would result in the commission approving slightly in excess of 219,000 curies for large quantity generators. So in this case, approval of this would put us over the amount of curies that were allotted to large quantity generators. And in terms of our total approvals, approval of this would take us to 219,624 curies for both small and large quantity generators. Very close to the end. Questions for the technical committee?
How about carbon-14? How does it stack up against that?
One moment, please. For large quantity generators, that would take us to 58,282 millicuries, or 58.28 curies of carbon-14. The current limit may be 180 curies if in fact the legislature intended that the carbon-14 curies be limited to 30% of the approved initially licensed volume. So it would take us to almost 1/3 of the 180 curies if that is the number intended by the legislature.
Any other questions from any of the commissioners at this point?
And I assume you guys have been able to ship everything to WCS, so you're all caught up with shipping?
We have used all of our of the last approved petition.
So you've used your allotment?
Correct.
Okay.
And this is, of course, additional waste, as I think we explained in our cover letter. we're constantly receiving shipments, constantly processing, so we do our best to try and estimate what we need from now until the end of what I'll call the April year, and so that's the genesis of this particular petition, right?
Is it still in Tennessee? Is this waste still in Tennessee?
Yes.
Other questions from any of the other commissioners?
It's not a question, but I think we have an agenda item. Can't remember if it's the next agenda item or not, but it's a discussion on the issue of
disposal allotments.
Disposal allotments that may have some bearing on this and any other large quantity generator applications before us.
The only thing I'll say at this time is I sure am glad you technical people are around, because when I asked Linda a question a couple of weeks ago, is there a standard way to measure curies, and was told there are several. It caught my attention, and I assume that the curies we're talking about are the curies on the shipping manifest.
Correct.
And that's where. So however those are calculated, that's what we're using. All right. Mr. Balser, did you want to address this?
I was just going to, Rod Balser, WCS. I did want to confirm Studsvik is shipping. They have shipped, and they expect to be a continuous shipper. We do have a contract in place with them. So I would encourage the commission, even though we're going over the small quantity reserve, to use part of that for large quantity generators. We're basically 4 or 5 months left of the import year, and I think there's been ample opportunity for small quantity generators, and I think there's still opportunities as the possibility that some of these curies are not used or are not able to be shipped in the time frame allotted in the import applications, that some of those may not come to fruition. So we're just encouraging as many of the import applications that can be approved are, we have the best opportunity to actually ship and receive and dispose of the 220,000 curies by the end of April. And that probably is a lead into the next agenda topic.
I was just going to say that it was, but that's okay. Any other questions or comments from any of the commissioners?
We want to go in. We want to go into the other and then come back to this. I'm not seeing what the others are going to say, since the legislature set the curies and cubic foot at one number. I don't know what TCQ report is going to say versus that.
John, do you feel comfortable allowing this one in so close to the 220,000 curie limit?
I think
the last one under normal approval processes.
I think my concern would be that and this isn't a recommendation for or against the Studsvik application. It's that if we approved it, it would clearly limit our ability to approve any other large quantity generators who, I know we have at least one amendment application before us there that we don't consider today, but I think we will in a future meeting. And I think if we approve this one today, then that would perhaps make it impossible for us to approve any other large quantity generator amendments or applications without either limiting the small quantity generator set aside or reducing that allocation, and or perhaps hearing from other large quantity generators that they do not intend to fulfill their entire allocation that they were granted. So it seems to me that perhaps we need to talk a little bit about the volume question and the curie question before we approve at least any what I would call large allocations. There are some additional, I think, small quantity generator allocations that are very small and won't materially affect the volume or curies. Did I answer your question?
I think so.
Mr. Chairman, I think at some point in time, based on the last discussion, I believe we had at our last meeting, I went away with the assumption that this commission would at least look at potentially going over the 220 if we got a report from WCS and hopefully from TCEQ that said that some of the allocation that we've made already didn't come to fruition.
I think that's our next agenda item.
So,
do we want to defer action on this until we talk for the next, Mr. Chairman?
Yeah, well, where we are on item 8 is that we deferred action on Perk and Elbert, let them figure out the math. And we're now considering the Studevik. We have another Studevik and a Thomas Gray application on this one before we get into the question of the disposal allotment. And that's you, Linda. And so perhaps we have not yet made a motion. And why don't we do this? Why don't we could have lunch. That's one suggestion. But the other thing is we can, John, if you will give us a report on the second Studevik application and the Thomas Gray, and then we'll have all your reports out of the way. We won't have motions yet. And then we can talk about the implications of all of the applications that are yet to be voted on this on the limit that we're talking about, see what we do with that. Okay?
Sure.
Why don't you go ahead, and if you'll excuse us, Judge, we're just going to do that. We're just going to get a report on your next application, and then the Thomas Gray and Associate, which is item F, which is the 21. So, number 20.
Studevik has a second application before us today. It's numbered 1-0020-00. That application is for waste material, in essence identical to the previous application in terms of, I won't read the full description, but solid metal oxides, etc., etc. This application is for 2,166 cubic feet. It's for 13,371 curies. It's again Class A, B, Class A, Class B, and Class C waste. I won't read the full numbers but they are requesting an allocation for carbon-14, technetium-99, and I-129. The material is stable. I will note that this second application is not for this shipping year. I guess we will. Correct. I'll use that phrase. This would be for, or they propose that it would be for a period of April 27, 2013 through April 26, 2014. So in essence, the next shipping year, if you will. There is a letter from TCEQ dated November 8, 2012, which gives approval for WCS to receive this material. And same issue with regard to whether Studevik is a generator or a waste processor is before the Commission. Are there any questions from commissioners on this? That's sort of the high points of the application.
So we're starting over at 120,000 curies again.
That's my understanding is the legislature limited, other than the first year, we are limited to 50,000 cubic feet and 120,000 curies.
And obviously we're going to have a number of questions on this one. One is do we want to act now or do we want to defer action? And we'd like to hear from Studevik about and I personally would like to hear about two things. One is the timing of our action, and secondly, to add on Mr. Sadek's question, is will this be all you need for that shipping year, operational year?
Sure. So
Pardon me one
I'm
second.
sorry.
I apologize.
No problem.
Mr. Chairman, do you want me to go over the other application before we begin discussion?
Yes.
All right.
My apologies.
No, no problem.
I wasn't sure either.
Nor was I. So go ahead, John. What's the next one?
The next, and I believe last import application on the agenda today is from Thomas Gray and Associates / Environmental Management Controls. Its number is 1-0021-00. And this application is from Thomas Gray is a broker who is both a collector and a waste processor. They have requested that the allocation be considered under the small quantity generator. They are requesting 15 cubic feet and 0.3 curies. One moment. The state of origin of the waste is California, Kansas, and Maryland. It is sealed sources, Class B and Class C, stable. We have received a letter from TCEQ dated November 8, 2012, which approves WCS to receive these materials. They have, in their request, they are asking for very small activities of both C14, technetium 99, and iodine 129. And I believe that hits the high points.
And this one, I take it, would expire on April 26th of 2013, as the rest of the ones we've so far.
Their request is for a duration of 1 year, beginning, oddly enough, this October 1st of 2012 through October 1st of 2013. My recommendation would be that we would only approve an allocation through April 26, 2013 initially. So,
well, that'll give us something to talk about in our next agenda item when we talk about the various allocations and how we look at them. But thank you, John, for your reports and your work. We couldn't do it without you. And I think we're going to break now for lunch until.
I have a question.
Yeah, Judge.
If these, the one we deferred and this one's small generators, why couldn't we take up those?
I don't know that they've finished talking.
John, are y'all through talking, WCS?
Yes.
We can do that then. We're back on Perkin-Elmer.
Yes, we are.
I'm back. All right. Basically, what I would like to do is amend the earlier application that was approved for 15,188, add 100 cubic or 100 curies to it to make it 15,288.
Philosophically, I understand that request. I'm not sure technically that, from a legal perspective, what we have before us is an application for a new allocation as opposed to an amendment request. So I'm going to defer to our learned counsel.
What would be the total of the new
The
application?
total I want, period, is 15,288.
So what do you have to add to this application that you have before us today?
Okay, you've already approved 15,188. So 100 curies is what I need.
So in essence, this would not be an amendment. This is a new allocation, an application for a new allocation of 96 cubic feet and 100 curies.
Right.
It's important that we keep our.
That's fine. Whatever is easiest on you is what I'm trying to do.
Probably would have been better.
Yes.
To have had an amendment. But we are where we are.
Yes. We'll correct that in the future.
I think we can vote on this today, but we couldn't if we wanted to.
That's right.
That's right.
And so where we are is we have an application for a new allocation of basically 100 curies.
Right.
And how many cubic feet?
It's 96, almost 100 cubic feet.
100 cubic feet and 100 curies.
100 curies basically is what we're
round
looking
number. And so that would be in addition to the previously authorized
Amounts.
allocations.
Yes, correct.
And
Both
agreements.
increments. Yes.
Yes. And so, do I have a motion?
Well, actually, before I make a motion, I'll just point out to the commission that we have currently approved for large quantity generators 214,560 curies. So if we approve this, that would add another 100 curies. We would be at 214,660 curies, which is under the large quantity generator allocation, I guess you could say, of the 220. So I just point that out. So I make a motion that the commission approve the import application from Perkin-Elmer for 96 cubic feet, 100 curies. It's non-compactable trash, Class B, for a period of today through April 26, 2013, and the waste is originating from the state of Massachusetts.
Is there a second?
Second.
I hear a second. Any commission discussion or questions or comments? Ms. Haddon?
I would like to ask that you consider requiring that this be submitted in a more clean fashion. There's been so much discussion. I'm a little bit unclear at the moment whether this is an amendment or a new application. And we're supposed to be able to have, as the public, time period in which to comment. And this is an ever-changing application. This is the very kind of problems that we were trying to prevent when we worked closely with this commission in trying to develop the forms. And the capacity is getting close to limit. The numbers are ever shifting. I don't feel like we're actually in a position to be able to effectively comment when the applications change continuously. And again, I would like to urge you to hold off on this one and ask them to resubmit and make it clean.
Thank you, Ms. Haddon. Any other public comment? Any commission comment or discussion?
Excuse me, I have a question. So, just to be clear, we're approaching the 220, and
we're at least right now, I'd say it's probably more accurate to say we're approaching the 215 that we allocated to large quantity generators.
I see. Okay. And so, as a practical matter, this is other than the whatever it is, 350 that is still in play, I guess. This will, or no. I guess it's 5,000.
Hold on a moment.
5,350.
To clarify, if we approve the application, the Perkin-Elmer application, that will take us to 214,660 curies from large quantity generators, and in total, including the small quantity generators, that would take us to 215,267 and change curies. The limit is 220,000.
Yeah, and so you're counting the ones that will presumably be shipped before April 26th through April 26th.
Those numbers are allocations that we have approved. It is not curies that have been shipped. In some cases, they have been shipped. In other cases, they have not, which is the next agenda item.
Oh, okay. All right. I mean, I'm just trying to kind of figure what we're working with here and what we have left. Yeah. Thank Thank you.
You're welcome.
All right. We have a motion and a second. Peter?
Just an observation. It does seem to me that both the previous discussion and Ms. Haddon's comments do point out the difficulty with this process of spontaneous amendment, and the more that you can clear these things up beforehand, not only the better the quality of our consideration, but also the fairer it is to public commenters.
And again, I wholeheartedly agree, and if I had been more involved earlier in this process, it would have been taken care of quite differently.
I would add the technical committee would also appreciate that.
So will we see new paperwork between?
I will give Lee new paperwork on Monday.
If I may, please call me before you submit it to me.
Okay.
Thank you.
Thank you.
Everybody, any more questions or comments? We have a motion. Judge?
This is for the approval of this application before the commission, right?
Yes.
Okay. It's not for what we're going to give Monday or whatever.
No, it's for, we're going to make a motion today to approve, the motion is to approve an additional quantity.
96 cubic feet and 100 curies.
He read the new numbers.
And what's going to happen is that they're going to give Lee paper documentation that what we are proposing to vote on is what they are in fact wanting us to vote on.
Correct.
And the duration is through April 26th.
April 26, 2013.
Not
so
2 years.
No,
it's
2013.
Correct.
No.
All right.
Probably small or whatever you say.
All right.
That's what you say when they're
Everybody clear? And are we ready to vote? All those in favor say aye.
Aye.
Any opposed? All right. Motion passes.
Thank you.
As made. Thank you. We have the two Studevik applications and the Thomas Gray and Associate, which we've heard reports on, but rather than leap into our discussion about the disposal allotment committee now, we're going to break for lunch until 1 o'clock at the earliest, and it'll probably be a few minutes later than that, to allow everybody to relax, and we can then leap into the discussion about the allotment and the requests, and we'll progress from there and then come back to the other applications that are pending. Thank you. We're in recess.
We can save it until we get the shipping plan, we don't know how many
What time? Sorry. That one will pick up separately. If we have I prevented you from saying?
Well, I know that the good big here this year.
Okay, in view of that,
Hello. You go back to how are you? I'm fine. We don't set them. Charles McGuire, he can, he's here and he can direct you to the right people at PCP because he's not involved in rate setting either.
They're sitting back in that corner back there, seeing right now.
Glad you're here. Stick around.
Which is a problem because they've got some pretty good schedules. So far, I've been
Oh, Ken says he'll see next Friday at the trad meeting, then he'll ask you
T-Catch was telling me that he's been flying around so much that he's the only one flying economy. I keep switching airlines. This week,
So you moved into your new place? Yes. Well, of course it's cute. You're living there.
Jim.
I like Jim.
Yeah, I feel fine.
Chargers TV, and I'm like,
What's
the number now?
I'm always surprised in the nuclear industry. I'm always surprised they are.
Some actually get that sheet ready to go. Actually put that resin into that diategrous and take it. It doesn't always, the ones that comes out, work out the curies and the volume exactly that you thought it was going to do when you asked for the allocation. And so I give them a little bit more action. They don't have all these shipments sitting ready to go. They're asking for the allocation and then they're planning their ship out.
But I was worried enough about the indication of the capacity that I was considering talking about
That's going to be part of our discussion. I think our learned counsel is way on giving this on to taking back our dollars. So
you're saying they started selling it themselves?
No,
or not
that
using it?
because that study,
that is prohibited.
in the way it works, the language that fits into 4 words and 4 words.
Might be.
Yeah. I do get the feeling McCormick is kind of at the crossroads.
Well, he's representing
Betsy first.
they have been, I think they have been shipping those ways directly. There's a reason why you got that waste from they are doing. As far as I know, we'll be here.
What we started talking about. I'll tell you now, it's very apparently there's something about it. I told him, he would take it. Yeah. And then But
that's the compact area. However, the other caveat to that is, every year until it's done a final disposal, you would have to send me an interim disposal saying, right, what's, just on that, I'll say, okay, 2011-13 petition number. Hasn't been disposed of.
yeah, well, Melissa,
Joe, we haven't done it yet, and there's a box on the disposal report that says interim.
I don't think so either,
Still
but it could be
pending.
interpreted that way.
And then it's just a one sheet page, and then I
Then,
attach it
but
to
she
my
would
file,
talk about.
so that I know next year.
So am I looking.
It's no big deal, but it at least shows paper trail.
So, go ahead.
It's still an illegal, you haven't done paper, you haven't, you know.
It's just.
Right, we didn't move to Canada, right, yeah, you're still not, oh, yeah, you're not a bad kid.
We make margin, sold disposal and sold more overseas.
Right, so yeah, you can do it that way too, whatever would be easiest for you.
So what we'll do is in this case, we
Do you have a card with your?
I actually got it. I actually got this morning with.
State, this is the volume of this is the total activity.
I actually have your contact.
Okay,
I'll shoot you my.
And shoot me an email, and then let me just send you the form again. I know I sent you some forms already.
And Monty, and honestly, on the day-to-day, Monty and Tony and Neil, and I'll talk with them.
Not to Neil, but I have Tony's information, but I have to talk to Monty.
Tony's ours,
Okay.
we'll be here until take it.
Okay.
And then Neil, so if he may call you if he has a question.
That's
He's the one that actually does the hands-on process.
Okay.
So he may.
I haven't decompressed yet. I'll be down there in a little bit. Go ahead.
I can show my commissioners. No, this is here, it's being stored here, and it's on an interim basis, it hasn't done a while.
No,
No, I'm just covering, and I'm really covering your ass too.
I'm sure glad that you're looking at all those important, I sure am glad you're looking at those. I could not do this without
I
you.
really will be happy if they can get their numbers straight. It does make it so, that's the reason why I brought the computer today, because I had a feeling this kind of stuff was gonna come up. And of course, I can manipulate the numbers any way you want in terms of looking at, if we take from one and give to another, or however that's gonna work out.
That's my problem with him and his attitude.
Somewhat complicated.
He had a material.
We're gonna have
And then he
a hour-long discussion about that.
And he has no way.
I'm afraid so.
But
I'm not on that committee.
If the state of Arizona.
I may have an opinion, but I'm not.
Well, I have an opinion.
And say, well, I see you received, you had these materials, where are they?
Privately, we see this.
For him, it shows the transfer.
There's nothing to prevent us from
Yeah.
putting more than 220
According to NRC and state regulation.
in the compact. We'd be stupid to do it.
I would agree with that. Well, I'm comfortable with it. It is more than 220.
I'm not either.
So,
And when I talked to Rob,
industrial guys, that's
what
what they're.
switch software up,
That's the only,
we
beyond that,
want you
they
to get
have
to 220.
absolutely zero knowledge.
No, I don't have a problem with getting to 220.
And NRC and the state don't put that on them.
I have a problem with improving more than 220.
Yeah,
They want to get to 220 and.
Gotta get my.
Training, by the way, what you call it.
Ability.
That I'm okay with.
Okay,
If
now,
there's
I
a
guess
condition
that's
which
my
says,
problem is I've never.
if you're approved, except that we're limiting the
If these
commissioner
shipments
from.
take the total
Yeah.
up
Oh, yeah.
to 219.9, you can't ship.
We do that. I'm absolutely fine with that.
Yeah, that's where I think we're going.
And what's gonna work for me.
Yeah.
Let's go with that.
What this is, and the landfill.
Gotta get the information.
They've already done.
So they're the ones who
one
are.
of the reasons
It also
the
means,
NRC work with us and do what we do is.
the question I have,
Consolidate for these specific
what happens
applications.
if they ship it?
And, it's one thing that a lot of people look and say, that's works with what you do.
Well,
You
it's,
gotta get into this and this.
to me, that's a separate question. Shipping for storage, just like, Studsvik had a bunch of waste in storage there, it was not in the hole.
You don't know what I had. on the agenda that your cohorts convinced me to take off.
See, and I was telling you that one of the reasons why I heard about you was
TCQ on how to keep up with
was I had a
material
broker's calling
brought into the
saying that you weren't doing
company
business
for
properly.
storage that has the possibility of ending up in some company.
But you are going to be out.
I think we probably need to hear that discussion eventually. We don't have enough time on today's agenda, but.
What I learned was that the system that they had talked about putting in place got pulled out. I don't know that they were talking about doing it.
Right.
But
So, but I mean, it's a different arena, see, and so, but,
Who
so
talks
there's,
to who?
and again, they're in this other box.
Like
And so they see you as, but you're not
what's
working
in
on
storage.
it. We're forced to
How
work
that
with
relates
the
to
state.
disposal.
And what's funny about that, when they're doing that response, with one approach, if they were to go to apply for license, do what we do, they'd probably plan this, we're not gonna allow this. In many ways, until the system.
You're gonna hear
It's a much more efficient process, not only
one of
for
the things in the rule that we need to consider is a rule for
so you
importation.
can reduce volume, so we send stuff in. First of all, keeps the cost down to the customer, but it also keeps the.
I'm not volunteering for that committee.
I know you're not.
All right, I'm gonna head that way.
Yeah.
Which ultimately saves much of the money.
Right.
So they don't end up in a disposal.
Right.
One of the ones, just to speak to that right now, is Amarillo right now. You know, there's nuclear data in the market right now that according to everything's in place, in 10 years, nuclear density before we get just the construction will cost them upwards of $30,000 cost to dispose of that. It's crazy. Those haven't come off the market yet because they still have a useful function, they're still fairly new in the industry.
No one can afford that.
Let alone the fact that it's $50,000 gauge,
Right.
charges $50 to test with it.
Right.
And $30,000. So what's going to happen? And this is what we're scared about. We look at this and we go, this isn't solved. In about 10 years, what's going to happen is we're going to have these licensees that start cages get broken, run over. We have one facility that ran over, and changed the prices on that. We actually have one of these licenses already. But when that happens, or when this stuff starts happening, we're going to start
Right. Well, see, and that's the whole concept of why we're, we're wanting to have the
everyone
a little protection. We understand that, yeah, but you understand a small home and mom and pop contractor guy,
Never going to be able to afford
he
it.
can't afford to replace it.
And that's if they do it themselves.
That's
If they hire someone like us.
See,
it
that's
could be-
ridiculous.
Yeah.
They're
And
better off to just put it in their garage
And it'll be there for the rest of their life.
and buy a new one, a new unit for $8,000, and not worry about that. And then when they die, it becomes an orphan source.
But the orphan source is the one that's rejecting it as well. Because they can't focus on that outside of discussion. So you can't even dispose of it through those, because those guys have funding to take care of that, and that's where all this stuff is going. They can't even take it now, because the rules are, the manufacturer can't take it.
That's done.
So now it's gotta go to WCS, or it's gotta go to, Canberra, whatever disposal that's in. And the limits there per container, the uniformity limits, are 30 to 40 military containers on the side. That's one gauge source. And the cost for one barrel is, especially at Convex, 32,000 plus fees. So.
In my garage.
That's exactly what's happening. We had one scenario actually, because we've been sending everything else, our fees, we had actually, in fact, I didn't want to.
Because, see, they're doing that report right now on sales sources. And this is the perfect what if 10 years from now.
Emery's even one that, for us, we know these extremely good.
So that, you want to get a hold of them before they do their final report, you need to have some input into that. And I'll
identify, it's exactly the same thing. If they can tell OSRB what this generator material from last user, then they can accept that.
Right. Well, that's it. And then I don't want to make you miss your flight.
Oh, you're okay.
So,
Is that us?
is that you? No? Well, because that's, I'll email you Leonard's information.
I appreciate it.
You need to call him and get on to the, and we're going to have the next meeting.
What?
Just the TCC. How was the Vermont meeting?
It was great.
Oh yeah. I wish I could have gone, but I couldn't. So I wasn't asked.
No, we had a great time up there.
Where was it? Was it in Montpelier?
Yes, it was.
That's cool.
I'd never been to Montpelier before. It's I thought I was from a small town, but Montpelier is smaller.
Oh really?
I'm ready.
Better go quicker this way.
Except I don't have any boats.
Yeah.
Well, John McCormick was talking at Hagen, too, trying to get us to do an interstate exemption and bypass DOT for extension. So that's only on emergency basis. I don't think you can buy it. I don't think so. I've had that discussion with Richard.
You still representing that conservation district down in Gonzales?
I hauled it over.
It's actually in Lockhart, Plum Creek.
What y'all have to do something? Certain folks that were in two had a big election. Which way they were going to go? You guys handled that already? Are you their general counsel?
The district, yeah. The Senator Hager passed a bill that made the Gonzales County District send a letter to everybody that was duly annexed, including the people who asked to get into our district.
Have y'all done all your permitting and everything?
We're permitting, we have rules, we have management plan, we have all sorts of stuff. We're having a good time.
You already did the desired future condition, all that was due last year. You know,
The GMA.
The GMA. You know, I challenged one of those. If we go to the Texas Water Development Board, we lost. But at least we went through the process. It's kind of a quirky process.
It's a horrible process, and the whole issue of how to deal with that as groundwater district is just ridiculous, because they pay lip service to local conditions, but they adopted the DFCs and the model available groundwater on an area-wide basis, and the Oxford, the management area that my district is in, goes all the way to the Rio Grande Valley. So
you may have, and it's all a common aquifer?
Yeah.
So you have one that's trying to conserve it, and it's pumping, and sometimes
yeah,
that's
and it's thicker in some places and thinner in others, you know, and it's just a mess. And then you have to look at recharge and sustainability, and people look at that differently, and then there are the folks who don't want anything going anywhere, and people who want everything going somewhere. It's just.
Are you aware of anything? I mean, I've read that the legislature wants to focus on some water issues this session.
I've read that. I haven't seen any bills yet.
I was talking to some folks from Solomon Central Water Systems. I think they want to make a run at that provision that talks about that limits the duration of an export permit, permit to take water out. It's 5 years, and if you spend so much money, then maybe you get it.
30 years, yeah.
I think they haven't spent the money yet. I think, like, here in Gonzales, that may be your district.
No, it's not my district. They're down in Gonzales County Underground Water District.
Right. So that's
Gonzales County goes up now into Caldwell County. And they've got the better part of the Greenville Wilcox, which is the only source of water for Caldwell County. So that and San Marcos River. So Caldwell County is going to get Dust Bowl.
The Dan McDaniel decision concern you guys much?
The Dave McDaniel decision? Yeah, it does. Because what do? I mean, for injection wells, what do?
Injection wells?
Yeah, if you inject salt water.
Like a disposal well?
Mm-hmm. And it moves over to somebody else's property, what have you done?
I guess it's an invasion of the state.
Could be a trespass. There's a FPL case that came out of the Beaumont Court of Appeals that talks about that in light of that. The Senate Bill 332 and the Davis.
Right, both those things make your private property. You got some districts like Bandera where they got out ahead of themselves. They issued a bunch of permits.
I know.
And then adopted DFC that's way below the sum total of the permits.
Yeah.
And they got approved, and that's the basis on which we challenged them.
Yeah.
They gave us this permit, and they adopted rules that protect historic use, which was my client. But they adopted this DFC that with the mag that's going to be way below.
Yeah.
So, they upheld it, but the district hasn't gone back to try and implement their mag yet. So
you know who Bob Keir is? He's a groundwater hydrologist here. He's got his PhD, and I've known Bob a long time. he told me one time, and this was 7 or 8 years ago now, he says, legislatures directly or inadvertently designed a system that they knew would not work to allow them to come in and say, it's not working, folks, we got to take over.
I was going to ask you that question. I mean, I think what he's probably needs to happen is a lot of local field. Do you think it's working on the local level, or is that we need some sort of railroad
It's
commission?
not working on a local level. And the other thing is that, okay, so what do you do about, in our little district, we come up with a concept called an area of influence, where if somebody wants to put a well in, we require that our hydrologist goes out and does a calculation, theoretical calculation, looking around, and we limit it to a 5-foot drawdown under normal pump. So if you draw down stuff by 5 feet, you got to notify those people that the application is pending and give them a right to come in. And so far, nobody's come in and said anything about it. We mail them letters. We not only post it on our website, but we mail them letters. So far, nobody's said anything. They're going. Because what they're going to do is they're going to go to the applicant for the well and say, you're taking my water.
Exactly. Then where does all this, do you have a lot of oil and gas exploration around the Eagle Ford down there? So we've got that big exemption.
Yeah, well, we got shallow stuff, and we got the Eagle Ford, and we got the Pine Island under that.
So where does that stuff fit in? I mean, they didn't really account for it in the manual. I think a lot of this just didn't even account for it.
The development board is supposed to give an estimate of the exempt water, but if they estimate it correctly, there's no water left for permits.
That's right. I agree with you 100%. Yeah, because they dumped all the exempt water first, and there's not really anything left. But actually, what? There's so much, you probably know, so much money splashing around down there today. We don't think if the districts were to really look at the exemption and what it's for, you see a lot of people that are not technically qualified.
Well, you're going to, predictions are you're going to start seeing that in the local appraisal districts.
I was wondering why not?
Yeah.
It's private property, right? You sell it, why don't you see the valuation in the property where you acquire it in the EA, or then you can move it around?
And it's not, at that point, it's not ag value either.
That's probably why they haven't done it, because most of them with the water got ag.
Yeah, but on condemnation case, you have to value the water separately from taking a property. Under chapter 21 of property code. So if you're valuing it separately, why can't you value it separately? We're talking water. Well, I found out yesterday we're dealing with a group that wants to produce brackish water from the lake. And I'm wondering what the EAA says about production of salt water from the lake.
There are PPPs that can use to try and loosen that brackish water into protected.
Yeah, I told them that they'd be stupid to go after this. It's a great aquifer. It produces all sorts of water. It's saline. So it's not capable of being used. But they can treat it. No, they're going to treat it. They've got
One of them actually
patented treatment process, they say, under 20,000 feet.
Oh, wow. Reuse some simple stained glass paint. Oh, wow. So is this good? Can we get it back to you? No, it's good. Well, thank you.
I still have to get permits for it.
It's a really, really good thing.
Is it? You want it back, of course. Oh.
That's why it says.
We allowed to take,
Oh, we allowed to accept food.
Of course.
Take a
You want me to give it to Susan when I'm through with it?
Whoever you'd like.
So, your professional. All right, so let me explain my perspective.
Yeah.
Then we can.
Really like
I noticed that's why you brought grab tea.
Yep, green tea. Drink of choice.
I seem to be lacking commissioners.
guess I'll slowly appear.
We set aside. We need to discuss, I don't know, the format of this, take it to 5,000 curies. At least that's it. Not a small quantity.
Okay, I got your message. Yeah, okay. Okay. Okay, well, I got the message. Okay. Okay. Are you, do you want to try to go to the services? Yeah, yeah, it will. So, okay, well, find out more, let me know, and I'll see how my schedule looks. And this is the last week of classes next week. And, you know, I've got graduation stuff coming up, so it just depends on when it is as to whether I could or not. Okay. Okay. Alice was going to call Doug and Sue and let them know we're coming to that. Has she done that yet?
Close. Everyone's getting closer.
Uh-huh. Okay.
Not my volume.
Yeah. Yeah. Who called you? Yeah. Right. Who called you? Uh-huh. Oh, okay. Right. Okay. Okay. Uh-oh, okay. Well, tell him he's got to make it behave. Okay. Well, you know, I'm in Austin. We just had our, So, right, yeah, I think they are. Like I said, okay, well, they'll like that. Okay, all right, okay. Well, that sounds good. I'm just not sure what time. Yeah. Okay. It'll just depend on how late I am.
You're realizing it really is over. I don't think I've ever heard of this one. I don't know. And who was Kristen Iverson? Okay.
And grew up around us. They had a lot of problems.
Okay.
And her experience is she company and the cleanup and the wax cleanup.
Oh, is that the federal facility? Yeah. Okay, I'm trying to, my memory. Oh, was this during World War II?
And they were actually building.
Oh, I see. Gotcha. They're. Twice? So Murphy was there twice, huh? Okay. Oh, thank you, Karen.
Now we got dessert, Judge. Judge, now we got some dessert. Okay, I found them. Hey. No, you got more than I got. Oh, you've been chewing on yours, huh? Well, I chewed on one or two, so.
Dick, is Peter on his way back? No, he's not. I'm using your lid, or maybe it's my lid.
I think it's your lid.
Well, we're waiting for Commissioner Bradford, and our need permission to start without him. That's a gift. There's to be a quiz. All right, we have a full complement of attending commissioners and almost staff people back, so we'll reconvene the meeting almost right on time. But the next agenda item we're going to take up is our agenda item 9, which is the update on issues in progress of the disposal allotment committee. And as we said before, then we'll go back and look at the other applications that for import that we did not consider. And for this one, my committee chair is Ms. Morris, and she'll take over and tell us what she's been doing.
Okay, well, the committee consists of Dick Saudick and Judge Dolgener and myself, and we have frequent input with figures and things from some of the other commissioners, but not during the meeting, of course. But anyway, so we called this committee. I talked to Ms. Ng and tried to figure out what should we name this committee. So we just named it the Disposal Allocation Committee. So the Disposal Allocation Committee conferred with the TCEQ, WCS, and generators to try to determine the most efficient way to utilize, we decided to call it Operational Year 1 Curie allocations. So after discussion, we came up with the following recommendations to the Commission. The first one is non-party state generators with approved import agreements who have not yet shipped their full allocations to WCS will be required to provide the Commission with a shipping schedule for those materials by and then a certain date. We can get input from the generators as to how long about that would take. So we're thinking something like the end of the month, just so we have them in time to evaluate them before our January 25th meeting. So in this shipping report, the generators should state whether or not they're going to be able to complete their entire allocation for operational year 1, and if they also how many curies they expect to have completed by a specified date. And if they were not going to be able to fully use their allotments, the Commission's going to consider reducing their allocation so that can be reassigned. The second recommendation is non-party state generators with applications before the Commission who would be able to, I hesitate to use the word guarantee because that's my understanding after talking with Mr. Baltzer and several other individuals, that it's hard to guarantee, almost impossible to guarantee a shipping date in many cases. But to the best of their ability, non-party state generators with applications before the Commission would be able to come up with a firm date for shipping to WCS within operational year 1, may be conditionally awarded a portion of the freed allocations. We also looked at the small generator set-aside, which is 5,000 curies. We approved earlier today some more curies totals against that 5,000. The bottom line is there appears to be 5,000 appears to be a very generous set-aside, and it's the recommendation of the Disposal Allocation Committee that this set-aside be reduced, and so that we don't leave any empty, unused allocations in the 5,000. So we were looking at 1,000 curies. The set-aside should reduce from 5,000 to 1,000 curies, and we might need some input from Mr. Salzman if that would be appropriate, or any of the small generators, small quantity generators would like to comment on that. That would be appreciated too. So this would also be for this operating year 1. Now, Ms. Ng has spoken with a number of the generators that have large outstanding allocations, and to kind of explain the direction we were moving in, and she has received a positive response from them regarding these particular recommendations. And so the whole bottom line is that we're just attempting to be able to use our full operational year 1 allocation of 220,000 curies, get as close to that as we can, so that we can do everything the legislature essentially asked us to do and provide revenue to the entities that are being paid that money. So that's kind of the basics, those 3 recommendations. And again, the comment, I understand from Mr. Baltzer that one of the big problems has been with a number of the shippers is the limited number of shipping containers available. That's been a major impediment to the shipping a lot of these materials. And you can comment on this later if you'd like to, Mr. Baltzer, that situation is not going to improve until maybe later on this summer. So when there's more shipping containers, I think we'll not see as many problems with getting these allocations in. But at any rate, so that's the report. Those 3 recommendations: non-party generators that have not used their full allocations, reducing some of their allocations. Non-party state generators with applications for the Commission that could ship the materials within this operational year 1 could be awarded some of those free allocations, conditionally awarded, and then finally the small generator set-aside be reduced to 1,000 curies. So if you have any questions, please feel free to ask, and any comments from the other commissioners, any of the generators, Ms. Ng, anybody wants to say something? Yes.
I'm Miguel Azar. I'm the Rad Waste Manager for the Exelon fleet. So that being said, in order for Exelon to fulfill its obligation, I would need you to amend or take up our amended application in January, on January 25th, in order for us to meet that allocation. Since that number was what we requested and what we received, there was no correlation. So now that we are able to kind of balance things out, we'll be able to meet that if our amended application is approved. So that's my request to you in order to meet your requirements.
What requirements are you talking about?
Well, the requirements that was just stated, that if you're going to ship, to ensure that you receive what was approved, the allocations of volume and curies, you want to schedule and you want to ensure that we deliver, which is fine. That's the reasonable thing to ask for. In order to true up the math, you might say, since we were given a number, which was 1,800, the containers don't fall into that numerical 1,800. We're going to need a little bit more volume to kind of balance out the math, because of the physical container size. We can't just cut it. We can't just cut it at 1,800 because the next shipment will put us over. So we couldn't ship that. So that's from a volume perspective. From a curie perspective, packages tend to vary from one package to another. One package can have 50 curies, the next package could have 200 curies, depending what kind of a reactor it came out, the time it's been sitting in storage. So all these things tend to play into that equation. So all we're trying to do is requesting that you review our amended application so that way we can meet those meet what was originally approved. So it's just pretty much kind of balancing out the math.
Okay.
Like if I gave you a nickel and I said, give me back 2.5 cents, you tell me it's not reasonable. I can't cut the nickel. I can give you back 3 cents. I can make change. That's what I'm saying.
I understand. And let me launch into this a little bit if you don't mind. This all started because we became aware after we approved the majority of these import applications on June 29th that some entities that, and it's no secret who it is, it's TVA had a significant portion of the curie content. And for whatever reason, and it's up to them. I mean, these are your management decisions. They did not, or apparently will not ship the curies. So the question comes, okay, if somebody asks us for an import agreement and we grant it to them for specific curie content or a specific volume, what expectation should we have that they will actually ship the amount of curies to the facility that they're asking us to agree to? You're in the business. Tell us.
I have no problems with that. I mean, the expectation you should have is you should have a quarterly true-up. That's what I would do. Every quarter, I would expect them to show up and tell me, reconfirm that they're going to do it, or you go ahead and take action and reduce it.
So are you suggesting that our agreements are too long? They ought to be shortened?
No. What I requested was, personally speaking, for Exelon, what I requested was 6 years. But I requested what the contract value had in it. I didn't, and I realize this is a dynamic process right now. We're all kind of feeling our way through it. So if I'm the landlord and you're the tenant, and you're renting from me, whether it's based on a monthly or a quarterly basis, I would expect us to true up the numbers every now and then, or I would expect to see progress made in that direction.
We can all comment about this, but I'm just asking some questions now because from my perspective, what we've got is a situation where there is we didn't put the limit there on the license. There is an annual limit on the license on out-of-compact curies brought in volume. But we're focused on curies. The first year it's 220,000 curies. And so if somebody comes in and asks us for 100,000 curies and we approve that, what we expect is that they're going to ship 100,000 curies. And if they don't, the next question is, what happens? And there ought to be some mechanism to adjust, but from my perspective, there's got to be some other thing, because you mentioned contracts. We don't know what your contracts are. We don't see those. We don't have any idea what's in them. So we're making our judgments on the basis of an application that the generator submits to us and asks us to act on. And I think from my perspective, and I'm only speaking for me, the expectation is if somebody asks me to do something for a year and says, this is what I'm going to do, we expect them to do that. Now, if trouble comes up, I can understand that. Or if plans change, I can understand that. At that point, again, this is just personal. At that point, it seems to me that they would come into us and say, all of a sudden, our plans have changed, and we're not going to be able to do that, and so we're going to free up a certain amount of capacity that we've previously been granted, so you can be free to give that to somebody else. Is that comport with what you're trying to say?
Yes, that's what I'm trying to say. We work on a 12-week schedule.
Okay.
So in order to plan ahead, I need to understand that I have this allotment, I have these curies, so I can schedule my work, reserve the cash, and get this project going. So if you have to know, you have to lock in all the variables ahead of time so you can execute.
Totally understand.
Right. So yeah, I agree. That's why I'm saying on a quarterly basis there has to be some sort of true-up.
All right. We commit by virtue of our import agreements that we say you can do this. What is the commitment of the generator to us that they will do that?
I would say look at the results. Results speak for themselves. I can be up here telling you yes, 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 and come April 23rd and say, oh, by the way, I'm TVA and here's 100,000 curies back.
We don't want to wait till then, because we don't want to leave any curies on the table.
Right.
So this is actually a step, making this request is a step towards that quarterly or periodic re-evaluation of where we are.
No, it's fine. I fully support it.
And if you're going to use all yours, no problem. Just let us know that.
I am, and I need more.
If I can, and the reason I think this is the point, and if it isn't, please correct me, because I think it's an important one, in addition to what's already been said, is that what you're saying is you go out, you do the best you can to try and predict what your volume and curies is going to be ahead of time when you go in and enter these agreements. You get data back, oops, sure enough, it was a little more volume, a little more curies than you thought. And your point is, which I think is as important, is you have to come in for an amendment to get that, for you to make the first shipment to meet that commitment. And so sometimes the true up of coming in later with an amendment, now that you have exact knowledge, is critical to committing your deal to ship at all. Is that correct or not?
Correct.
Okay.
So what I'm saying, yeah, I need let's call it an enhancement to the already approved curies and volumes to meet the final number. Otherwise, I will be short.
So you need how many more between now and April the 26th?
About approximately 500 curies and approximately another 120 cubic feet.
I don't think volume's a problem.
No, we're bumping against the curie limits, not volume, so really it's curies.
Right, so if you look at what was approved for TVA, which was 150,000, what was approved for Exelon, which is 1,800, which is about 100-fold less, what I'm asking for is a very reasonable number.
Miguel, even more important to me in this instance, where we are in the operational year, is what kind of time do you need, lead time, in order to be able to say, Compact Commission, I need to know by X date in order to be able to meet my commitment for, did you say 500 curies? In order to be able to say I could ship those by the end of April.
On the 25th of January, you have to give me, you have to approve, you don't have to give me, you have to approve in my application, because our shipments are already scheduled to start in February. Otherwise, I will have to kind of divert them.
How far out in advance do you schedule shipments?
I like to operate a minimum of 12 weeks out. Our
Okay.
preference is 3 months. That's the way we operate.
All right.
So, and we've looked at our outage schedules, and we've looked at our resources to make sure we have the resources to execute these shipments, because it takes approximately 18 hours to prep the shipment and about 10 individuals to kind of execute it.
How close is it reasonable for us to get when we estimate curies to be shipped in a calendar year? Is it within 10%? Is it within 20%? You've got a much better feel for this than I do.
The rule of thumb is 1 to 1. 1 cubic foot to 1 curie is the rule of thumb. However, that's not always the reality.
Somebody had several thumbs.
Right. You got to look at the waste stream. You have to look at the source. There's a few variables that play into it, but it's usually 1 to 1.
What I'm trying to understand is if somebody comes in and requests, let's say, 100,000 curies or 50,000 curies, whatever, are they really talking a range from 45 to 55, or what are they talking?
It's hard to say. I mean, I say there's a little fudge factor in there of about 10 to 15% built into it, because it's a science, but it's until you ran the numbers, you won't know perfectly what it is.
Miguel, what if we use your 500 for an example?
I will use my 500 to complete the last, it's kind of funny, like 2.5 shipments, because I'll have to stop at shipment number 14, because I'll have the volume, but I won't have the curies. So that's how the two kind of.
And in your estimating of your 500, did you build in a little fudge factor there to make sure that it was a reasonable request and that is as close as you could have estimated it at this particular point in time?
Yeah, I built in a 25% fudge factor.
Okay.
If you were how would you suggest we deal with the allocation that we've allowed TBA? It seems to me that that's a pretty big chunk, and it may be off by quite a bit.
Well,
and I think we've got a responsibility to make sure, as the chair kind of suggested, that if we have granted petitions, they'll ship in that quantity. I mean, we all know that there's going to be some swing one way or the other, but that's a pretty big number that we've allowed. What would you suggest that we do?
I would suggest you contact them and have them come on over and address you. I mean, I don't know what their
maybe kind of say, listen, we're thinking of cutting you back.
Yeah.
Because you haven't shipped, we don't know what your prospects are. Unless you can give us a much better idea, we want to know.
And you guys want to be first on the list for the new conditional approval?
Yes, I'm ready.
Mr. Chairman, could I clarify one issue with Miguel, and that is, a moment ago you spoke about estimates, and I want to understand, when you're talking about estimates, you're referring to your ability to determine for your allocation request curies and activity and volume. That's where you're talking about estimate. But when you actually make the shipments to WCS, it's no longer an estimation. You actually know the volume. You've actually calculated and measured the activity, correct?
Right. The volume, I can get you down to the 10.
When you make the shipments,
right,
there is no longer an estimation. It's an exact number, correct?
It's an exact number, right.
Okay. That's the point I wanted to clarify.
Yeah. The estimate is the request. Yeah. Correct. Volume is very easy to request. It's the curies that's the variable.
Okay, I see Mr. Foster there, and I'll have to say that this conversation started some weeks ago when Rod called me and said that one of the large generators that we had agreement with was not going to make their schedule. And he said, what can we do to make sure we get close to the 220? And Rod, is that basically it?
Yeah, this is Rod Balser, president of WCS, and since TVA is not here, I did want to defend them somewhat. The concern is they won't use the exact 160,000 Curie estimate. When they went through, they had several radiated hardware shipments and things like that. We've taken some of those, and they came in a little less than expected. TVA is anticipating to ship additional shipments and use some of that Curies, but the concern is, what if that doesn't come to fruition? As we've seen through multiple customers, cask availability is an issue, just shipping schedules in general, because they're typically dealing with on-site service people who are going to load those casks and do other things as well. There's a lot of variability there. And so as we get toward the end of this, I want to make sure if there is, hey, somebody's not going to make a shipment and there's an extra 1,000 Curies, I don't want an extra 1,000 Curies just to lay around and go useless if Exelon or somebody else needs those to complete their shipping requests and schedules and things like that.
What would you suggest?
I like the recommendations that Commissioner Morris laid out. I think getting additional information from the shippers, the generators, obviously we're trying to get that as well. Those schedules will change. They are not carved into stone. Things happen. So there is some variability there. As we talked about, there may be some estimates of how many Curies per shipment there are, but there will be under and over. And so you will see people come back and amend their request. Typically what you've seen to date is people who have under and come back and ask for over. We haven't seen the opposite happen yet. So we do need to get that kind of information. But I think, there was a brief mention about, conditional approvals. Part of that is it does take a while if you do have an amendment or an application to come in, have the comment period run, go through the technical committee and approval process. And if we have some of that done up front so that it can be basically signed out as soon as somebody drops their Curie request, I think that'll speed that process up and help us in the back end so we can provide more notice and allow the shipments to be scheduled in a more timely manner.
I have, as you might expect, all sorts of questions because that's all I do is ask questions.
I am shocked and amazed.
But one of my questions while we're having this discussion is, we've assumed that how hard a limit is the 220,000 Curies? I mean, it says you can't accept more than that the first year, but does that mean you have to assume that you can only agree to take perhaps 25% less than that, or what are we talking about here?
No, so the 220,000 is a hard limit. There is no way to surpass that. It's written into legislation. So if the Compact Commission approved 1 billion Curies and we got shipped to our site 1 billion Curies, we could still only dispose of 220,000 Curies. So the limit is there. It's real. It will not be surpassed. But I don't think that stops the commission from approving more than 220,000.
I don't want to go quite there yet. But my question is, how close will WCS come to 220? I mean, you get a Curie limit on a shipping manifest, don't you? Don't you get Curies?
We do. We get on the manifest. They will list out the Curies.
And so somebody prepares a shipment to you, and you're at 219,000 Curies, and they have 1,232 Curies in the shipment. What are you going to do with it?
It will not be approved.
And so you have to keep a constant running total then.
We do.
Of the number of Curies based upon shipment data.
Correct.
To you, the manifests that are passed to you on how many Curies in that shipment.
Correct.
And so you might have. Okay, so what are we talking about here, Rod? I'm sorry. Are we talking about that we get to the end of this and we're going to play with 20,000 Curies, or we get to the end of this we're going to play with 500 Curies?
I would expect we're closer to the 500 curies. Most of the shipments we receive are resins and things like that, and they've got a couple hundred curies in a shipment. For irradiated hardware, that may be in 10,000, 20,000, 30,000 increment chunks. It is very curie intensive. So, depending how those shipments come about and how much we can replace a lost irradiated hardware with more resins or a different irradiated hardware shipment comes into how close can we get. How close do I want to be? 219, 999.
Well, I understand that. But my other question is, given that there is, as Miguel tells us, a 12-week or 3-month scheduling time, how do we solve this problem of fine-tuning at the end?
Well, and this is, I think, where some of the conditional approvals come in. What would ideally happen is we would have possibly people who are approved for the next year, I'll call it the 2013 year, who could ship in advance and be in storage. And if their lucky day came up and we could dispose of that earlier, then it's put in 2012. If not, then they've already got it approved for 2013, so there's minimal risk coming into storage at WCS. That would help manage that as a surge capacity.
Well, you just raised another issue that I was going to talk about a little later, and that is importation for management, but we're not quite there yet. So the question is, I'm still trying to get an understanding, and I know you are too, because you're just starting in this operation. And we've got all of these rules we have to live with and understand and work our way through. And we're trying to understand from our perspective how to manage import agreements to give you the maximum number that is authorized by the legislature and still do our job in looking at capacity. And we're open to discussions and suggestions about ideas on how to do that.
Yeah, and so, for example, if you had approved 220,000 and you got notice from a generator that they were not going to make that shipping schedule and there was an extra 1,000 curies available, if there were conditional approvals for 2, 3 other generators, we could contact those other generators who were conditionally approved, see which one had the curies that would absorb that 1,000 but not go over that 1,000, see if they were willing to ship, able to ship, could guarantee the shipment in that required time frame, and basically move those curies over. Void, cancel, amend that other one, and final sign out the conditionally approved one, and make that happen to get as close to that 220 as possible. And it is very challenging, and part of it's first year and not knowing exactly what the last couple of months is going to look like, but knowing already that there are scheduling issues, cask issues, a lot of other variabilities, and we do need to sort those out and finalize those so that the planning can happen to give us the best opportunity for this.
Okay, how much variability have you noticed in somebody comes to you and says, I'm planning to ship something that is this volume and have this many curies, and you say that your experience has been that they generally ship more curies than they anticipate to you?
Well, no, I think the statement was the people who are coming to get amendments to their applications have typically been under and need additional approvals from the Compact Commission. I don't think we've seen the vice versa.
And my question is, why do they get these under approvals in the first place? Was that a function of the allocations we did back in June, or is that something else?
Yeah, part of it's just estimation. I mean, you're looking out.
Well, part of it is how you divvied out the allocation. You started out with, I think Philo was first, right? Or John McCormick was first, and then TVA was second.
They were 7 and 8.
Right, but the way the numbers ran was, by the time you hit the second application, you were already almost at 155. So what did that leave for the rest of the generators? Very little.
But part of that also is, it was nice round numbers, and part of that is, we don't know exactly how many shipments that'll be over a 12-month period of time. We estimated this kind of shipments, and maybe it'll squeeze into these kind of time frames. But, it doesn't end in round numbers most of the time, particularly double-digit round numbers.
Yeah. And my question to you is, when somebody says we're going to estimate that we're shipping you, 3,800 curies, and you get the actual shipping document, and does it say 4,200, or does it say 3,300, or can it vary all over the map?
It can definitely vary, I'll say, all over the map. It's usually a tighter band than that, but we have seen some of them that have been, 60% of what we thought they would be. But we also have generators who got curie and volume allocations and may be able to ship more shipments under that same allocation than they were planning to, so they could still use it.
Okay. And I understand that curies is really the limit here that we're working against rather than volume.
Yeah, volume really hasn't been an issue so far.
Yeah.
Well, I was just wondering, do you have a pretty good idea, a ways in advance, what you're going to get, what you're likely to get from a particular shipper? I mean, like, would you know a month before or something?
We do. We do have this scheduled out months in advance. But I'll also tell you, we have shipping notices we provide to TCEQ within, a week or several days of the shipment. And we've had to send them notices that said, never mind, that shipment's not coming after all. So within days, that can change.
Well, it just struck me that maybe as a regular part of our interchange, at least at these meetings, you could give us a kind of an update on what you see. I'm not asking that you kind of undercut your customers, but perhaps if it's clear to you that by discussions with the customers that they're not going to need the amount of permission within that time that they've got, you could tell them. I mean, I kind of can I share this with the commission and so that we're as close as possible to kind of being on target.
No, and I think we've been consistent with our customers and told them that if we don't think they will use their full allocation, we will go back to the Compact Commission and recommend a reduction because we just can't waste it. It's too precious of a resource that's been given to us at this point. And so we're happy to work with you through that process as best we can. Having said that, I don't expect in January that I'm going to have a schedule that's not going to change by the end of April.
Yeah, that's what I'm hearing from you. If you tell TCEQ that we expect this shipment to be made within the next 10 days, and 3 days later you're calling them and saying, oops, it's not going to be made after all, then you've got really short reaction times to replace something with something else.
Yeah, we juggle best we can, but we need as many tools as we can to make sure we can manage that process.
Yeah, I would think that with somebody, where you have 150,000 on the, you can develop probably a pretty good idea of the likelihood that's going to be met and at least an approximation of what the overage or shortfall might be.
Yes, I think we can definitely do that.
I think so. I think in January we will see some free allocation that will be available. And also, Lee and I were talking along with some other people as we get closer and closer to the end of the first year, operational year, we probably need to stay in contact more frequently.
Absolutely.
So that we can fine-tune it as time goes by, that last quarter.
Rod, could you estimate now, back to whatever time frame you want to go to, what WCS had estimated and what actually was disposed of from a curie perspective? Do you have that off the top of your head? Could you?
I was going to say, we could probably get some kind of information back to you next week, but sitting here today, no, I couldn't do that.
Yeah, it would really be good to be able to start tracking what you estimated and then what actually showed up, so we can start some trending and some benchmarking now. So, and that hopefully will help us in the future, that when requests come in for import, we'll be able to hopefully do a better job at as time goes on and we track this appropriately. Thanks.
Mr. Crossan has a couple of questions.
Just one, really. Ron, do you have just a ballpark as to how much there might be to take back at this point? I mean, just a ballpark idea.
I would expect it's probably 10,000 curies, but that is a wild guess. I'll call it a wide range, but I think we'll have enough to take back that you can approve all the import applications in front of you today, and we will not have an issue getting over the 220,000 curies.
I'm sitting here pondering all these things because I'm trying to figure out how to make our system on import agreement work better. And I don't have a lot of good ideas about that yet.
Well, I do think the recommendations of the committee are a good starting point. I think this will be an iterative process, and we'll probably make progress and changes and things, I'm sure, as we get more experience.
Okay, I'm going to assume for a minute that we somehow conditionally approve over 220, and the limit is clearly your limit, not our limit. And so, if we go there, how do we assure ourselves that we live within that limit?
Well, as we stated, that is a legislative limit, so we're required to do that. We also have the TCQ resident inspectors who are double checking our work and keeping track of these things as well.
My question really is, we have conditional agreements then with people that says, so long as there is capacity in the site, you can ship, or some words to that effect. And I don't know what the words would be yet. How do we know that they are authorized to ship?
Well, I think you would know that somebody has given up that volume. So if generator A has said it, we're not going to use 1,000 curies, you would then be able to contact generator B, who was conditionally approved, and say you're now authorized for your 1,000 curies you wanted.
Would you do that?
We'd be happy to do that and facilitate that contact and work through that, because obviously we're contacting the generators A and B of who wants to ship, who can ship, who's supposed to ship, and when is that all happening. So we would be happy to provide recommendations that A be reduced to 1,000, B be granted their conditional approval. And I would expect the commission could unilaterally void or amend generator A's agreement and fully approve the conditional agreement from B.
Okay, I'm just trying to figure out the mechanics of the process in a short time frame.
I think WCS would have the best knowledge available that was piecing together the entire picture. Generator A, B are our disposal limits as well as what's been approved by the Compact Commission.
Okay.
I think this is something that needs to be talked to with Ms. Byrd and the legislature into getting, as we're tweaking this process as we're going to do, is put that in some bill that gives the commission latitude instead of these hard numbers, because next year it's 110. So unless we get that raise, I think you're still going to have 110 year. You may have 300,000 the next year, but unless they change that, but I think there's some, when we're tweaking this, we might could go back and change, when they're tweaking the limits, then we can tweak this. I don't have a problem with you doing that, but I want A and B to come to us and say, we're doing it. I mean, I don't, if it's theirs, it's not yours, so.
Yeah, I was just saying, I think we'll probably have knowledge of who A and B are, so we can recommend they come to the commission or facilitate that process. Right. Obviously, they need to contact you directly to make sure we weren't making things up.
Right. Yeah. But I do think that the legislature could tweak this a little bit not, or at least give us direction on, yeah, you can do 1 billion curies, but they can only take 110. Which I really don't like, because then you, as they say, you've lost it. And I don't like losing it.
Well, the first step, I guess, is go ahead and get that information from the generators and confirm what's going to be available. And at the same time, we could conditionally approve some of these applications or petitions. And like I said, as the curies get freed up, we could do that. Now, we do get a monthly report, do we not, John, from the TCEQ on what actually has been disposed of at the site?
Is that correct?
We get one from the WCS facility once a month, usually in the first 5 days of the month.
Again, I'm focusing on the mechanics of trying to get to this and figure out how to put the pieces together, because the report we get is the total number of curies disposed of. We don't necessarily know which of the generators, do we know which of the generators with whom we have agreements have disposed of it?
Yes, John has a spreadsheet on that.
Actually, I don't know that I do have that. I think I've seen it, but I don't know that I actually have it.
Yeah, you've seen what they submit us, but yeah, that's what they've actually disposed of as opposed to what has been allotted to them through our agreements, which is what Commissioner Salzman has.
Is it a total amount, though, or is it by allocating?
I know it is a total amount. I don't remember if it is by allocee.
We do provide by generator, by import agreement.
By agreement.
Well, I'll say by generator. I'm not sure it's by agreement. By generator.
Okay.
Or broker, as appropriate.
Or broker, as appropriate, yes.
So if I understand what you just said, you keep by generator name, but not necessarily if we have multiple agreements or 2 or 3 agreements with the generator, we wouldn't be able to allocate it to each of those agreements.
The reports right now do not split it out by agreement.
So it looks like we may have a tracking problem.
I was going to say, but I'm sure we can provide that information.
So if a company has like 3 contracts with us, or 3 different approved petition agreements with us, thank you, we would really have, when they give us this information, they're going to have to give it to us for each of those agreements. So
Correct.
we know where we are on each of those agreements as opposed to just that generator or that
Correct.
broker.
May have to bring your big board back, Rod, like Dick was saying, and have these check marks off the 0013, 0014.
Mr. Chairman?
Yes, sir. I'm looking for help.
Concerning Linda's recommendations, one of those was that we reduce the small quantity generator allocation from 5,000 down to 1,000 curies. And in looking at the spreadsheets, I believe we can do that. And even with the applications that are either on today's agenda or that we've received but are not on today's agenda, I believe we could successfully review and approve those and still have some small quantity generator allocation left, so that we could reduce it from 5,000 down to 1,000.
Okay. I'm looking at what Linda has, and there are really 3 steps to it. And you're talking about the 3rd step, which is the reduction down to 1,000 curies, freeing up 4,000 curies. And, you know, the 5,000 curies was an artifact of what we chose to do anyway.
Correct.
So we can.
It's not a rule.
It's not a rule. So we could just do that. And we would do it by granting applications. We just have to keep track of.
I want to change the spreadsheet.
Yes, change the spreadsheet. And then I'm looking at the first 2 statements, which are recommendations in the first one, who have approved import agreements. We know who those are, at least as of before today. So we would write them a letter, I'm assuming, and say, please provide us with a shipping schedule. And would we also ask them to report on how much they have shipped already and for disposal at the WCS site as of the time they respond, so we know how much room they have left? What will we do with that?
I would say yes.
I would say yes too. Yeah, that
I would think we'd have to.
Curies used, curies remaining, or something.
Curies remaining under the agreement, and when you plan to ship the remaining curies.
Don't lie to us.
Don't lie to us.
And then the next sentence is the generators must state whether or not they will be able to complete their allotment for the entire allotment for operational year one. My question about that is, if I were a generator, I'd say, yeah, I'm going to complete it. Of course I'm going to complete it. And
I think, Mr. Chairman, we need to give them a date by the time that they say they need to ship.
Well,
so that there's an opportunity that it can be disposed of within the operational year.
Well, that's the second part of the first sentence,
right.
actually. Yeah. And it says, required to provide the Commission a shipping schedule for those materials to show us what the schedule is, right. And then we'll know whether or not they plan to ship it by that date. We won't have to ask them the next thing.
That's right.
And then, assuming that we send that letter to them and they respond, then the next thing will be that if they don't respond, I guess we will reconsider that agreement, which we can do under our rule at our next meeting, and modify it unilaterally. And
it's not necessary.
What?
Hopefully everyone will just jump to and do it.
Yeah. Yeah. You're an optimist. Then and then the second point is non-party generators with applications before us, who would be able to guarantee shipment within operational year one may be conditionally awarded a portion of the freed allocations. How do we get a generator to guarantee that they will
I couldn't answer by that, because that's difficult to do, but with WCS, they have knowledge of the ability of the shipper to ship, so their confirmation.
Let me turn your mic.
Yeah, I think we would have to have that confirmed with WCS, based upon the best of your knowledge.
Yeah, we would want to be able to get information from the generator that they were able to acquire a cask and the proper shipping approvals and things in a timely manner, and could somewhat confirm those.
Yeah. What is the scheduling of those casks now?
They've been very occupied, and they are difficult to come by, and so you do need to get those well in advance, but I can't tell you exactly how long.
Are we then looking for practical reasons, for the practical reasons you're talking about, perhaps conditionally approving several, and we will not know until the actual shipment occurs which ones are triggered and which ones have valid agreements?
Correct. I would like multiple horses to run the race.
Well, Mr. Chair, Kathy Davis with the Southwest Compact. So I can throw in another item for your operational concept. We have, like today, Thomas Gray and Associates on the agenda for an approval. It's a very small amount of curries. And they have also had several other agreements that they've already brought through because they handle a number of small generators. First of all, I guess one of our shortcomings, it was not explained to the generators that you were on this year program, and I don't know if WCS ever really discussed it, but from talking to Gay Nelson, she did not understand that this most recent application she submitted, she asked for October to October because she was submitting this October
and she thought it would go through till next October. I've contacted her and said, no, this has to be done, everything you're requesting has to be done by this April. She said that would be real tight, she could get it all ready, but then it comes back to WCS and the ability for them to come pick it up for shipment, which could take up to, she implied, 4 months. So if we're already talking about 4 months and she gets it ready, she's already pretty much missed the date. In January, February, March, she might make it by April.
WCS does not do the shipping, but
with the cask and everything to get those shipped to you, the availability.
yeah, we do not arrange the cash shipping, so it's whatever it takes.
Whatever, but she's saying that would take 4 months. So she's concerned she might not even make the timeline now. It's not because she's not ready to send it off. It's the availability to get it to WCS for disposal. And so my smaller generators, I'm not sure if all of them, I can work with Lee. I work with Lee. She's very helpful in contacting the small generators and Thomas Gray to make sure that they understand that they have this April deadline. In January they need to come in, and they'll promise that they want to because they don't want to lose that opportunity. And certainly you want to take that from them. But I think with the shipping is the big issue, and so you're saying by January you want to know, and so really by January they're going to have probably a pretty good idea that they can't get it shipped, and not understanding that 6 months or 8 months ago that they would be forced to look at something that they can't ship. And they, in good faith, they requested the amount.
The problem is a construct of a curie limitation in the first operational year.
Mm-hmm.
And that's not...
The small generators might not really be a big factor to that if they're allotted on a regular basis, and if we could assure them that we're going to have this opportunity for small generators.
But the picture I'm getting in my mind is a picture in a regular commercial process that is not tied to an operational year. It's an ongoing process.
Mm-hmm.
And the question is how to fit that ongoing process into these restrictions that we have built in, not we don't have them, but WCS has built into their license.
Right, and the generators in Southwest Compact really never had to look at that as an issue. They apply for a petition, it's good for a year, and within that year they ship, and there's not, I have to do it before a certain date. They know they have a year, and I think that's why my small generators put in, thinking if I put in October, I have till next October, not understanding that was not an operational year for you.
Well, and the reason for that is most people have shipped to Hansford or Barnwell, and there wasn't a question about operational year, and then
Right.
they had 2 or 3 years lead time to know when access was being cut off, and they wouldn't be able to ship anymore.
Correct.
And that's not what's going on here. We have a site in Texas primarily for Texas and Vermont generated waste, and then for other wastes from non-party states that the legislature put limits on to the license for. So we're trying to figure out how to operate on a basis that is different than what Hansford and Barnwell have, and we're not, obviously we're just starting in this process. We're trying to figure it out, how to make it work, and that's what's going on. And I can think of several answers to the problem, but none of them are specifically available to us right now. And
Well, and I just wanted you to be aware of Thomas Gray thinking they had these different options and had posted this October to October. She'll be happy to resubmit or amend that it would go to April, and with the intention.
I don't think it would be necessary for her to resubmit.
No,
I think
okay.
It's done.
Right.
It's done.
Okay.
I don't like it, but it's done.
Yeah, and
Okay.
I thought we made it abundantly clear when we approved all of these, because I think, John, we had a little run-in
John said April, and we kept 26, and it's in the agreements. And so I'm a little surprised that Thomas Gray didn't either understand it or...
I agree.
Yeah, okay. All right.
I'm not here to...
Yeah, and we tried our best to be able to say that that was the operational year, not necessarily the time that they had made the application, and they had another full year or 2 years to do whatever they wanted to do.
I think as it goes down the food chain to the different departments and operations, and then they've been working in a different fashion all the past years, they make assumptions.
Okay, thank you.
And those that are conditionally approved, I'm speaking just for myself now, but if they can't ship in this first operational year, I'm sure there'd be consideration for there to be at the top of the list for year 2.
Well, and that does bring up a good point, and Studsvik is probably a good example where they've already filed for year 2 just for planning and shipping and all the variables we've talked about. I think it is time to start authorizing some of those so we can get some certainty out there for some of the larger shippers.
So are you going to establish like an open date to start accepting for the next years?
We haven't prevented anybody from...
You're just open to it, and you haven't really stated any specific time that you would accept them? Okay.
Yeah, we probably should, because at one time we set up a January meeting to think that that would be when applications for the next year would start coming in. We were looking at that time, as I recall. That was my recollection, but I could have been imagining it. But in the Studsvik application, but there's nothing to prevent somebody, whether we act on it or not at a particular meeting is a different question. But there's nothing to prevent somebody from saying, now that we've established this operational year concept, that we didn't have that done until June 29th when we had the first series of agreements. And so anybody can apply to us for anything. We'll say yes, no, or we'll put it off and consider it next time, basically.
But you would look in the future of maybe having a set time to open up for the following year? Or
we might do that, or we might leave it up to the generators. If the generator wanted to come in and say, we now know this operational year concept exists, if it's maintained, so there's nothing to prevent somebody from coming in now, I suppose, and applying for the next operational year, beginning in 2014.
So if Thomas Gray has another set of small generators, they would better to ask for a 2013 start operational date. And then
it depends. If they can arrange for quick shipping right now, there's nothing to prevent them from doing it, as far as I can tell.
Except getting it there.
Yeah, but Kathy, we are.
I'm just pushing.
I know you are, and we're feeling our way along, because what we want to do is to make sure that, I think collectively, and I think I can speak, that WCS gets, like I said, he said 220,000 curies, and we want him to have 1 curie less than that, just like he does, for lots of reasons, and all of us want that. And the question is how to manage it to where that comes out that way. That's what we're dealing with. So, any other comments from the commission? Rod?
No, thank you very much.
Kathy?
No, I think the shipping form or the proposal that you've made is positive, and it would help you, and it would help the generators too, to force them to look at their operation and how they're pacing themselves, and maybe quarterly or semi-annually they need to report back to help you have a judgment of how are you going for the year. And the small generators, again, they're going to be a small amount, but I know that they're nervous about getting in, or how to file and how to participate, and they're still learning, like as you see with Qualtech, and they're 118-page application, which they're nowhere near ready to really submit as they did. So hopefully, maybe by January they'll be ready to submit, but even then, I don't know with the issues that they have, certainly from my compact, it might take a little bit longer.
Well, okay. One of the other things, and Mr. Krause just mentioned this in my ear, that we're probably learning is that we might need to modify in the future our agreements to take into account reporting to us, so we have a better idea and understanding then of how we might make adjustments during a year if we stay within that year basis.
Mm-hmm. And to have on your agreement maybe the dates, valid dates. This is good through this time period. So
That's on there.
is it on there?
It's on there.
Shame on Thomas Gray.
It's on there, believe me.
Okay. All right, thank you.
All right. Okay. Yes, ma'am. Quickly, Karen.
This is a quick comment. One of the things that's coming up right now is a situation that probably could have been avoided. And to be quite honest, I feel like a lot of the responsibility here is on the shoulders of WCS. And it seems like at this point in time, they should be able to be telling you more specifically who's not coming through and who is. It's their profit, it's their operation, and their responsibility to maximize it, as opposed to having the commission work, excessively to try to help them get every ounce of radioactivity into the site. And I would also like to suggest, and this is not a new suggestion, but one of the reasons why last January we suggested in the forms that they be more specific is exactly this. If you've got a generator who just has a vague idea of what they want, that's really not good enough. They need to do their homework. They need to get it straight. They should be coming to you, and they should be able to put on their forms what they intend to ship. We're still seeing sloppy paperwork. We're still seeing applications that have Class A, B, and C and don't even say how much of each. They should be able to tell you the radionuclides and the amounts that they anticipate. That may change with shipments. Everybody knows that. We recognize that. But they should be able to give you a better estimate. And if they can't, that's a problem. And that leads to the situation that there is right now. And one of the, I'll wrap up, one of the applications from California actually did that. So obviously it's possible. We would encourage you to look at that in the forms.
Thank you. All right. We have Linda's recommendations. We've been talking about them. And as I said, the small quantity set aside of 5,000 curies, we can take care of that, and we can act on that just by acting to grant additional applications or not. And so we really don't need to do anything other than to.
I think John is saying he would like a number, though.
John, you would like a number down to 1,000?
Just so I can change the spreadsheet.
Okay. You would want to make a motion then to reduce the small quantity set aside to 1,000 curies.
So moved.
Is there a second?
Second.
All right. It's been moved and seconded that we reduce the small quantity generator to 1,000 curies so you can adjust your spreadsheet and help us keep track. All those in favor of the motion say aye. Aye. Any opposed? No opposition. So it's done. Okay. With respect to recommendation number 1, non-party generators with approved import agreements who have not shipped, I think we should send them a letter, and that's my recommendation, that says show us your shipping schedule for those materials by, and we can put a date in there. We can say the end of December or January 15th, I guess, which would be. What do you think, Lee?
Your next meeting is currently slated for January 25th, so I think the 15th may be too late, because my hunch is that once the letters come in, there might be some questions about them, and we would need some time, Audrey and I, to get on the phone and maybe get things more.
First day in January.
First Monday in January. What's the first Monday in January?
Looking it up right now.
Okay.
January the first business day, January 1st.
Yeah.
Oh, that's on a Tuesday.
That's not the first business day. That's a holiday.
So do you want to make it the second day, Mr. Chairman, which is a Wednesday?
Third.
Yeah, the first business day of January is Wednesday, January 2nd.
Or you want to make it 4th for that Friday?
It doesn't matter. Y'all just tell me the date so we can tell Lee to put it in the The 4th?
The 4th,
Okay.
that's Friday.
Okay, we'll do it the 4th. And then we'll require two things. One is the shipping schedule by that date, and we'll also request that they show us how much they've actually shipped for disposal under the agreements that they currently have outstanding with us as of that same date.
I was going to also suggest including what curies they already know they will be shipping and when. So if they have those agreements but merely have not shipped them, they
Okay.
could tell us that. And then if they already know curies they will absolutely not use, they could tell us.
We can do some wording on that.
Yes. And then I do think it's important to show that if they do not respond or respond inadequately, they should be told that they may have a unilateral revision of their agreement terms.
I'll work with Mr. Krausen on that language.
All right. And then the second one, non-party generators with applications before the commission who would be able to guarantee shipment. I don't know how they guarantee shipment, to tell you the truth. And I think maybe somebody smarter than me can figure that out. John?
No, I don't know if it was me or that.
Yeah.
John. That wasn't what I was coming up for.
Okay.
On the small quantity generators, the reduction is just for this coming year.
Yes.
Okay, and we'll revisit it again next year. Okay, just wanted to make sure. Okay, thank you.
I guess I would want clarification. We haven't established what the small quantity generator set aside would be for year 2, 3,
That's
4,
right.
so on. So we've talked about that concept, but there's no number that's been talked about yet.
Okay, thank you.
All right.
Or we could go back to the idea of having a pool of candidates. And then as the allotments open up, someone, WCS, can decide who's ready to go and take those.
Yeah, that gets into the priorities and agreements and agreement forms and agreement language that I'm trying to do the best if we can to stay away from, because we're coming back to, we need some time, I think, to work on language that we would insert in. We can certainly today come up with a concept if we need to on some of these applications for import, but in a motion, but we need to work on the agreements. So basically what we do then is just we'll continue to consider then, I think, non-party state generators who submit applications to us to see whether or not we would enter into agreements with them on some terms up against the 220,000 curie limit. That's the way I think it would work. We can act on today's agreements, go back and act on them to the extent we don't exceed the 220. We could technically, if we want to consider it, put in conditional language.
John, if the commission votes today to approve all those that are on the table except student fix for next year, you don't exceed 220, do you? Or you don't exceed 215?
Yes, we approved Studsvik's application for this year. That would put us in excess of the 219,000 curies.
It would.
Yes. So my recommendation, if I made one, would be that we give them conditional approval.
Gotcha.
Okay.
All right. All right. What else do we need to talk about on the update on issues and progress of disposal allotment committee? Do we need to consider anything, or are we straight on what we're going to do?
I have one question that's bothering me. How did Barnwell take care of this?
You really want to know?
Well, I'm sitting here thinking,
They
and
don't have the operational year problem. They didn't have.
I don't know, but that could be taken care of by the legislature.
Yeah.
Because all of this is tending on how much money this commission has to operate on also. So all this is fixing to hit us in May when the legislature's here in July, January. And I'm just trying to figure out how Barnwell, because I know it was tied to their school stuff, but how did they quickly, I guess.
No, I was trying to avoid ever telling you this. They get some size in the back of the room, I know. Towards the end, if you wanted allocation, you had to prepay for your allocation. And if you didn't use your allocation, you lost your allocation. So it was pay or play, you know, you lost it. And that was the incentive to make sure you shipped in to that site. And, you know, you see me, I've got 100 and some different generators, okay? I prepaid all that money for that volume and that activity, okay? Now, if somebody jumped out of there, I had to find somebody to replace it. But I prepaid for that volume. The thing that it did to the small generators is a lot of small generators got locked out because the big boys bought it all up. But the only way you're ever going to make sure that you get to the penny to the dollar to the cubic foot to Curie is a prepay system. And if you're going to do that, please make sure there's something for the small quantity generators.
You're not telling me something that I had not figured out on my own. So but that's out of our control, right. And it's not here yet. I'll say that.
That answers your question.
Thank you.
Thank you.
All right.
Sounds like WCS might go along with it.
I just don't want to be sitting where they're at with all those guys up here wanting to know why we're not getting the money. Because they gave us rules to get the money.
All right. Are we squared away on item number 9 on our agenda? Is there anything else that we need to talk about at this time?
So we have 4,000 curies that we can do something with today.
Roughly. Okay. That takes us back then to the items we deferred earlier, right before we started talking about all this, and we voted on Perkin-Elmer, as I recall. So that leads item 8D, which is the Studvik application for the Irwin facility, and this is the one for 457 curies expiring the April 26th of 2013.
That's for 4,457.
4,000, yeah, that's right. That's that one. Okay. You heard the report earlier. Here's Joseph.
Right. Hi again, Joe DiCamillo. Good afternoon now. Based on your comments, maybe we could make this quick. Mr. Salzman, you suggested that we do a conditional. I guess from our perspective, we would prefer to get some, since there is clearly some remaining curies that are unaccounted for, if you will, available. We'd like the commission to consider allotting some of those available curies to us and taking a conditional amount on others. My view would be we take as much as we could get that are unallotted, and if there's an overage, we would go conditional on that. If that would be that would be our proposal.
And Rod Balzer, WCS, I'm confident that in January, when you get the information from the other generators, there will be an excess available. So I don't think there's any risk with approving the entire allotment as a final instead of conditional on this one.
We're speechless.
Now that is a first for the commission.
Ron, are there likely, do you know whether there are likely to be a number of new applications in January?
There's probably going to be new applications I would expect for the next import year, but I'm not aware of a whole lot of applications for this current year. No, I think we're getting toward the end.
I'm just asking, you're probably looking at the tail end of the applications for this operating year.
And earlier you told us how many curies were you playing with that you think that you...
I said 10. I think that's probably closer to 20 at this point. I got an email meanwhile. As I said, there is some variability.
Somebody was watching.
So instead of 10,000, you think it's 20,000?
Yes, so I think we would have plenty to finalize this as a final instead of conditional. And I know Miguel had said Exelon needed additional curies. It sounds like that may be something considered in January or if not earlier, but again, I think we'll have plenty for those as well.
I'm sorry, but I'm lost. We just spent an hour and a quarter trying to figure out how to get more accurate on this and how to pin down if we give a certain number of curies or volume, whether that's going to happen. And now, exactly what are you asking for?
So we have our first application, which relates to this, what I'll call import year, which is up until April of 2013. We're asking for 4,400 curies, roughly, I think is the number. And I think that in light of your decision to reduce the amount of small generator allotment to 1,000 curies, we're very close to being able to grant the import application for 4,472 curies or whatever it is, 4,457, with curies that are still within the 220,000 cap, and taking into account the 1,000 curies you've allotted for small generators. I don't know exactly what the math is, but it's very close. So
John Saltzman, I think, would tell us what the math is.
If we approve the entire 4,457, that would put us at 219,724 total curies. That's large quantity and small quantity generators. It would put us over the 219, but we would still be under the 220 hard cap.
So we've got less than 300. We've got 275 curies to play with, is what you're telling us.
So you'd be stealing small quantity.
Right.
And the judge asked a good question, which was, what about Studsvik's second document before us? That is for operational year 2, so approval or disapproval would not be towards the 220, and then the Thomas Gray application could still be approved because it's only for 15 cubic feet and 0.3 curies. 3/10 of 1 curie.
But at that point, we're essentially out of curies.
We only would have curies left for small quantity generators.
And only if they came in at less. My calculation is we'd have
a few curies left.
But for clarity, from our perspective, we're not asking the Commission to erode further the small quantity generator allotment. My proposal was we'll take whatever large quantity curies are available, and we'll agree that, and we'll take a contingent allotment for whatever the difference is. So I think we're 700 curies here that we would have to take. If I'm looking at this right, 219 is the cap for large quantity generators. So it would be, we're over by 724 curies in our request. So we would take a conditional allotment. I mean, in where we are at the moment, we would take a conditional allotment on the 724 curies.
So the Studsvik, right now, you're saying that you're willing to accept a firm agreement that takes you up our total agreement allotted curies for large quantity generators to 219, and contingent on anything over 219 to use up because we have the 1,000 curie small quantity. That's what you're willing to do?
That's right. I mean, we certainly don't want to. We don't want to infringe at all on the small quantity generator allotment.
Okay. Thanks, Chris.
Did I clarify that at all?
Yes. Yeah.
Okay.
I I
think
understand
I
now
know.
what you're asking for, yeah.
All right. Any more questions from any of the commissioners? We're considering the Stoogesville processing application 1-0019-00. And we've had a lot of discussion on it. Are we ready for a motion?
I move that we approve the Stoogesville application for 722 cubic feet for 4,300 curies, 4,300 curies. For 5,143 millicuries of C14, 133,886 microcuries of technetium-99, and 22,457,143 nanocuries of I-129. That approval would be through April 26th, 2013, from waste from the state of Tennessee, Class A, Class B, and Class C, solid metal oxides, etc. That waste is in a stable form. I would also recommend that we give a contingent approval on another 157 curies, subject to release of curies by other generators.
Is that your motion?
That's my motion.
Is there a second? There's a motion and a second. Is there any other discussion among any of the members of the commission? And of course, we'll have to write up the agreement to appropriate language on the contingency portion of it. And so you'll see that clause added into the language, I'm sure. And any other questions? All right, I'll call for a vote. All those in favor of the motion to approve the Stoogesville application 0019 as stated in the motion, please say aye.
Aye.
Any opposed? There's no opposition. It is approved. So that takes us up to the 219,000 curies plus the small quantity.
Actually, technically, that takes us to just a little under 219, but
okay, it's close enough.
It's close.
Rounding errors are fine.
It's
okay. Very good. And that one's approved, and we'll write it up and send it out. Joe?
Okay.
Okay.
Thank you. Yep.
Yeah.
Mr. Cross and I will, I'm sure, interchange on the contingent approval language.
I'm sure you will.
I'm sure it'll be all fine.
Yeah.
No, you'll accept the first draft.
All right.
I always try to, Jim.
All right. The next item on the agenda, and Carol, I'm going to take this up first, and then is the Thomas Gray and Associates. This is the item number 0021-00. And
so, Mr. Chairman, we'll defer number 20 until after Thomas Gray. Is that how you want to do it?
Yes.
Very good. Thank you.
We're dealing with the first operational year.
Mr. Chairman, I make a motion that we approve the Thomas Gray import application under the small quantity generator set aside for 15 cubic feet, 0.3 curies. The waste is coming from California, Kansas, and Maryland. It's sealed sources, Class B and Class C. It's stable. And as a part of that request would include 0.001 millicuries of C14 and 0.243 nanocuries of I-129. That approval would be for a period of today through April 26th, 2013.
All right. Is that
That's
your
my
motion?
motion.
You've heard the motion. Is there a second?
Second.
There's a motion and a second. 1, 2, 3. Okay. Is there any further discussion among the members of the commission? All right. Hearing no discussion, all those in favor of the motion say aye.
Aye.
Any opposed? The motion is approved. Now we'll come back to E, which is 8E, which is the last one of the applications for importation, and this is the Steedvik Processing Irwin Facility application for the second operational year. And the agreement with terms would begin April 27th, 2013, and go through April 26th, 2014, my understanding is. Is that correct?
That's correct. That's what's April 27, 2013 through April 26, 2014 was the request.
Okay.
You had two questions pending, Mr. Chairman, I think I remember, prior to lunch.
Yes.
So the first one, I think, related to the timing of the application.
Mm-hmm.
Clearly, part of our motivation for filing it now is that because we are in constant operation, we're always running 24/7, 365. We have shipments coming in all the time. We have shipments coming out all the time. It's very difficult for us to project on a short-term basis so that we can manage curies on site, our holding tanks, et cetera, from an operational and license compliance perspective. So knowing that April's coming, and we're looking at, really effectively 4 to 5 months out, we thought it was prudent for us to file now so that we have operational clarity after the end of April.
Okay.
And clearly, if there were some delay or change in the application, that would require us to make other operational decisions. As Mr. Azar talked about, utilities like to plan optimally 90 days, but some are longer. We're already scheduling shipments incoming and outgoing, after April. So it's important from an operational plan perspective that we try to resolve or get clarity on the next import year as soon as we can. As to allotment, we've got a dozen years of operation under our belt. We take a lot of time and effort in planning. So I'm not going to say you're not going to see me again for the next import year, but we've tried our best to estimate, based on our operational history, what allocation we're going to require.
In terms of quantity of curies or in radioisotopes or both?
Across the board.
Okay. All right. The only question that I have is we're in the second operational year, we're down to 120,000 curies.
Right.
And so we're starting out, and you're going to take the first however many there are, 5,000, and so
13,000.
13,000.
Correct.
13,000 off.
Right.
So you're taking almost 10%.
Mr. Chairman, I'm very reluctant to support it because I just think we've been going through a whole discussion of the uncertainties here, and I don't know how far ahead you say that you plan 5 months ahead, 6 months ahead, 7 months ahead, whatever. You're asking to tie up more than a tenth, about 12% of the radioactivity for next year, and not a huge amount of the volume, but some volume. And I just think we ought to, by the January meeting, it would seem to me, with all that we've gone over this this meeting, by the January meeting, we should have a much better idea of who's going to come through on these things and so on, and still have enough, it sounds to me at least, like enough lead time to be able to address these petitions with enough lead time for you people to do what you have to do. But what worries me is that the January meeting is going to be spent allocating for next year. We're going to get a whole bunch of petitions. People are going to come in and they're going to say, okay, they've reserved 10% or 12% or something, and we're going to have to start getting our foot in the door, kind of the way I guess TVA did this year. And when we're talking about all the uncertainties here, I guess my gut tells me that I don't know enough perhaps about the way this business works yet, but my gut tells me that we should be careful about biting off chunks for next year unless there's some very good reasons to do so.
John?
Dick, I would just say I share your concerns.
Well, that's a relief.
So this would be your only request for the operational year 2? So you're saying you need about 13,000?
Right. We have done some.
Okay, so that's an annual. There won't be multiple petitions to.
As I said, right. I mean, it's not our plan. We've done a plan for operational year 2, and we think we're asking for what we need because we're frankly assuming that we're not going to get more than one bite at the apple because we know that there's less curies and we know what we need. I mean,
what would happen? You've got projects out there. I mean, you've got people lined up and talking to you about bringing stuff in. If you process this material and you don't ship it to WCS, what happens to it?
Well, there'll be fairly quickly. We'll have to stop accepting shipments. We have a small site, and we're curie constrained on our site.
Yeah, I've been to your site. I know
Right.
what it looks like. But so this affects. Are you telling us? Do you have any other outlet for your material that you process?
Not with respect to BC. I mean, and to your point, Commissioner Sadek, I understand the issue. I guess my response is somebody had to be first, right?
I don't blame you.
Sure, I understand.
I think it's a good business practice to try to get it to be first in line. I don't have a problem with that. What I have a problem with is that everything has seemed so squishy right now in terms of what the likelihood is that people are going to be shipping. We may be reconfiguring this quite a bit even before the end of this year, and I'm just reluctant to get into next year without some idea of how this year is going to go.
Mr. Chairman, would Studsvik have the ability, if there are curies that are left over in the first operational year, would Studsvik have any ability to ship waste in addition to what you've already requested, additional waste this operational year?
Hard question to answer. I mean, I think it depends. I'd have to check with my operational people about how close we would be in time to be able to create a shipment close to the April deadline. I just couldn't answer the question.
Fair enough.
One of the reasons for my question is I'm aware that you have previously shipped material to WCS for storage.
Correct.
And that was why I asked the question of what would happen to this material if you processed it and couldn't put it in the site under an import agreement with us.
Well, I mean, we can talk about that, but I mean, I think that if there would be any storage at WCS, it would contemplate that there would be a disposal path for it at WCS. And if we didn't have allocation from import, if it were an unknown, from a business risk perspective, if we didn't have allocation for import for disposal, it would not be a palatable risk for us to store indefinitely at WCS.
Or you'll have to forgive me, but wasn't that what happened?
It was, but there was a different dice roll at that time, right? The site was not open, right? There was no other alternative, and so I understand your point, but I think it's a little bit different now because we have a site that can take it.
Well, I hope it's different now.
Yes.
Okay.
And this is Rod Balcher. I thought I'd come and put Joe on the spot and
Sure.
see if he would be willing to, instead of do a full year, go through August 31st or some shorter period, and take a smaller allocation. That at least gives him some certainty for year two, without, I think, some of the concerns of the commission of a larger curie allotment at this point in time, and he would have to come back again, but we could probably get him to do that.
In January? I'm sorry, I'm being silly. I didn't mean to be facetious, but at some point, clearly before that time. I mean, I don't want to horse trade with myself, so I'll entertain whatever the commission would like to suggest. I mean, we're.
Mr. Lee.
Dick and John, do y'all have any ideas in your mind about when it is you would like to take up second year of operation at the site? When do you think
would
would
be
be good?
that January is going to be kind of a watershed meeting. I mean, on the one hand, we'll probably be firming up pretty much what's going to come in by April 26th of the amounts that we've allotted, and it wouldn't bother me. I think, assuming that we have a pretty firm idea of that, then to look into next year. I mean, I certainly appreciate that these people need lead time, no question, and that they want to. But I'm a little bit concerned, as I say, with the floodgates. I mean, yes, we have one request now, but it could leapfrog pretty fast. It seemed to me once people feel we're going into next year, it's like to get a better idea of this year.
Okay.
And it would be too bad if we had approved a lot of them and then they didn't come to pass, and then we just kind of trying to.
John, how about you? Same way?
I would feel more comfortable in January. I think Dick is correct. I think we're going to learn a lot between now and the January meeting. I have a feeling that at least a couple of generators who've received allocation are going to be forthcoming about their shipping schedules and their ability to get material in the door by April. So
the reason I ask is I think that as a commission, we should be willing to encourage the business practice of prudent planning, and the earlier the better, for all concerned, I believe, based on this first year of operation that we got. So I definitely would want to look at the ones as soon as possible, where it made sense, where the generator broker had some history of planning well, and then executing that plan appropriately, and not take a look at the ones who came in early for our first operational year and then didn't execute very well.
And I think using that information, I think the information we will receive between now and January may very well help us to do that. I would say on Studsvik's part, they've indicated they could ship, and to the best of our knowledge, they have done so. And so I think, to their credit, they've done that, and I think their requests are timely from the perspective of developing a good business practice. So I very much appreciate that.
We may reach a time where we're scheduling 6 months in advance, the next year, or something like that. But it just seemed to me.
I've got a question for Rod, WCS. I don't know what your business planning horizon is, and I don't know how what we're talking about impacts what your planning is and what you know of your contract solicitations. I also don't know if there is this big allocation to TVA, let's say, and they haven't shipped. Are they going to load all that material into the next operational year for you?
Yeah, it won't fit all in the next operational year, so it is a zero-sum game, so to speak, on some of this. If you lose it, we may not be able to reaccommodate that in the next year. and I'm sure we'll have comments on many of the applications that come in front of you.
Yeah, I don't know enough about what you're doing to be able to make a judgment about how this might impact your ability to get business and dispose of material up to the limits that the current legislation puts on your license. Yeah. And so that's what I'm thinking about, and anything you can offer us to help you with that,
And I won't have the right numbers off the top of my head, but I'll say a smaller portion of the 120,000 curies that were allowed for next year would be taken over by resins and materials such as this from particularly large quantity generators. Similar to this year, a lot of the curies would be irradiated hardware. That's more difficult to predict, and the schedules for that are a longer time horizon and planning. We do think we have customers that are in the queue to take curies for irradiated hardware and things, and we'll fully utilize that again next year. But we did not intend any kind of, I'll say, rollover from this year to next year. Those would basically be lost and just try to fit in the grooves when other shipments could not be made.
Okay.
But from a business perspective, state revenue perspective, the resins and things like that we can take, the better everything is.
Yeah. I'm worried about curies because I just didn't know. I knew if some of those shipments were delayed, they were probably irradiated hardware, and if they came in, they'd have really high curie content, and so then you might not be able to take anything else.
Yes, but again, if they were scheduled for 20, the first operational year didn't make it, they may not be available, would not be available in year 2.
Okay. All right.
We just had other plans for that waste. You do not have applications in front of you, but we have been talking to customers about commitments and shipping schedules and things like that through the complete calendar year of 2013. And so we anticipate that the entire 120,000 is going to be used by a variety of people. And we do need to get applications in and get those in front of you relatively soon.
First year, if somebody drops off this year, they're not going to be able to go next year.
Yeah, there is no rollover. I mean, we don't get the 220,000 if we only use 200. We don't get an extra 20,000 next year. So if you plan to use that 20,000 in year 1 and you didn't, it's not available in year 2. We lose 100,000 curies. I just don't have it available.
I see that. I'm just saying, if we approve, I thought you said if we approve the contract and they didn't get it in, then
they're left out in the cold.
So how does that leave legally for us?
Seems to me we're fine because our agreements are set to expire April 26, 2013.
Right. That's right. It takes care of itself.
Right.
Yeah, it does.
Okay. John?
I would make a motion that we defer this Studsvik application for the second operational year till the January meeting.
I'll second.
Okay. It's been a motion to defer this application on Studsvik till the January meeting, and that means more or less we're going to have a January meeting. But and there's a motion and a second. Is there any discussion about this at this time? Hearing no discussion, I'll call for a vote. All those in favor of the motion say aye.
Aye.
The motion, any noes? Okay, the motion passes. Thank you.
Thank you.
We'll see you again in January. One of the things that I want to ask the commissioners perhaps we should do is to publish to the world that we expect anybody that wants to have applications considered for the second operational year, they need to get them in. And what do we want to have them all in January? Or when do we want to have them in? As soon as possible, as soon as the people want to submit them to us, but why don't, it seems to me like what we should say is we're ready to consider applications for, and that would mean to consider them at the January meeting for import agreements. They would have to be submitted in December.
One voice on the technical committee would like to see those applications submitted so that they could, for all those that chose to send one, that we could consider them in total at the January meeting.
Yeah.
That would make it easier from my perspective.
So I think we ought to, I think that's something we can do, is tell the world that we have deferred an application for the second operational year, and that anybody else who wants to submit applications for the second operational year, we're going to consider the first one in January at our January meeting. And so if there are other people considering them, they should get them in by the end of December so we can post notice as required under our rule for comment, and then consider them at the January meeting. Yes, sir.
Hopefully with one caveat that I would suggest is I would hate to have them just plan it to have a holding slot without appropriate planning, looking into business risk and everything associated with it. I think we'll get a flood of say, well, we better go hold a place and we'll suffer the consequences. So some kind of language we could put in, I would hope, that would say that's been appropriately planned and that it's the intent of the applicant to be able to shoot on that particular operational year.
Furthermore, another important complexity with this is that given we have a policy that we allow any application that comes in the end of the month to be considered the first business day if it lands on a holiday or a weekend, that would mean that we would potentially get applications through close of business January 2nd.
Yes.
Which means by the time the comment period closed, it would be after the January meeting.
Interesting. Well, we could always defer the January meeting to a later date. Take that into account. Yeah, but
maybe a meeting in early February rather than January.
Yeah. But we may have to reschedule. But thank you for bringing that to our attention. It's true that we have this policy of saying that if application is deemed received, it's supposed to be received by the end of a month, and it's deemed received on the first business day. And we have in the past interpreted that to mean the first business day after a weekend, or deemed received. Basically, we extended the month in one instance to accommodate somebody just by an interpretation. So it may mean that we may be talking about moving the meeting date for the January meeting, which would put us into a conflict schedule perhaps with the legislative committee meetings.
That's the last item on the agenda is your future meetings.
Yes, I know. Okay, but I think we do need to get the word out that we would consider that we are going to consider at least one application for the second operational year and invite anybody else. And Mr. Lee, the question that you raised about stakeholders and placeholders, we've got nothing in our rules now.
I get it.
To prevent that from happening. And it's one of those interesting things that I won't bother you with the details of where my mind goes when I worry about these things. But it's absolutely true that the only way to prevent that is to make sure that people pay a price. And I don't know how to accomplish that given where we are and who we are. Right. And but there has to be a way for us to address that issue, or you're right, we will get applications for 800,000 curies for our 120,000 curie limit. Right. And we would be forced then into evaluating those, and I don't know what to do about that at this time because we have to live within our own system. So.
I just assume now, Mr. Chairman, we can make that request in the communication that we do.
I would
and ask for that and evaluate it as we assess it as we get them.
I would suspect that we would request that information, and I suspect that the WCS, as they did back in June, would provide input to us when we're making the decisions about which ones are most likely to be shipped during the second operational year. Because that's the way we worked it out this year, as I recall.
Post something on the website.
Yeah, we can do that too, that we're inviting, but to me, it's very difficult to figure out how the generators will know that when it's so difficult for them to, obviously, to know what happens this year, where we learned a lot this year from what didn't happen. Okay. All right. Any other comments from any of the commissioners? All right, we're going to, that takes care finally of item 8, and we've done item 9, and we're going to take a short break before we go to the next great issue was update on issues and progress of the export committee and then consideration of exportation agreements. Everybody agree we need to take a break? I need to take a break.
Yes, sir.
We will still be having public comment on 8.
Ma'am?
We were seeking public comment on number 8.
You can tell us what you were going to say. I'm sorry.
Thank you. I held off on these comments earlier today, trying to respect your agenda, and I'll try really hard to make this brief, but I want to address with you something that I had hoped to address before you voted on the import applications today. And not on the agenda today is a report about water at the compact waste facility. In my written comments, there is extensive write-up about new data that I'm guessing you have not seen before. This was submitted on the 28th, and I want to bring it to your attention. We looked at the monthly water reports, and the September report states that water levels in the 302 wells installed in the OAG are currently measured on a monthly basis. Of the 302 wells, 214 are currently dry, unsaturated, and 88 have measurable water levels above the top of the red beds. They're saturated. One well showed an increase of 1.22 feet in July to August. There's speculation that that was from some clean potable water from tanks, but that data is inconclusive. It's based on the fact that there was some chlorine present. There are also other wells of concern. Let me find this one here for just a moment. 1 second.
May I ask, while you're looking at your notes, is this something that the TCEQ doesn't address?
The TCEQ has these monthly reports. That's where we obtain them. But what's not happening is that this information is not making it to you.
And there's a reason for that, is we have no licensing power over this site, and the groundwater protection standards by Texas law are set by TCEQ, not by us.
However, I am requesting that you hold off on further approvals of applications until the site can be officially certified as dry. And I'd like to point out that you've had previously from Mr. McGuire reports, but they are not giving you the kind of data that I found in the monthly reports and have provided to you in writing. And they are not telling you that, for example, you've heard Mr. McGuire come up and say that the water that's being pumped is a small amount, kind of like a ground hose and so on. But what was not said is that that water between November 2011 and September 28th of this year added up to 28,000 some gallons. That's like, think of a 31 by 31 foot square swimming pool, 4 feet deep. That's a lot of water. They did not in the monthly report say how long they have to keep pumping. They did not have any analysis of how well the pumping was doing or how much is expected to, if any, to accumulate in the future. So this is important information. I understand that you don't do the licensing. However, you are charged with public protection of health and safety, not just getting as much radioactive waste in the ground as possible. And therefore, I urge you to look over this carefully, to get Mr. McGuire in here more detailed. Every time he comes in, he tells you things like, we're monitoring it, it's fine. That is not adequate. There is a state law issue. They do need to meet state law and state code. That needs to be looked at carefully by you. You need to assure it before you can say that this waste can safely be stored at the site. Some of the wells showing water are within the compact waste facility boundary. They're in the buffer zone. Some of the wells showing waste or water are down from that. And one reference was to a filtration pond being a source. Well, why is that happening? This site
What do you want us to do?
This site is supposed to be dry. My recommendations are as follows. One second. I'm going to find those in writing. First of all, first and foremost, I think that you should insist on having full reporting from TCEQ. It's not on the agenda this time. It has been in the past. And simple comments that we're monitoring it are inadequate. I'd like for you to insist on presentations of the monthly water data and a thorough explanation. I'd like you to ask TCEQ exactly what the permit requirements are regarding the site being dry. Request that exact language. Request an independent third-party analysis or audit, possibly by a hydrogeologist, and halt approvals of waste imports until the analysis is completed. I don't think that further waste should be going to the site until it can be proven to be dry in terms of health and safety.
TCEQ says to us the place is a mess. It's the bad water all over the place or whatever, and so on. That's TCEQ's problem.
We don't supervise them. And
No.
I assume, Ms. Haddon, that you have taken this up with TCEQ.
No, I have not actually.
Well, would you please start there?
Well, and I do think that, we've started by getting the water reports, but I think that you as a commission need to have that provided to you because part of your purview is protection of health and safety. And so this is something that you should be looking at even if they make the final decisions.
The compact says that the state has to provide a site, and the state has chosen to do that in a particular manner. And the particular manner that they have chosen to do that is this public-private partnership with WCS, and the licensing entity is TCEQ, and they have those responsibilities. We have to depend upon them to live up to their responsibilities, and we are going to do that. Okay?
And do you anticipate that TCEQ will come to you and say you should no longer import because there's water? Do you anticipate that they would?
I don't have a clue. All I know is we are concerned with what we are concerned with, and TCEQ is concerned with the licensing of the site.
I would urge you to consider the safety of the site and the safety of health in Texans as part of your purview and part of your concern. Thank you.
Thank you.
Can we go now?
We could take a break now for about 15 minutes, I hope.
I think you can shut it down. Wait a minute. You got nothing to do with exports, right? That's my point, right? So you got nothing to do with that. Yeah, I think you can shut her down. I think you can.
Yeah.
Be careful.
You read my mind.
I'm just having a
Another
Sure.
Some people, rate, got it going on.
No, you rate, I don't rate.
There's a, we talk. There's
You got some blue?
That one.
Then it says, all recorded
Okay, I'll shut up. Yeah. Guess what, Art? I don't rate. Right there.
Not even Lay's.
You want something to drink? I'm gonna go get some.
I'll have a Coors.
Option B.
Some coffee.
Let's go. Come on. Mr. Chairman, you want something?
I think I'm okay.
I'll get you something. You just tell me.
If I have another cup of coffee, give me a small cup of coffee.
Small cup, black?
Black.
Black coffee, okay. All right, come on.
So in this, we'll put in the future, we'll put in reporting.
I'll speak into the mics. I have been told. You can be heard, I'm sure.
I can't be heard.
Yeah, I've heard some of the hundreds exotic and the judge will not be heard.
Oh, they can't. I can, they can't.
Well, I don't know, she didn't know who said your name.
Oh, okay.
How are you?
My classroom voice. I used to be shy.
You claimed to be shy.
Number 18. And and the water report, I actually read the water report and looked at the graphs.
And she submitted more comments to us at 9:19 this morning.
Okay.
Yes.
Yes, but I was already sitting in that chair when I saw him come up, so y'all don't have those. At 9:19 a.m., so y'all don't have those.
I do.
Yeah, if you can access them on your internet, you want to read them. That's the only way you will. I did not pass them out. They're not in the notes. I don't have those. No, thank you. I appreciate you asking. I'm in good shape. I'm in good shape.
So Jim can come up with the proper wording for the agreement, make sure it's legal. Okay, but she and I can write the letter and run it by you and Jim. How long does it take to get back to Houston?
I must compliment you on your patience and tolerance. I fully understand that.
They're entitled to speak their piece. And I get a little shorter with her now.
Just about.
But
You got why the game?
You go to TC.
Yep. Yeah, lifelong dollar here.
Yeah, TCEQ, like she said, if somebody said TCEQ, said that they were a mess, right? Like Dick said, well, we probably wouldn't allow any more shipments to go until they're straightened out. Yeah, so we can't do their job and our job too. Remember, we don't get paid. Has it been raining in Houston or not?
Off and on.
We
Of course, I
haven't
live
seen
down
rain.
on Clear Lake, so,
Okay.
so we get a little different weather than Houston.
And my sister lives near Katy, close to the loop.
Chairman, have you,
North Central Texas.
I wasn't sure what the weather would be like up here. Charlie was up here yesterday, and he said it was kind of cloudy.
Yeah, well, it actually drizzled on me driving here this morning, but it didn't rain. Just fog, heavy fog drizzle.
Right. Hopefully mine will be a great deal easier.
I don't know, they may or may not know. You could ask them, I don't think they'll know. Barring that, so, the Capitol all right? Yeah, if you walk out the Capitol, the first main Bridge Street is 15th Street. It's been on 15th Street, but I would walk on 15th back. The first cab stand is Bridge Water, go to 15th, and go about a block and a half left. They have a cab stand there. If they don't have a cab waiting, they can use one at the end. And so, I don't know if you see more of the 15th and go over to the side, but they have the cab cross, where I think it's a little bit long places. And just right on the I would do that. I would go to the west side of the cab and meander your way over to Guadalupe and 15th, and you will see a guest quarters there. It's in between Guadalupe and Guadalupe. One way south, right in between there is Echo Johnny's guest quarters. There may be a closer place right now. Yeah, it's not too long. Don't walk all the way down right there. It was this morning. Yeah, I'm always
Three hours.
It was really good to see if the next agenda, whatever that might be, either here one of ours or yeah, I knew that was the next morning. Whatever that was in Las Vegas. All right, well, you take care. Thank you.
Well, how are you doing?
Very good. How are you? It's good to see you again. Yeah. So are you here for item 12 this way? Yeah, the lady who's going to be representing the AM, she's
We're making it through slowly but surely. Although I think we could go a little faster.
Yeah. I don't know. It's going to be interesting. Here's my interesting. Here's the
How do we make sure we're going to get 220,000 cures? That's very interesting.
the green pile. So sorry. It would be such a shame. It's hard to believe. So what you're going to have, are you on vacation? And you're going for 2 weeks. So we're renting a car.
We have
You know, I thought about Verbo things.
Well, we don't really.
It wasn't Verbo, but it was something that conversation. We walked out on the, oh yeah, we had a little balcony. The other one is that is go up into that area. It's not a unique area necessarily. So you have to talk to that part of the band, and I'm the one that is making sure that side is staying. This is the Portugal. The other side.
So Peter, are you ready for us to come back? Yes. This is for the chairman. Put it right. Let's put it right in the middle, where he can't miss it.
She cannot miss that.
Can't miss it. Thank you, ma'am. It's here. People just all find it embarrassing when you gave me the turn. Oh, embarrassing. I really did. You got bad. I mean, look what I've been doing.
It's a really good.
Well, I've found ways to improve it, but
You always do.
you're
You're never through with something.
And we don't have, we haven't really established a common vocabulary yet, like, fiscal year, operating year, we all need to kind of like get on the same page on things. And then contingent approval, and I can't remember what these things are called, but they're agreements, so it's whatever.
No, that's a good job. That's the right. That's the right way.
When you think about this, is the easiest way to do it. It's really, so hopefully we'll get, a response back. My greatest fear right now is we're not going to have enough carries in. I'm afraid that. That's why I could get some of the 2014 year 2 allocations stored or waiting there, and I could slip it in if we needed to. I'm really concerned.
That's really not a bad idea. You're going to have some left because of the small.
Statistical variation of the data, you don't want to be over. Statistically, someone can make the argument in large, because you're minus 1 sigma, 1 standard deviation, which for 220,000 carries is quite a few. Square root of 220,000.
No standard deviation.
Well, just take a basic. Where is 69 carries? So that's one standard deviation. Otherwise, it's like, statistically speaking, you could be.
And you know, you could grant as many as you want. That's
But then when they get, the last vendors generally start shipping, there's just going to say, wait, you can't ship.
Yeah.
Then they're going to try and send in a request just to year two. And we only have 120,000 carries for year two. So like he said, we've got a radiated hardware that can be 15,000 carries per item. And all of a sudden, you don't have to put your radiated hardware.
Sounds like they're planning to tell those people they're just.
Well, that's right. And so, unless then maybe that'll encourage them to Brian Wood, TDA, to go ahead and get his radiated hardware in here. Otherwise, but he's Brian Wood's one.
And that's
TDA
okay.
is the one that says,
Yeah.
right. Brian Wood's the one that said that he are willing to give up from a minimum of 10,000 carries, maybe even 20,000. And we don't have 20,000 carries waiting on the lanes yet.
That's why I was asking.
We have 13,000. But they can't get their entire student, they can't get their entire 2013 year in 2012. They can't physically get it there. So that's not going to happen. We have some stuff there waiting to be placed in the hole. That gets into the whole concept of management and
Which one of those legislature wrote that language? It's just words to them.
They don't really have, so they're feeling, many people in this room don't have a true understanding of what this is going to be.
But anyway, that's okay. I really, and I kind of want to apologize to you. Last night, this is the first time I really focused on what you had sent out, asking for graphic. And by the time I focused on it, it was too late to be helpful.
Rather than we can write a letter, but we need to make sure that letter gets run by you and Bob, and make sure it's all legal and stuff. And then the amendment of the agreement to reporting of the conditions and terms for reporting requirements. So this time will become a standard. So try to
Yes. Yes. Further out, yes. Council. Previous.
We could do that, like the terms over. Maybe next month.
You're going to be chairman.
Y'all have done really
If the previous commission, we had to do the bylaws and the fiscal petition. And you had to prove the petition, there's no place to put it here. So we should
learning exercise.
Bears to deal with.
I'm depending upon you wonderful contract people to do all that for us.
They're unusually loyal contractors.
All right, we're about ready to get started in the next iteration of our agenda, so can everybody if everybody can rejoin the group, we'll get started, including commissioners. The Vermont caucus is still caucusing.
Trying to have an edge here.
Well, yeah, well, I can understand.
If you looked at the logo, they're the same size.
And they were an independent republic. All right. Next on the agenda is the judge is missing, but we'll take up because he's probably on the phone. Item 10, update on issues and progress of the Exports Committee. Vice Chairman Lee.
All right, Mr. Chairman.
Is your mic on?
Yes, it is on. Can y'all hear me out there? Great, thank you. At our commission meeting on the 18th of October, the chair appointed alternate Commissioner James Saunders, Judge Richard Dolgener, and me to form a committee to work on any needed amendments to Commission Rule 675.21 entitled Exportation of Waste to a Non-Party State for Disposal for consideration by this commission at future meetings in accordance with the Texas Administrative Procedure Act. The committee has not had the opportunity to meet yet. However, as chair of the committee, I am working with our staff to develop a draft, excuse me, as a starting point for the committee's deliberations. The process for developing needed amendments to Rule 675.21 will be similar to the process that we utilize for developing the import rule. Once a preliminary draft has been developed, I anticipate the committee will circulate the draft and conduct or cause to be conducted one or more public meetings to gather public input. When the committee has agreed on a final draft version of Rule 675.21, the matter then of publication of the rule for the statutorily prescribed comment period, or even longer if we choose to do so, will be placed on the agenda of a meeting for future consideration and possible action by this commission. Depending on the circumstances at the time, the commission may or may not cause the rule that it publishes for comment to be discussed at a public meeting during the comment period itself. At a meeting to be held after the close of the rule comment period, the matter of final adoption of amendments to Rule 675.21, exportation of waste to a non-party state for approval, will be placed on a compact commission agenda of a meeting for consideration and possible action. Mr. Chairman, tentatively, I would expect that at our January meeting, assuming there's time for a crowded agenda already, that the committee will have developed a draft rule, possibly conducted or caused to be conducted one or more public meetings concerning the draft rule itself, and will be prepared to recommend to the commission that it publish a proposed rule for public comment. That should make it possible then for the commission to consider for final adoption of the rule itself at a meeting that we currently have scheduled for March the 22nd. So that's my report. I will work with you, Mr. Chairman, as we always do in scheduling this, and if it appears that that January meeting is crowded, then we will have to at least move this and then possibly move the schedule out some than what I just anticipated as part of my report.
Okay. Thank you, Mr. Lee. Any questions of Mr. Lee about his report? No? Anybody on the commission? All right.
Oh, one other thing. Peter, I would assume that if Jane's not available, she did volunteer you. So I'm probably going to send draft copies and comments and all of that to both of y'all to make sure we got it covered. So I almost forgot. She says, make sure that Peter's aware of that.
I'm sure Peter's thrilled.
Yeah, he's thrilled right now. Yeah.
Sure. I think it's a great choice.
Okay. All right.
All right. The next item on the agenda is item 11, Consideration of and possible action on each of the following applications, proposed agreements for exportation. Now we get into the export of low-level radioactive waste, and I know that we've received comments about several of these, and I'll take them up in the order that they're listed. The first one is NSSI export petition extension request. Mr. Gallagher.
Bob Gallagher.
Good afternoon.
Good afternoon. I appreciate the opportunity to visit with you. My situation is somewhat unusual with respect to exportation in that NSSI is one of the very few waste treatment facilities, and essentially the only one within the state of Texas which handles a broad range of hazardous, radioactive, and mixed radioactive hazardous materials. In the course of that treatment, there is always a question at the end of treatment as to the generator of the waste, whether it is a new waste generated by NSSI or whether it is a waste that has come in from out of compact, been treated, and needs to be shipped back out of compact. Those questions as to whose waste it is are yet to be determined. My problem is that because, I should say, up until the WCS site began operation, I had an export permit and was able to ship my waste out of the compact to other land disposal sites. As WCS began operation, the other sites in the country chose to not accept waste from Texas generators unless the Compact Commission had issued an export permit. My export permit lapsed at the time WCS went into operation. So my request for an extension of the export permit is strictly for the purpose of re-exporting out of compact waste that I have imported for treatment, because those disposal sites won't let me use their sites unless I have an export permit from the state of Texas.
Okay.
It's a most unusual situation, but I am saddled with it.
Okay, Mr. Gallagher, so is it my understanding that the only waste you are requesting an export permit for is waste that comes to you as waste from out of compact?
That is correct. That complicates your situation dramatically.
Is it a waste when it comes to you? Is it manifested when
it is a manifested waste when received at my facility. It may also potentially be a hazardous as well as a radioactive waste.
Okay. Is it all Class A?
Essentially all Class A. If I remember correctly, we may have suggested that we would also export B and C, but that's not really a matter. I really can't export it to other locations. Nobody else can take it.
Well, that was the reason I
Right.
asked the question. Do you segregate the A from the B and C?
Yeah. At the moment, we are segregating all waste being received as Texas and non-Texas and processing them as two separate waste streams.
Are you aware of the WCS comments on your request?
Yes, I am, and that appears to be because of some wording on the second page in which the word "in" was accidentally or in error put into the request. It says "in, out," and it should only have said "out."
Okay. Have you had discussions with Mr. Balcher about this?
I have, and I got the indication so long as I was re-exporting out of compact waste, that they had no objection to what I was requesting. Is that correct?
Yeah, Rod Balzer, WCS, and we were a little confused just on the face of the application due to some of this. It was both in and out of compact, but he assured us it was all just out of compact waste returning to out of compact for disposal. We have no objection to that.
All right. John?
I'm trying to find the place where the in-out occurred.
I'll show you.
We don't, I don't think we have it.
Right here on the second page, at the top of the second page.
Is that in the letter
It
itself,
says
Mr. Gallagher?
sites
Oh, I
in
see
that.
it.
Yes.
Is it in the second page of the letter?
It's in the
Second
cover
page
letter.
of the cover letter, yes.
Got it. Thank you.
So if that word is removed from the cover letter, I think there should be no question as to our intent for the request.
I just have one clarifying question. With respect to every one of these 4 or 5 items, you say they're both Class A and B. What is that all about?
No, he asked the question. We do receive A, B, and C waste, or we are, in terms of seal sources and things of that nature. They are not involved in this situation.
So the fact that you say Class A and B, it's not right. It's just Class A.
It is Class A, yes.
You only seek to export Class A, correct?
I'm sorry?
You only seek to export Class A?
That's correct.
And it's clear enough from your standpoint, is it just when that essentially everything that comes to you comes as waste. So this is not waste that you're creating on site.
Let me be clear. I am a source manufacturer. I am a broker. I am a treatment facility. I'm more or less a jack of all trades in this business. I'm a primary vendor and shipper and receiver of sources for the oil well logging companies. So we're very actively involved. So everything we receive is not waste.
And do you sometimes get an item that, as far as the shipper was concerned, is waste, but you're able to recapture something and actually...
We have a tritium recovery operation in which the material comes in. We normally do not receive those materials as waste. We will receive them on a manifest to show proper transfer, but not a waste manifest. Recovering materials from waste and making a useful purpose is not an easy thing to accomplish under the TCEQ rules.
Thank you.
And most of us know from Texas that Mr. Gallagher is in the business of instrumentation and sources, using sources, and he occasionally gets inventory and then makes a determination of whether the inventory of the sources in those instruments are useful for other purposes or not. And so some of the instrumentation that you get contains a radioactive source that you would then declare to be a waste. Is that correct?
Well, in some cases, for example, if an americium source was received, our source manufacturing operations, which function under the Gamatron name, we actually cut the source open, recover the americium material, and manufacture other americium sources out of them. In the case of some of our oil well logging sources, those may come in, no longer be usable by the logging company, but very usable for a company which is doing spinning pipe inspection. So we do make a determination as to whether there is a recycle or reuse value, and then make a determination whether it is waste or a reusable item.
Mr. Gallagher, I'm trying to be clear. You had an export.
That is correct.
From that went away when the site became operational? Is that
yes, it was a specific condition of the export permit.
It came from this commission?
It did.
Okay.
And that it lapsed the minute WCS was in a position to receive waste.
So you're asking for an extension of that? I'm trying to be clear of what you're asking for.
I will take an extension or a new export. I'm not sure whether you can offer an extension.
Yeah, Mr. Gallagher was one of those people that had one of the export agreements that expired with not with a date certain, but the date that the site opened and began operations. And there were a number of those. We had other people who expired on a date certain, and he was one of the
others.
Yes, and so he was one of the.
I did not have a fixed date.
So what he would be asking for, in my view, is a new authorization beginning with the vote to allow exports. And how long are you asking for that authorization for?
I was told that you were only allowed to issue for 1 year. I would prefer one that ran past that because this problem is not going away.
It is not going away, but on the other hand, we have other considerations.
I fully understand.
That cause us to, and we'll talk about some of those as we get through these applications, to put limits on exports. And so this way we get to revisit them from time to time, and that's the reason we typically.
We did request a year.
If there were, just throwing it out, if there were a common expiration date for yours and all others, would that be any kind of a problem for you?
If there was a what?
A common expiration date for all.
Oh, I would have no problem with, if you're trying to tie it to an annual date, I have no problem with that.
What we're considering is tying, if we state an expiration date, we would have the same expiration date for all applications. We
have no problem with that.
Meeting. Okay. All right.
I have a question that the WCS operator says that you meet compact waste facility requirements.
We are approved by Waste Control to ship waste to the site. We are also licensed with the state of Texas to transport to the site.
So
both of those are in place at this time.
So why do you want to export?
Because this is only out of compact waste, which cannot go to the Texas site.
It's only A as well, right?
And only A.
His operation.
You need to be on the mic.
Gallagher's operation NSSI.
No, they're asking you, Kathy.
We have recorded meetings in Texas.
Kathy Davis with the Southwest Compact. His operation has become very important to our generators in our compact. We have a lot of generators who do the processing and send it to this operation. And if this is not available to us and that we have to send somewhere else, the cost is like triples. And so we're very interested in having the ability to still send our materials for processing to his facility. And it is petitioned by our compact with the understanding that it goes to Clive because it is a Class A. So any residual from his processing goes to Energy Solutions. So he does go through a petition process through our compact. So from our compact's perspective, he's very important of an operation, and for cost factors to our generators, he makes it very affordable for processing to take place, which then causes the reduction of the amount of waste that's going to the facility. So that plays an important part. That's how we have excelled in reducing the amount of Class A space that we've needed, is because we've aggressively been after processing and recycling. So that was just 10 cents from our compact.
Thanks.
All right, further questions?
Any other questions from any of the commissioners?
Move that we grant the petition for a year, and I was just looking at the other petitions, and they're all over the map. So maybe we just ought to grant it for a calendar year. What do you think of that?
It's your motion.
Okay, well, I'll move that, and I'm willing to amend it, but I'll move that it be that we grant the petition for Class A waste for the calendar year 2013.
From today's date through the calendar year 2013.
Yeah, from today's date through the calendar year 2013.
Okay.
And that would be only for...
Only for non-party
Yes.
state waste.
Class A.
Class A waste.
And I think he stated the non-party part of it.
Yeah.
Right? You know.
So the motion is, if I could restate it, to grant the petition for an export agreement to NSSI for non-party state Class A waste imported by NSSI for processing and ultimate disposal. You didn't put this in your motion, but the intent to ultimately dispose of it at the Clive facility for...
Not just at Clive, I've asked for several other locations to be usable for that waste.
Seems to me that's not germane.
Okay, it's not germane. Okay. For export for disposal out of the compact for beginning with the date of approval through calendar year 2013.
Yes.
All right.
I second that motion.
The motion has been made and seconded. Is there any discussion about Mr. Gallagher or NSSI's request? No further discussion. All in favor of the motion say aye.
Aye.
Any opposed? All right. We'll write this up. We have some forms somewhere that we still have, I think, available for export.
I have no doubt that Mr. Krausen can find this and give it to me.
I certainly have no doubt that Ms. Ing
I appreciate your...
Yeah, it'll take us a while to find the form.
Not a problem.
All right. All right. All right. Next we have a series of Texas A&M University applications, and from previous conversations with John Salzman, I know that other people from A&M are here, but Mr. Salzman will not be participating in the discussion on this one, and so it's up to the rest of us to straighten it out and ask our questions. So I'll call up the first one, which is Texas A&M University Energy Solutions, and who do we have?
Laita Vasudevan, I'm the Radiation Safety Officer for Texas A&M University.
All right.
And John McCormick from Bionomics.
All right. Explain this one to us.
Go ahead, Laita.
I'll help you.
Okay. Everybody lets me go ahead. All right. We do have a series of three. The first one is animal carcasses. It's not dry waste. It's animal carcasses and tissues that we would like to send to Energy Solutions Incinerator in Oak Ridge, Tennessee, and have those incinerated. And as you know, in the waste acceptance criteria for the burial site, the recommended disposal method or treatment method is incineration, and that's encouraged by TCEQ. We want to continue to take advantage of this technology, from a number of reasons, including health and safety. The problem is once it is incinerated, it is commingled with other waste. There's no way to separate out that little bit of material from non-compact waste. So it would be economically unviable to resend it into care. So we would need an export permit in order to let this go to Utah for final disposal. In the past and for a while, Energy Solutions could send this as their material, but Utah now wants tracking from the individual generators. So it will be identified as Texas A&M waste. If we need to, we can get into the real finite reasons of why we want this out of here, but that's the crux of the matter.
Okay, let me ask the same question. We're talking about all Class A material?
All Class A waste.
All right. And we're talking about the residue from the incineration process is then goes through the incinerator at Energy Solutions and is cleaned out and taken up to Clive for ultimate disposal.
Correct.
And these are animal carcasses.
And tissues, yes.
And tissues. And I know Mr. Balzer wrote a letter in and recognized that this is the preferred method of disposal, and he had no objection to this particular. Am I stating that right? Correctly? Okay. Are there other questions?
You've asked for indefinite. Do you have a problem with limiting it to next year?
No, a yearly thing is fine, just so we can plan in advance what we're going to do with the material.
As a member of the Technical Review Committee, I have no objections to this petition, export petition.
So moved.
Is there a second?
Second.
Okay, it's been moved and seconded that we approve the export petition dealing with the animal carcasses, which is the Energy Solutions, Texas A&M, item 11B.
Thank you so much.
All those in favor of the motion, please say aye. Aye. And Mr. Salzman abstaining on the motion, and Mr. Salzman, coming from Texas A&M, it's better that he abstain. All right. So the motion passes, and so that one will be another one. Next is Texas A&M Permafix DSSI waste. Who wants to talk to us about this one?
Okay. This may or may not need to be moved to the next agenda item, okay, because I know the UT system, the question about mixed waste is coming up. So if you want to move it to the next agenda item. In the future, I think we would want to, with Texas A&M anyway, is do like we do with the University of Texas system. Notify you when we send out mixed waste scintillation to Permafix or DSSI, and do it in the same manner. So whatever we would consistently do with one, we want to do with the other.
But you're not hurt if we grant your export petition?
I'm not hurt at all. No, I'm not.
You wouldn't rather A&M, UT follow your lead rather than vice versa?
The schools have different views on how to handle this.
Okay. So the only question that we have is an inconsistent result.
Yeah. You ought to treat them both the same way.
Yeah, I think we should treat them. Okay, why don't we defer on that one then, and we'll go to we've done Energy Solutions. We'll defer temporarily the item C, 11C for Texas A&M, the Permafix DSSI. Next we have Texas A&M Permafix Florida.
Right, and it would be the same thing if we could defer that.
Okay, we'll defer these two until our discussion later. Thank you very much.
Okay.
John, what's the difference between Permafix DSSI and Permafix Florida?
The Permafix Florida facility is a vial crushing, bulking operation, and those liquids in turn will go up to DSSI and Permafix. Okay, but when you do have a hazardous waste facility, you bring in a material and you bulk it, you therein become the generator. So we're going to Permafix at Florida, they're then the generator to DSSI.
Thank you.
Mm-hmm.
All right, the next one we have is University of Texas Medical Branch. Are we deferring that one too, or are we going to go ahead and consider that?
Yeah, next year we'll apply.
The medical branch is in a different category, right?
Right, it's a different thing.
All right.
Some people don't want to come up and face you guys.
She brings us chocolate.
That's right. Yes, I am representing UTMB as well, Tom McCormick.
Tell us about this particular item.
Okay, this is a bunch of vials and oddball stuff that it's freestanding liquid inside the vials, okay? And of course, you hear all this about the liquid. They don't want to look at it at the site. I would have to open up each individual vial and dump it out in order to make it compatible with the site criteria. And we're talking thousands. Now, we are paying we would pay a premium price to have this processed by incineration, but it's worth to pay this premium price to incinerate it because of that health and safety. I mean, there's a lot of considerations here with this material. Again, the problem is once it's incinerated, the ash is unrecognizable from anybody else's. I've picked my brain over this one. This is about the only way I could really economically and feasibly do this without potentially harming somebody. So this is really what I want to do. The whole container would be taken, incinerated. Nobody would be touching the material.
All right. And this is not the mixed waste kind?
This is not hazardous waste. No, no. But it is.
So it needs to be done by permit rather than?
No.
Give us some idea about the size of the container and the composition of the container.
30-gallon plastic drums. Okay.
Regular old plastic.
Regular old plastic. And the vials inside, they're all in bags. There is some other, syringes and things like that in there, and maybe now you can understand why. Okay. So the whole thing then gets put in the incinerator and burnt.
In total?
In total.
John, approximately how many 30-gallon drums is it?
I believe we're going to have 8 or 9 by the time we're done here.
Right. So fortunately, with the process they have, they'll be able to incinerate the entire container. So from a health and safety perspective, that means nobody has to go in and try to dig through that material.
Yeah. That's what I'm trying to avoid.
Okay. Any other questions from any of the commissioners? Mr. Balser?
Not opposed.
Okay. All right. Application by University of Texas Medical Branch. Do I hear a motion?
I make a motion that we approve it.
Second.
Motion's been made and seconded for approval of the export application. I assume this one will also be through the date that it's signed through the end of the calendar year.
Yes.
2013. All those in favor of the motion say aye.
Aye.
Anybody opposed? No one's opposed. Very good.
Thank you so much.
All right. Next, Vermont Yankee.
Mr. Chairman, Commissioners, for the record, my name is Derek Seal. I'm outside counsel for Vermont Yankee, and with me is David Teketch, who is a high-ranking official with Vermont Yankee, and he can answer any technical questions you may have. I think the petition we have in front of you, I think is self-explanatory. Very generally, it's for a little over 18,000 cubic feet of Class A DAW waste. It's basically all of the Class A DAW that Vermont Yankee generates, except for the resins, which Vermont Yankee's already shipping and has shipped to WCS. We are asking for a term for the calendar year 2013. And Mr. Chairman or Commissioners, I'd be happy to answer any questions or go into any further explanation as much as you'd like us to.
Just to make sure I understand, one of the provisions is there that you will provide information back to the Commission about the waste volumes that were shipped. Will you also be able to provide information about the waste volumes that were actually buried at wherever they're ultimately disposed?
Yes, we can provide both to the Commission.
Great. I think that would be very helpful.
Other questions? Judge?
So moved.
Judge move the approval of the Vermont Yankee export petition. It certainly helps with it. Is there a second?
Second.
All right. It's been moved and seconded for the Vermont Yankee export petition for Class A through the end of calendar year 2013 be approved. Is there any discussion among the Commission members? Hearing no discussion, all those in favor say aye.
Aye.
Any opposed? Granted.
Thank you, Mr. Chairman.
Thank you.
Commissioners.
Next is the South Texas Nuclear Project.
Good afternoon, Renee Reese, outside counsel for the South Texas Project. With me is Tom Sullivan. Our export petition is basically identical to Vermont Yankees except for the volume of waste. This is Class A, low dose Class A waste. It's not our high dose Class A waste. We're seeking essentially a one-year permit through calendar year 2013. There is a WCS support, I believe, for this. It's been submitted to the the commission, and be happy to answer any questions we have. I would ask the same question that I just asked, which is, will South Texas be able to provide us information with regard to the volumes they ship, and then also the volumes that are actually disposed?
Yes, we get reports from, it's Tom Sullivan from South Texas Project. We get reports, monthly reports from Energy Solutions. Sometimes there is a lag, but we report those different volumes on our RECOT 121 report.
And we can provide that to the commission. Yes. Thanks, Tom.
You're welcome.
So moved.
Second. It's been moved and seconded that the South Texas Nuclear Plant project application for export Class A material be approved through the end of calendar year 2013. Is there any further discussion of the Compact Commission? Hearing none, I'll call for a vote. All those in favor say aye.
Aye.
Any opposed? Motion passes. The final one we have is Lumina.
Mr. Chairman, Commissioners, Richard Adams, outside counsel for Lumina Generation. With me is Robert Knapp from Comanche Peak. Our export petition application is essentially identical to the two that you've previously heard from South Texas Project or Vermont Yankee. So with that, we would simply be...
I take it, Mr. Adams, you'd also be happy, before John asks his questions, with a expiration of calendar year end of 2013?
Yes.
All right. John?
I'm assuming that you all can, as the other two utilities have indicated, you can provide us volumes that you've shipped and then also volumes that are disposed at the site.
Yes.
Thank you.
With that being said, I'm assuming that none of you object to the order authorizing the export reflecting that agreement. Is that right?
That's correct.
I have one question. I just called, actually.
Yes.
WCS's letter says, maybe a typo, it's not on the first one, but it's on the luminance, and it says, RE petition Luminant Generation Company, LLC, to export Class A waste for, there you go. Anyway, well, the letter dated November the 9th, 2012 has got the through October the 21st, 2018. Y'all see that? Does that mean anything, or is that just a...
You can ask Mr. Adams if you...
I'll just...
Judge, we have only asked for calendar year 2013 for export authority.
I think WCS is going to give you approval for the next 6 or 7 years.
Well, we would appreciate that, but we'll take 1 year at a time.
So moved.
All right. For the motion, is there a second?
Second.
It's been moved and seconded that the application of Lumina for export through calendar year 2013 with the terms and conditions that Mr. Krausen and Mr. Salzman have discussed be approved. All those in favor say aye.
Aye.
Any opposed? Motion passes. Now we'll go to item 12 and then circle back to the two Texas A&M items. The 12 is discussion and possible action with respect to the applicability of low-level waste compact to certain types of mixed waste. And as everybody,
Mr. Chairman, for the record, since we are going to continue to discuss Texas A&M University, I'm going to recuse myself from this discussion.
Very good. We have a, how do I want to characterize this? A determination, I guess is the right way.
Conundrum to
solve. Because at a previous Compact Commission meeting, we had a discussion, and this was over a year ago, had a discussion about the fact that it's mixed waste. And as I recall, Rod, and you'll have to correct me, I don't think radioactive mixed waste can go to your facility. So it can't go there. So the question then became, do we need an export permit for it or handling it? And at the time, the commission chairman made an announcement that as long as there was information sent to us by the University of Texas, and this is specifically with regard to the University of Texas, that they were just an announcement that they were shipping it, we would not further require any information from them with an export agreement in spite of the radioactive constituent of this radioactive mixed waste, because it could not be accepted at the Andrews County facility, which wasn't even in existence at the time this wasn't operating at the time this came into effect. So the question is, before the commission, do we want to, I guess the question properly stated is, do we want to continue to ratify and adopt this practice of requiring people who ship radioactive mixed waste, it's hazardous and radioactive, to not necessarily request an export permit from us because it couldn't go to the Andrews County facility, the compact facility, in any event. But we want to know that it's properly being disposed of, and that's the reason that we requested that we be notified of shipments. And those shipments have come in regularly to our office. And I know they have because they show up on my email. So that's the question of, does the commission wish to now choose to require export agreements associated with the radioactive mixed waste that is shipped out of Texas for, I believe it is for incineration or other handling, or do we want to just allow it to continue to be done by the universities on a notification basis, and that will be good enough? And the truth of the matter is that I think the statute says, and it's been a while since I've looked at it, but the statute allows us to grant authority to export. And basically what we'd be doing is just saying, as long as it's this kind of waste from originating here being exported as radioactive mixed waste, we would just have a motion declaring, I think, that is that can be done, and that would suffice to be the authority.
The notice of intent.
The notice of intent. That would suffice to be the authority that they would need to ship, and we would not require other shipment. And if they needed verification from us that we had approved it, we would issue a letter saying that we had approved it through a motion done at a regular commission meeting.
So moved, Mr. Chairman.
You might consider, just an idea, consider perhaps limiting that to universities. I mean, I don't know where else this might apply or what kind of situation might apply somewhere else, but I do know the practices of universities.
I'm comfortable with limiting it to universities if you are.
I am. So moved.
Is there a second? It's been moved and seconded that we authorize, is the right word, I think, the exportation of radioactive mixed waste by universities on an indefinite basis when it can be sent out for processing and disposal, including destruction, without further requirement of an export agreement from the Compact Commission. That's
but requiring a notice of intent.
But requiring a notice of intent. And that's the motion, and it's been made and seconded. Is there any discussion about the motion? Hearing no discussion, all those in favor of the motion say aye.
Aye.
All those opposed? Nobody's opposed, so we took care of...
Mr. Chairman, I'm abstaining from that vote.
I'm sorry. I should let the record reflect that Mr. Salzman is abstaining. It would apply to Texas A&M University for the Permafix DSSI and the Permafix Florida applications that are pending on our agenda, as well as for future continued shipments for the University of Texas system. And if anybody else comes within that, they can call us, or they can come in and let us know that they want to take advantage of it. But right now, it's limited to those institutions, my understanding is. Okay?
Okay.
All right. That takes us through item 11. Next is 12. Now we are finally to the TCEQ reports, and we have certain bullet points from Mr. McGuire. Welcome, Mr. McGuire, and thank you for your patience for dealing with us today.
It's always a good day to get out of the office for a little while. Thank goodness for iPhones, though. Thank you for allowing me to come and talk to you. I did pick up on the agenda items. Lee and I visited with them earlier, and so by way of reporting to you, to bring you up to date on the status of the rate case, all of the parties withdrew. The State Office of Administrative Hearings has remanded the case back to TCEQ. Early in 2013, it is our plan to go forward with a rulemaking based on our proposed rule that we went into the contested case hearing with. That rulemaking process, if we start on that early in 2013, might not go just really, really fast because there'll be other things going on that we will be involved with. But we do plan to get a rule proposed in early 2013, and we're in the process at the agency of briefing our management and looking to when we could start to put things on the calendar to do that. Do you want to do questions as we go, Chairman?
You can give us everything you want to say, then if somebody has a question, we'll ask you, Mr.
Okay,
Clark.
that's great. Also, you asked me to speak to the status of any WCS license amendment applications. We don't have anything presently in notice. WCS does have some amendment applications that they've placed with us. We're considering those and looking to see what we might go forward with in terms of Amendment 19. We think there may also be an Amendment 20 once Amendment 19 is finished, but we're looking at some of the things that WCS has requested and have not yet gone forward with anything additional to notice. You also asked me to speak to the method of tracking out the compact disposal quantities in connection with current WCS license and Texas law. And what we do is when WCS is supplying to Lee for the Compact Commission their disposal amounts, they send it to us at the same time. We review those amounts to make sure that everything being reported to the Commission is consistent with what our records indicate. And before waste is approved for disposal at the compact facilities, and our two on-site inspectors sign off on it, we've made sure that it's consistent with the license and all the elements of the checklist that we have for the operation of that facility. The last thing you mentioned, maybe most important or most of interest right now, is an update on the capacity study. We were able to release the study on November 20th. The study is available on our web portal, and we did provide copies for the Commission, and we're looking forward to the discussions. We feel sure that that study would render. I probably also should tell you that the financial assurance report is also due in early December, was released yesterday, and we've provided Lee with copies of that for y'all, and it will be available on our web portal next week.
Thank you. And then the last thing, of course, is anything else you care to talk to us about?
Y'all talked about so much already. I think that covers it for us.
All right. Let me ask the commissioners if do they have any questions questions of Mr. McGuire, Dick?
I do. I confess that I don't understand the capacity study. I have tried to understand it, and the math I don't understand. I think what you're saying in it, as far as volume is, as far as curies are concerned, I think you're saying there's plenty of room. I think on volume, you're not exactly saying that, but that one has to do another calculation which basically says that the volume's going to be so reduced in processing, or all the Class A is going to be shipped somewhere else, or both, that you will have enough space. Is there somebody in your in your commission who the hour's late, and I don't want to get into this right now in detail, but is there somebody there whom we can call if we have questions about it?
Sure. And what, really to develop the report, we had to reach out to get information from the folks in the compact that generate the waste. And we felt like to get reliable information to then make some projections on, again, at the end of the day, they're all estimates, that we would have to ask them about an as-generated number. And so we produced the report based on survey results on an as-generated basis. But, we felt an obligation in terms of reporting those as-generated numbers is make sure that the folks that would look at the report would realize that we're in looking at those numbers, that there is the possibility of compaction, there's the possibility of export of the A waste. The A waste represents a significant part of the total
to this
volume.
layperson, it didn't jump off the page. I mean, I looked at it, I tried to massage the numbers and figure them out and stuff, and as I told you what I came up with.
Sure.
And so, is there somebody or some department that we can consult on this?
Sure. I mean, we would be happy to brief you, to walk you through that, to leave our technical folks at your disposal, if you will, to ask us questions as they come to your mind about that. We have felt sure, sort of even before we released the report, that we would probably be busy and would be called upon to sort of explain what the as disposed numbers might look like. You have to make quite a few assumptions to get there, and so it would be very, very important for somebody to understand our assumptions as we were developing those calculations. But we'd be happy to do that with you.
Thank you.
And we do understand that is the question that most everybody is going to want to know. I would say, as far as the conclusions you drew from the report, I feel like I did a pretty good job of conveying that to you. You got exactly what I would hope you would get out of that. So,
whom should we call?
Well, we're used to working with Lee to establish connections, so that y'all don't have to have a quorum or whatever. But you're welcome to call me. You're welcome to have Lee contact us. We'll come visit with you. We can set up conference calls with my people. Well, in your hotel room, maybe. But
nice in the fall.
But we're used to dealing with conference calls and things like that. I'm sure we can do that. Really, probably better for us to know more about your questions, and then let us try and address them as specifically as we can.
Okay, well, in general, I don't want to prolong this, but in general, I read it hoping to figure out whether there was enough room for what was going to come in, and And in general, as I say, what it looked like to me was you probably had room for curies, but you didn't, but it looked to me as if you had to assume a great deal of compaction or shipping out of Class A in order to have enough room for volume with imports. Is what, so
Sure.
Just a kind of a gross feeling of what's going on.
Well, and, you know, we believe that with the Class A waste, and again, that's probably close to 99% of that cubic foot volume that we've said estimated to be generated. You know, we think a 3-to-1 compaction on most of that is a possibility. So, that I think meets your notion of significant compaction. We are also trying to make the disposal of that kind of waste, the bulkier stuff, more efficient. We're looking at amendments that WCS has proposed in that regard.
Okay. Is that something that we can inquire about?
Sure.
You see,
Sure. Absolutely, and any time.
Okay. All right. Thank you.
Mr. Bradford.
So, on this issue of water in the monitoring wells that Ms. Haddon raised earlier, I think my colleagues made clear that we don't have any intention of trespassing into your jurisdiction. I just want to ask you, though, the fact that you didn't have that on your agenda, I take it means that you are not seeing anything in that question that affects the work of this commission.
I think if we thought there was something actionable there that would affect the environment, the health and safety charge that we have, we would have already done that. We do monitor. We require a significant amount of reporting associated with this site, more than anything else I'm aware of that the agency does. And certainly, as Ms. Hayden does say, I always say we are monitoring that. We're diligent in that effort. We require the information. We evaluate the information. I'm briefed on that information frequently. If we saw something there that did look like intrusion that could be long-term harmful to that site, we would already be moving on it. We wouldn't have to wait for somebody to tell us to do that. We don't. But what we do see there is a need to have the monitoring because water always has the potential with any sort of waste disposal that's in the ground to be a problem. And so we just want to make sure that it's not. And we use those monitoring wells and the data we gather there to reach a level of comfort that we're okay at the site.
If I might, just one other thing. I think there's going to come a time when we're going to want to have a sense of what is going on inside the fence at WCS other than what's going into the compact facility. In other words, over time, I assume a fair amount of waste is going to come in there, but is not going to go into the facility because it's being held or processed or something like that. You must monitor that too, don't you?
Yes, that's reported to us.
Okay.
Anything that goes into storage is reported to us under the licenses for those parts of the operation.
Any other questions of other commissioners before I start? I have a couple of questions, Mr. McGuire. First off, I did read the capacity study, and I appreciate very much your saying that it is an estimate, because that's all it is. It's an estimate based upon the responses that you have and some assumptions that you built into all sorts of calculations.
Sure.
And are there any plans by TCEQ to perhaps update that once we get more experience with knowing what the flow of waste disposal looks like to the compact facility?
There are not presently any plans to do that. Again, this was instructions that we received from the legislature. I don't know if they intend to give us further instructions. We're on the brink of a legislative session. Before we started to think about that, I think we would want lots of feedback on the study we've just completed.
Well, clearly, it's our job to keep up with capacity at the site and
Sure.
make sure that that we can make sure that the host state is entitled to unlimited use of the facility over its operating life.
Right.
And so at some point, I don't think anybody thought that we'd have a problem early on, but from what I can tell of the capacity study, everybody anticipates that down the road we might have a problem under the current license.
Well, for me to say we would have a problem, I guess I would have to assume that we weren't going to do anything to address some of the things the capacity study indicates. I would just say, well, to us, if we don't do things to address things that the capacity study indicates. So,
but clearly, we need to keep up with what those things are to make sure that there is truth in the capacity study that's been prepared and submitted to the legislature.
Well, and I think while we have estimates from generators, as we start to see even 12 months of disposal, we would have some better idea of what really the operating numbers going to disposal are.
And we all know about regulatory impacts that could impact the situation of capacity at the site, and we also know about monetary impacts that could impact the situation with the capacity of the site, and there are all sorts of factors that nobody can anticipate 40 years out into the future.
That's true.
All right. What progress has been made, if any, on an update of the performance assessment associated with the site?
We have had some meetings with WCS. We have encouraged them to develop a probabilistic model. They have presented sort of a draft version of that to us for my staff to look at. We're anticipating we sort of have a March time frame in terms of what I would call the new one, but we're because that's such an important aspect of some of the decisions we know we're going to be asked to make. We're working closely with them to push ahead with a new performance assessment.
Do any of the amendments that are contemplated, or you've told us in the past that there's some in-house, do they require a new performance assessment?
None that are close to us right now. Things that we've talked about certainly with WCS would, but things that we have specific amendment applications in front of us looking to put to see if we would want to put something in notice. None of those do. Tanya thinks I need to be sure and mention to you that the updated PA is a license requirement that's due in March, and so that March date's very real.
Okay. With respect to the rate case, I know that everybody's agreed in the contested case hearings have been removed and withdrawn, and it's now back into the rulemaking process, and so. Of course, we have an interest in the rate case because part of the rate case is generating funds for our operations, and we need to make sure that we understand how that all works and what the anticipations and actual collections are and how it works under the expenses and the rate setting. And I'm not clear on that as I sit here, but I've not been involved in the rate case. So as you propose the rule, I assume all that will come out in the rule proposal, the analysis, particularly as it affects money available to support our operations.
I think that is part of the basis of the rate, and so I think you will see in that what comes to the Compact Commission from the gross receipts.
I understand that, and I'm interested in the forecasts also of volume and money that you forecast, because our rate is going to be dependent upon the actual use of the site rather than the theoretical use of the site.
And I have to hope that you're visiting with WCS about the forecast. We're not close enough to the actual deliveries that would trigger the invoices that would result in gross receipts to be able to forecast what those gross receipts might be. So we think it's important to look to WCS to supply information that might help us all understand what money we might be looking at. So.
That's a really interesting statement that you just made in light of our inability to get good fiscal information about site operations in the past. And but so you're encouraging us to take that matter up with WCS?
I think they have the best information available to make estimates about future revenues.
All right. One of the things that has been on my mind recently is a situation that occurred with storage that then got transferred, and I had this discussion with Mr. Balzer years ago, and when he said, they're accepting stuff at storage, and I said, WCS, you've got to have an agreement with us if it comes in from out of compact to move it across the fence. And he said, yes, he absolutely understood that, and then stuff shows up. How do we know what is there to take it into account when we have to look at, if we need to look at what the estimates or forecasts are for the next fiscal year, operational year? What do we do about inventory if we don't know what it is?
So you're talking about inventory that would be in storage?
In storage there, or at NSSI, or any other place that might be shipping to the site for disposal. Because, obviously it's best to get it in the ground rather than leave it in storage.
Sure. Well, we have an inventory that's provided to us by WCS. Our resident inspectors look at that inventory, and we feel like there's verification from them of what that inventory is. And so, we know what's on the site with that information, and I think if that's that's something you feel like you need, we should probably visit with Lee about.
Yeah. Well, one of my questions is, of the inventory on site, do you know of that inventory what might be destined for disposal in the compact site?
Only to the extent that we know what's going on with import petitions. We know a lot about that. We also know when contracts have been approved between WCS and certain shippers. But other than that, there might be radioactive materials in storage that don't have a pathway for disposal yet, and so we know what's there, but we might not know what its plan for disposal would be.
All right. Thank you. You've been very patient answering my questions. I appreciate that.
Sure.
Any other questions from Mr. McGuire?
Mr. Chairman?
Yeah.
Could you cite for me the discussion that you and I had relative for this commission to, I think the word is shall use the capacity study for any determinations that we have, and I cannot remember that. I don't know whether you had it with you or not, but I think it'd be good for Charles to know that this is not going to collect dust. Just sit somewhere where we don't use it, and so it's something that I think, I don't know whether my fellow commissioners know about it or not, but it's in somewhere, and hopefully he'll find it and cite it. And so you probably know it already, but I wanted to make sure that this is a document, Dick, to your point, that that we are.
It essentially says that we're to use, y'all are to use this to guide your estimates.
I can read you the language. It's in 401-208 of the Health and Safety Code. What it says is the Texas Low-Level Radioactive Waste Disposal Compact Commission shall use the study to anticipate the future capacity needs of the compact waste disposal facility. That's all it says.
Okay. But to me, it's a powerful sentence. Because it said shall, it doesn't say may, and then nothing else. Say you shall use
to anticipate the future capacity needs.
Shall anticipate.
But
strange articulation.
I know, but
and the other thing about that is that we had a rule that said, we adopted a rule that says what we anticipate the future needs are for the year 2045.
Right.
And that rule has not changed.
Yeah.
It still exists.
Yeah.
So.
Well, and just rest assured, since May 1st, when I came to the Radioactive Materials Division, there hasn't been a moment that I wasn't acutely aware of the importance of the capacity study. So, and I continue with that acute awareness.
All right.
Very good. Thank you.
All right. Any other questions, comments? Thank you, Mr. Breyer. Appreciate that. And next, not last, not least, WCS. Welcome, Rod.
I thought maybe we'd run out of time. Still want me to talk? Okay. Rod Balzer, WCS. You did have a couple items on your agenda, so we'll run through those on operations of the site. To date, or through October 31st, we've disposed of approximately 7,800 cubic feet, about 42,400 curies. The in-compact waste of that portion was about 2,300 feet and 590 curies of waste. So the vast majority of that is out-compact waste. Pending the license amendments, we have some for non-containerized disposal for decommissioning debris, things like that. You asked about expectations for utilizing the full allocations. I think we've already discussed that in a variety of detail. And other matters, I thought I would go ahead and weigh in on the capacity report. We did do an analysis based on the TCEQ capacity report, comparing that to our capacity study we had done internally previously, and utilizing some of the factors such as, compaction on Class A DAW and better efficiencies and things like that we expect in the future. Based on that, we think we have more than twice the volume and 3 times the curies already licensed that are needed for in-compact disposal. So we think we have plenty of volume and curies for importation of waste, and particularly if we continue at the levels we did in year 1. The TCQ report was as received. It was not as disposed, and obviously that is an important distinction. And likewise, I'm happy to talk about that offline if any of the commissioners have additional questions or want to talk in detail about any of that. The other item I didn't have on my list before today, but I thought felt compelled to talk about, was water in the wells. Since this topic has come up, we do have groundwater monitoring wells that have saturation in them. These are all within the first 30 to 40 feet of the surface. They're old playas and depressions. They've been collecting rainwater for years and years. They are not contiguous. They are not connected across the site. They're not connected to an Ogallala aquifer or any other aquifer. We are in full compliance with our license. All of these are above where the waste would be disposed of. The waste is below 40 feet from surface, and these are all above 40 feet from surface. And so we are very cognizant of what this means and what it is. We're very proactive about the management of that. We have had potable water leaks, and we have so many wells that one leak from a pipe that was underground impacted 3 nearby water wells. So we have enough monitoring wells that we can locate irrigation leaks, basically. So I think we are sufficiently covered on that. But I just wanted to state that, and I'm available for any questions.
Hey, Mr. Sutton.
Ron, I think it's been reported to us previously that at least for some of those monitoring wells where you are, where the water's present, that you are able to pump them for some period of time, and then because of the cone of depression around the well itself,
there comes a time when you have to shut the pump off because there's nothing left to pump, and then you have to let the water, in essence, permeate back into the void space. Is that still true?
That is correct. It is a very tight formation, so if you do have saturation, it will take a while for it to move through that formation into the well where it can collect it enough of a volume that you would be able to pump it out. And so it does take a long period of time.
Thank you.
Other questions? Dick?
Yeah, could you give us could you like send to Lee or something a summary of why you reach the conclusions you do about having so much more capacity, more than 2 times the volume, more than 3 times the...
I'd be happy to.
Yeah, I've been, as I say, I've been trying to tease it out of this report, and I can't. So I'd appreciate that.
No problem.
Peter?
Let me also talk about the capacity study for a little bit. From my perspective, we have the capacity study, and it is an estimate, and it's got all sorts of assumptions built in it, of course. And I understand all that. And as I've said in the past, I don't think anybody thinks we're going to have a problem the first few years. But down the road, as we learn more, we'll get closer to knowing whether we have a problem or not. And what I'm going to say, and this is just for me, is that we need everybody's help. We need your help. We need the generator's help. We need everybody's help because we're granting these import permits particularly for the B and C stuff, the high curie content stuff. And if any of the generators or you see that we're running into a problem, we need for you to alert us so we can all work together to figure out what to do about it. Otherwise, we're in the blind.
No, absolutely. We understand that, and we are managing this. It is a limited resource. We have both, physical design limits at this point as well as license limits. And so we are managing all of that. And as I've told the Commission before, we do not expect to turn away any in-compact generator, Texas or Vermont, at any period of time. We expect to be there to fulfill your needs. Understand the future, nobody's got the crystal ball, but our expectation is if there needs to be disposal, we will be there to meet that need.
Well, and we want input from everybody, not just you. We understand that you're the manager and you know what you're doing. We don't know what you're doing day to day. So we have to get reports a little bit after the fact of what's actually been there. But the generators know what they're proposing to ship, and if they know their schedule better than you do, probably, and if they see something that begins to bother them, and I'm saying this for their benefit, even though they're not here anymore, but 2 of them are. But we need somebody to call that to our attention, or else we're not going to react to it because we won't know about it. It's just that simple. Federal facility. I know it's open in September. What activity is taking place at the federal facility?
They are still waiting to have their first disposal, so they are still lagging behind the compact facility significantly.
Okay. That was my only other question to Mr. Walter. Anybody else?
I'm sorry, but I have one more. And this is probably more for the TCEQ. We have here a financial assurance report. Will that answer the questions about what happened with the stock that was put up for security and the company was sold, and what the ramifications of that are?
The study, the time period for the study ended November 1st, and so it will not reflect the stock currently.
Can you tell me in a nutshell what has that security been replaced?
Yes.
With what?
Stock and Kronos. And
Is this another company that's
yes.
controlled by the same guy who controls
the
WCS?
I'm not sure about all the pedigree with the company, but it was what was proposed by WCS, reviewed by the trustee, reviewed by our financial assurance people, and accepted.
Okay, so there's some place we can get that.
Yes.
It also comes under the designation of other security, the way the previous one did?
Same mechanism, yes.
Okay. Thank you. I'll be interested to hear about it.
All right. Any other questions for Mr. McGuire or Mr. Balter? Hearing none, thank you for both being here. And the next is my report. It'll be real short. I've been doing some things, and one of the things Mr. Milton and I did yesterday was we can, there are two things in particular that I wanted to report to you. One has to do with the auditor. I sent out a letter to some of the people that I know who are auditors. We're probably going to work through the process of contacting them and making a selection for our auditors so we can have an audit done as is required pretty quickly, and they'll have to work with Lee and Audrey, who I hope now understand our various financials, but I doubt seriously that they do because they're 4 years behind in the learning curve. But we should be getting that under place, and then we have had some conversation about a more permanent executive director. When we hired Ms. Ng, she's been very generous to us in giving us her much more time than we're paying her for, basically. And so we had some conversations early on about perhaps finding a contract executive director who, and we do have to do it by contract because we still have we can't employ anybody. So what we're beginning to do is we've developed a new list with Lee's help of qualifications of person, and there are all sorts of things on there that I didn't know about, like maintaining a website at midnight, but that are in the job description. But we hope to be able to perhaps at some point, we're not in a big hurry because things, from my perspective, are working so well, because I'm doing a lot less now than I used to do because of Lee and Audrey's help. So we're just starting that process, and we're about to start the process of drafting a new annual report. And we haven't done the one for this year or the one for the previous year yet. So we have all sorts of things on our checklist. We're asking Lee and Audrey to come up with a comprehensive list so we can start keeping up with them and checking them off. I will notice for everybody that we now have a new physical address, a new mailing address, a new telephone number, and I hope that our mailing address works, Lee, and most of the time anyway, or some of the time, because we're trying to switch over to our space in the hobby building. And with that, I'll be quiet because that's all I wanted to talk about. Lee?
There's really not much more I have to add. I think the mailing address is finally stabilized. Unfortunately, it took two state agencies and a federal agency to come together on a mailing address, and that had some hurdles, but I think they've all been resolved. And we're working on getting a fax number without having to pay for an expensive fax line being pulled through, and I think we've got that just about solved. And and then we're also going through, as you said, and finding all of the reports that we need to do. We just finished and submitted our annual financial report with the help of the Board of Nurses, so that has been done for the year. And I'd like to thank all the commissioners for getting all of their receipts to me in time so that we could do that. That was very helpful to me. Thank you. And I really think that's all I have to update. There's just not a lot this time.
I think the other thing I want to say is all of the files that had been kept up to now have all been delivered to our office, and all the equipment is there. So we now have a consolidated office in Austin, and Audrey has the job of going through there and trying to figure out what's what, but I'm sure she's capable of doing that. So we're beginning to act like we really function. So for the first time in a while. So all right, you've heard from me and Lee. Possible changes of dates and locations of the remaining meetings, and she has this by fiscal year, and we had originally planned for a date in January. We're now looking at moving it perhaps to have comments on the import applications that might be submitted by the end of December, and looking at those, the first business day would be second, third, or fourth, so we have to allow 25 days after they hit to be commenting. So we may be actually looking at the first week of February. Is that right? I don't have my calendar out in front of me. I can pull it out. Currently, the date is scheduled for when, Lee? 25th.
January 25th. If you, under tab 21, it has all the dates. And it's currently set for January 25th. And so either the last part of the last week of January could work, or the first week of February. I will tell you, however, that the amendment that is being, that Exelon discussed earlier today, the first shipment day for that is February 2nd.
Say that one more time.
The first shipment date for the amendment of Miguel, that Miguel Azar brought up for Exelon, their first shipment date is February 2nd.
So you need to be before that.
That's on a Saturday.
Is that when it leaves the facility or when it arrives at WCS?
And when it leaves, my understanding is when it leaves their facility.
So that means we're looking at the 31st of the 1st. At the latest.
Can't do the 28th.
Okay, that's Monday.
The legislature's in session.
The legislature is in session.
One,
So we may have to
three,
relocate.
28.
Relocation is possible. We've done it before.
Mr. Chairman, so what do you think, the 31st or the 1st?
It's up to the members of the commission.
If the other members could make the 31st, I think perhaps just from a timing perspective to give Exelon
comfort,
a little comfort, the 31st might be better.
Providers?
I believe I can. If it had been the 25th, Jenny was going to have to do it. So this is a new thought to me.
Dick?
That's okay with me. Works for me.
Looks like it's the 31st.
It's on my calendar. I'll change it.
And we'll start exploring locations. Sure.
I was just saying the midpoint of winter is a good time to come to Texas.
You dig out.
Mr. Krause, is that okay with you? Yes, sir. All right. Looks like the next meeting then will be the 31st, and we'll continue to revisit the later schedule after that. I noticed we had one.
Lee, do you really think that'll work with Exelon? Is that okay?
Depends on how quick the attorney can get an agreement together.
Well, in this case, it's just going to be an amendment.
Yeah.
Right? This will just be an amendment. It's not a brand new agreement.
The time deadline, the better off you're going to be negotiating.
And it'll be a very easy amendment. It'll be pager to me.
Well, maybe we could even have it pre-done.
Presumptuous of you, Mr. Rice.
I've already done the technical review on that one.
It would be contingent, of course.
Yeah, contingent on approval, sure. All right. Anything else from any other member of the commission? Do I hear a motion to adjourn?
So moved.
Second.
All right, we're adjourned. Thanks all of you for being here through this process with us. We can't do it without help. I appreciate it.